Good morning, good morning, good morning. It's bright and early on Tuesday, January 7th, 2025. Will I probably mess that up at some point in the future? Yes, I probably will. But it is the new year, and new year, same law nerds. We are back in court for this first stream of the new year in the Karen Reed case, Massachusetts versus Karen Reed. This is the part 2 of the Daubert hearing that we attended together on December 12th. That hearing was hey, this is going to be an evidentiary hearing. And then like 6 hours later, we were like, they haven't even started cross-examination yet. So to answer all your questions, what is a Daubert hearing? It is a hearing to examine an expert witness to determine if the scientific methodology that they used can be presented in court. You know, the type of hearing that we all thought would have been more forthcoming when the scientific method in the Murdaugh case was throwing a cell phone around an office to see if the screen lit up. You know, that type of like, is this science? Is there really a repeatable process here? Or is that just some dude in his office throwing his phone around telling the jury about it? Because the jury doesn't need an expert to tell them about things from their common experience. They need an expert to explain to them things that are outside their common experience, someone with specialized knowledge and training. And the defense is trying to bring Dr. Russell in to talk about the injuries to John O'Keefe's arm and her opinion that those injuries clearly came from a dog and not from a vehicle. Not only does she have expertise as a coroner, she has also worked as an emergency physician. So she has seen dog bites and she has seen car accidents and she has done autopsies. So her expertise is not just where the injuries came from, but also where the injuries did not come from. And that is what the defense is trying to get in the new trial. Just because it came in the last trial doesn't mean it comes in the new trial. And just because something maybe didn't come in the last trial doesn't mean it necessarily comes in this one. So they can bring in new and different evidence. They can keep out evidence. We will see. So law nerds, it's so good to see all of you. Welcome back. We're going to roll the intro. Thank you for the compliments on the lighting. I am still trying to sort it out. New desk, new office, new setup, slightly new angle on the background. Moved the lights around to try to get less lighting, but now it's more above lighting. So now, we look more tired than the direct lighting, all the behind the scenes that you don't need to know. You know what? The flare in my glasses annoyed me the most. So we're solving that problem first. So we're going to roll. Also, it's just cold and snowy. So let me know where you're coming in, how your weather is. And I've got a warm cappuccino that hopefully will stay warm. So that's what we're doing today. All right, we're going to go to court. There was a super long break this morning. They did a couple questions and then a break and then a couple questions. So we've got plenty of room to zoom. We've got, like, right now I've got all the things with me. We got breakfast, we got coffee, we got everything. Let's roll the intro and let's get into court, shall we? I miss live court. You miss live court. Welcome to the new year. We will be live 3 days a week. And if you don't have the Law Nerd app, lawnerd.com. So we are live today. We're going to be live tomorrow. And then this week, instead of being live on Thursday, we'll be live on Friday because we're going to go listen to the Supreme Court ask questions about TikTok. So we'll be live on Friday instead. But if you have the Law Nerd app, you'll always be in the loop and you'll always know. All right, let us go. I just saw somebody telling me, Kate in the chat said Emily needs an Ember mug for the hot cappuccino. I just got one for Christmas, Kate. I did. I got a tech mug for Christmas. We'll see how I like it. We got a tech mug for Christmas. So yes, it should be keeping my coffee nice and hot. So Kate, same, because when I'm at home, I tend to drink hot coffee a little bit more than cold. But these are questions we can get to when we have a break from court, because that breaks will happen. So it's time for live court. We have picked a feed today that might have some distraction, but has closed captioning, which we prioritize. So let's just roll the intro and let's get rolling, shall we? Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. It's so good to see you this morning. So yes, we have grabbed the feed from our friends at Court TV. Why? Because they have closed captioning, and closed captioning is our priority here. We want good sound. We want closed caption. Law nerds, we just want it all. I feel like it's not too much to ask. All right, this is before court starts this morning. We are a little behind real time. Why? Because this court keeps just having breaking issues. So we're going to just make sure that we don't have to deal with all of the breaks, and we can zoom. So we're going to go to court. Let me know how it sounds and if it is or is not too loud, because hopefully not. I just want to hear the hear ye's. That's what I'm here for. Like, I'm ready. Like, hear ye. Ladies and gentlemen, theys, gays, girlies, girly pops of the chat, let us come to order. Hear ye.
Now open, you may be seated.
Yes, the pink pony girly pops. The Pilates princesses.
Good morning, Your Honor. Hank Brennan, along with Attorney Adam Lally and Attorney Laura McLaughlin.
Good morning, Mr. Brennan. Morning, Mr. Lally. Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor.
It is
Robert
indeed
Leslie
cold.
on behalf of Ms. Reed.
Good morning, Mr. Leslie.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning.
It is cold in Tennessee, and you know what it is? It's also a snow day. Did my kids go back to school for a day yesterday? One of them did. Snow day. Snow day.
Mr. Unetti. Good morning, Ms.
Good morning
Reed.
to me.
All right. Is Dr. Russell in the courtroom? All right. So why don't we have Dr. Russell take the stand?
Hopefully you guys can hear court well. And this is the courtroom where trial was. So if you're like, this courtroom looks familiar but different than the last courtroom, yes, this is the courtroom where trial was. So for all of you saying, what is a snow day?
Thank you.
The state of Tennessee went, ooh, those roads look like they could be icy. We're closing for the day. So we just closed for the day. For those of you that live up north, you scoff. I can still see grass and there's a snow day. I know the roads are really icy this morning, and they're like, our buses aren't doing that. It's too icy. So we have a snow day, something we never had when I was in California. The only time we missed school is if there was an earthquake. So, you know, that was about it. So it's really a nice day. But yes, snow day, ice day. We don't have actual snow, but the roads were pretty frozen. It rained, it froze, it was an ice rink. So no kids to school today.
All right. Good morning, doctor.
Which at the end of break is kind of rude. It's like, could they have a week? Could you just give them a week?
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor.
Hopefully when he gets to the mic, Brennan's pretty loud. Brennan is the prosecutor in this case, the special prosecutor that was brought in to handle this case. We haven't really heard much except good morning from Adam Lally since Brennan came into the case. These are Brennan's motions. So the prosecution brought this motion to exclude Dr. Russell. And it's not that Dr. Russell is not tremendously educated and qualified in all the things. It's whether the thing that the defense wants her to testify about is something that has a particular methodology that is outside the common knowledge of the jury that she can illuminate for them. So it is a bit broader than is she an expert. She has all kinds of training. And again, just to set expectation, is the judge going to rule today? No, she's not. This judge does not rule from the bench. So we're in cross-examination. The entire day of direct examination was done on December 12th. That's on the channel. There's a quick bit up. It's linked down below. We did it also as a trailer. We kept it a little bit shorter. We cut it down a little for a trailer for an overview of what happened.
Good morning, Dr. Russell.
But Dr. Russell says that the
Dr. Russell, it's fair to say that
injuries
your
are from a dog.
opinions have changed between the time
know
when you
if that's
first
fair to
testified
say.
at the voir dire to when you testified at the trial and then at our last time we met at the Lanigan hearing. Do you remember we spoke
She
about
said they
when
have
you
not.
testified at the voir dire hearing, you had uncertainty about
The reason he's saying the voir dire hearing is because at trial, they voir dired her on this. So they did questioning outside the presence of the jury of Dr. Russell to talk to her about what she was going to testify about in trial, she was disclosed late, and that's because she came to the defense's attention late. They didn't know she existed. Nobody knew, and then it was like, we're going to call her in. So this is going to be a vigorous cross-examination, but she was incredibly limited at trial because of that late discovery. The defense wants to expand that, and this motion could backfire on the prosecution, where the defense actually gets to expand her area of expertise.
What had actually caused the wounds?
I did not.
Do you remember using the words like, most likely, a dog?
No.
She did do
Let me
that.
remind you, in the
Her-
voir dire,
It was couched.
do you remember
definitely
the court asking
couched
you
her
what kind of
testimony.
animal caused the wound? And you said most likely a dog, a large dog?
May I see that?
Yes, you may.
Oh boy. It's early to go to the transcript. Hold on, I'm looking for a cord. Look, whole new desk setup, y'all. It's gonna take me a minute.
Counsel, page 51, line 18.
Thank you, Mr. Brennan.
May I approach, Your Honor?
Yes.
Dr. Russell, I'm showing you a copy of your voir dire transcript. I'm going to ask
I love
you to
the,
read it yourself when you're done reading
this
it.
page,
If you're
counsel.
comfortable with that time, I'm going to ask you the questions again. You can look at any part of that you would like.
It's gonna be a long day if we're gonna just do this and have to listen to the paper up there. I love that, I'm pretty sure Court TV is pool. I love that there's just a microphone taped up there as well. They're like, we're gonna get better sound no matter what.
Yes.
Oh, it's gonna be a long day.
Do you now remember when the court asked you what kind
However,
of animal you said
I
most
don't
likely
think that's a change
a
in
dog,
testimony.
A large dog?
I think it was couched, which
Do
is
you remember at trial your
Just what it is.
perspective and opinion changing?
No.
Do you remember you were asked at trial whether or not the patterns appear to be injuries you would see consistent with an animal or a large dog, and you said yes? Do you remember that?
May I see that?
You should know.
We're gonna do this all day, aren't we? I'm still trying to figure out like where stuff goes on the new desk.
Trial
Don't worry,
transcript,
members. We'll do a
page
background of
23, line
new desk.
3. This is a copy of your trial transcript. Feel free to look at any part you like.
Ugh. The white noise machine. And that, for those of you who are like, Emily, WTF is that noise? That is the white noise machine when there is a sidebar. I don't know why it's happening when there's not a jury in the room. That wouldn't be my choice because they're not really at sidebar when they are just approaching the witness to show her a line from a transcript. Somebody should have brought a transcript for the witness. So that's what some of that
Do you remember now
background is.
saying that?
I didn't say it.
Okay.
The question had that word possibly in it. I didn't say,
I'm sorry.
That's a fair answer. The question had the word possibly in it.
I didn't use the word possibly.
Okay. You were asked, does this appear as a pattern of injury that you see appear consistent with an animal or a large dog? And you said yes. Do you remember that?
Can you show that to me again?
Yes.
Okay.
Does it appear consistent? Yes.
Your Honor, may I make a suggestion if I could, please? I realize it's crossed. Mr. Brennan and I have agreed that with regard to transcripts and the use of them, I have them as well. Given that we've agreed for transcripts being in evidence, can the witness keep the transcripts and look at them?
Do you have an extra copy for her?
The answer is I have a copy, yes, that
Do
she
your
can.
colleagues each have?
Do you have an
a
extra
copy?
copy?
I don't know if they do, but I can give mine
Okay.
so that she
Problem
can
with that,
have.
Mr. Brennan?
You need yours.
Okay.
He needs his copy so he can see if it's being represented accurately.
It is. It's okay. I know what they say. You have an extra copy?
He's like, I got it. Don't worry about it.
Which page is it?
Well, I'm going to go through a lot of it, so you might as well give her the whole trial transcript.
He said, I'm going to go through a lot of it, so you might as well give her the whole thing.
mine. All right, so that we can continue. You can give yours to the witness.
Oh, the judge is
15
just
minutes,
like,
and then
what are we
when yours
doing?
done, you can have yours.
Thank you, Your Honor, I appreciate that.
Thanks, John.
So what are they doing? Getting a copy of the transcript for the witness. For those of you that said, I saw a couple questions. Let's see if I grabbed them when I saw them or just grabbed them in my brain. One of the things I saw was, does her couching her testimony indicate she was lying?
Why don't
No.
we take a 5-minute recess?
She was just saying most likely a
Mr.
dog.
Brennan,
I think
Mr. Alessi?
it's
Why
parsing
don't we
words.
take a 5-minute recess? Mr. McDermott will be back with clean copies of the transcripts that I have as part of your exhibits.
Thank you very much.
To
And the
be
witness
clear,
can
just so
have-
Mr. McDermott doesn't have to do it twice, Mr. Brennan has just indicated to me he's going to go back to the June 18th, so is Mr. McDermott going to copy the June 18th and the June 20th?
I have the voir dire and the trial testimony.
So they're making copies of transcripts for the witness. And the court is on break. So I'm going to zoom past the court break, but does her saying most probably a dog, she's saying I was answering the question. So the question was, is this most probably a dog? And she said yes. So those aren't exactly her words. They're going to try to catch her in, well, your opinion has changed. She's always said it was a dog bite. Did she say most likely instead of it is? Maybe, but does that indicate a change of opinion to you? Because the jury's going to decide if that's a change of opinion, because they are trying to catch her in something that the jury can use to find her either more or less credible. So that's what all these questions are going to be through. And then we've got Elizabeth, who asked, does this witness words like most likely create reasonable doubt, therefore favoring defense? This is a defense witness. So they want this witness to be as firm and strong as possible with this. This is what the defense wants from this witness. This was a dog bite. This was not a vehicle, period. So that's what they are trying to get. So when it's most likely or when it's a little bit more hesitant, then it can be difficult because the prosecution can be like, well, you're not really sure. But can anyone be 100% sure? I don't know with this. We're going to find out if somebody can be 100% sure when we get into the scientific methodology, which is what I imagine we're going to spend a lot of today talking about. So let me pull court up on screen as we zoom past an extensive morning break here to get copies of transcripts. Again, live court's dynamic, but out of 3 questions, I think they took a break for like 45 minutes, which is why we give ourselves zoom room. Also, the earlier it is, the more difficult it is in my household for me. Well, and just for me in general. All right. It looked like you were about to start, Brennan. You're messing up my zooms.
Yes,
There we go.
May I speak, Your Honor?
yes.
Dr.
No.
Russell, I'm handing you 2 documents. You have a third.
May I
The one
speak?
before you is a transcript of the last hearing called the Lanigan hearing that you attended. This is a copy of your voir dire testimony. I've noted it on the top right for you, and also trial testimony.
Ah,
Thank you.
Thank you.
where in the world did my... let's just bring it back again. Court just yeeted itself out of the feed. That was delightful.
Yes.
That was lovely.
I had asked you if you had expressed any uncertainty in the past about your opinion as it relates to the opinion you gave at the Lanigan hearing, at the last hearing, whether your position has changed or evolved is what I'm getting at. And you
Lanigan
said
hearing,
that your
Daubert
position
hearing, same,
has
same.
not changed. Is that right?
That's correct.
You were asked at the trial about the injuries and how you think they happened. I want you to turn to the trial transcript. If you'd turn to page 19, line 21.
Yeah, the extra mic is gone now.
19,
Page
Line-
19, line 21, may I approach, Your Honor?
Yes.
So the page number is here?
Yes.
And then line would be, okay. Sorry.
She's like, can we just, and we're going to hear the paper so loud, which is why I don't want to gain court up anymore, because it's pretty loud. At least on my end, it's pretty loud.
My apologies.
So I don't want to,
This one is the trial.
gain it up too much,
Okay.
because then those loud background noises are going to destroy us. Cynthia in the chat said this all seems petty. It's outside the presence of the jury, so it might be more petty. We don't know how he will be in trial. We haven't seen Brennan in trial, but it's a lot of very precise, picky,
Do you recall at the
minute
trial?
questioning. Because you don't
You
want to
were
do all of it in
asked.
front of the jury. Brennan wants to find the little threads he's going to pull in front of the jury. He's not supposed to go on a full fishing expedition, but he's going to go through everything she said at the voir dire, everything she said at the trial, and start picking all of that. So,
About the injuries, and you
he's
said, I
prepping for
believe
trial.
that these injuries were sustained by an animal, possibly a large dog, because of the pattern of injuries. Do you remember saying that?
That's not here in front of
Okay,
me.
but I'm asking you, do you remember saying that at the trial, that you believe the injuries were sustained by an animal, possibly a large dog?
Something to that effect, yes.
Okay. And when you said that, you used the word possible because you weren't certain.
because
were you?
everything's possible.
Can you show me where that is?
Well, I'm asking a question.
Everything in life
not
has some
asking about
level
the
of
transcript.
possibility,
The
sir.
reason why, when you were asked and you said it was by an animal, possibly a large dog, is because you were uncertain.
You know, Mr. Brennan, I think I explained that before, that in medicine, there are no absolutes.
Right.
And that's what, physicians are ingrained to think, is there are no absolutes in medicine. So that's why I expressed it that way.
And this is what
But
you
I
say in
was,
front
I
of a
was
jury.
certain that there was a dog.
Yet you were testifying as an expert witness, weren't you?
She's like,
Yes, I
"Sir,
understand that,
I've been
but
a
I was thinking
doctor
like a doctor.
for a million years.
And you understood as an expert witness that you were asking the jury to rely on your opinion. You were trying to be as accurate as possible, weren't you?
Yes, I usually do, yes.
You were
Yes.
trying to be precise in your testimony under oath, weren't you?
Yes, and I don't see a difference really between those.
Agreed.
And when you used the word possibly a large animal, that's different than an opinion to a reasonable degree of medical certainty, isn't it?
Objection, Your Honor.
In this witness's view.
It calls for legal conclusion. That's why they objected.
That he's referring to.
So he's not
He's-
asking about the transcript.
It calls for a legal
I'm going to allow
conclusion.
a question.
Would you like me to repeat that?
Yes, please.
When you chose the word,
Experts have to be able to testify to a reasonable degree of medical certainty that whatever thing is. And so that's why he's getting directly into, well, you couldn't testify to a reasonable degree of medical certainty. So he's trying to attack the underlying foundation of her opinion to either let it in or not let it in. And I know you guys are annoyed by Brennan's questioning style, and that varies based on how much you like the witness. Like if you really dislike this witness and a lawyer was going in, you're just like, get him. But when it's a witness you really like, it's like, ooh, ow, stop it. But this witness has to be able to hold her own. And remember, it's better to do it now than in front of the jury because she's going to know what all of his tricks are. She's going to know how this attorney questions. So it's good for both of them really to do this thoroughly before jury.
during your testimony to precisely describe what you thought, and you said possibly a large dog, that is different than to a reasonable degree of medical certainty, isn't it?
No, I don't think so.
You were
Right.
asked
She doesn't agree. That's it.
whether or not you could tell what type of animal left these marks, and you said you couldn't with 100% certainty.
She said large
Isn't that
dog.
true?
With 100% certainty, that's correct.
And the reason
Nobody
why
could.
you don't have certainty when you first testified is because there really is no methodology in identifying dog bite wounds, is there?
But that's incorrect.
I see. When you talk about methodology, is there any standard you're comparing your
And again, if
comparisons
he
to?
annoys you, he'll annoy a jury
There
too.
are multiple published peer-review articles that describe what dog bites and dog injuries look like.
Is there any standard that you use?
My coffee's still
Is
really
there
hot.
any
It makes me happy.
particular things you look at with specificity that you compare?
And she's
to a
going to talk about
standard
pattern
model?
recognition.
The pattern.
The standard model of patterns, where do you get that from?
Pattern recognition is used throughout medicine. And,
Brennan,
you
come
know,
talk to all
it's
the
something that I
neurodivergents
have
in the
been
chat about pattern
trained on
recognition.
since the very, actually before medical school, but certainly in medical school.
Pattern recognition, you understand, is different than a standard of comparison.
That calls
You
for legal
understand there's a difference
conclusion.
between those two things, don't
Oh,
you?
yes.
Okay, we'll talk about pattern recognition analysis in a minute. But what you're saying is that there's a methodology in identifying dog wounds. I'm asking you, where does that standard come from?
It comes from multiple published peer-reviewed articles.
Okay, tell me one.
Munich.
I'm sorry?
Munich, we talked about that one last time.
The gentleman who studied human teeth.
No, he wrote about dog bites.
Okay. And what's the name of the article that you've relied on?
The name of the article, I have to refer to my report, but it's something to the effect of forensic evaluation of,
Do you have any specific memory about what you're relying on as a standard of comparison to identify dog bite marks?
The other courtroom, we went the entire hearing in the other courtroom without a single siren. And the second we're back to this courtroom where the trial is, I don't know what side of the building this courtroom's on, but I am guessing that the side of the courtroom that this trial or the side of the courthouse this courtroom is on is right next to where the fire station is, because every single time,
yes.
every
Okay,
single
share
time.
that with us.
Again, the standard would be what the wound looks like, and the pattern recognition that goes along with it, along with the configuration of the wounds. It's a multifactorial
I'm
process.
trying to have you assist us in distinguish between pattern recognition analysis, which we're going to get to, and when you're looking at a wound, the standards in the science, the standards, the methodology you would actually use to look at it and see if there's points of comparison, to see if there's similarity. What standard are you working with?
Pattern recognition.
I'm not so sure I understand what you mean by standard then, because I know how I evaluate wounds.
You have personal experience where you've treated dog wounds and you look at it and you're simply deciding whether or not to you this looks similar. You're giving your personal aside.
No,
Aren't you?
it's her expert
I
opinion.
actually find that offensive.
Oh, okay. Well, is that what you're doing?
No.
It's
So
her
if you're
expertise.
comparing it to an actual science, a standard, a methodology, I want to learn that methodology from you. So what I'm asking you is, tell us, where does that come from, the methodology where you have a point of comparison, where you look at a wound and you compare it for similarities to another item?
There are several published peer-reviewed articles that describe what to look for, how to observe, evaluate, and then sometimes treat wounds, dog
And
bite
that's,
wounds.
I think, what is...
There are, several.
I think that's what's so important about this witness is that she's not just looking at articles and saying, oh, this is the methodology. She's used this methodology in treating and in doing her own studies about treating. So when you are looking to treat, identifying if a wound came from a dog versus some other type of animal or some other type of thing is a very important situation. The thing is, they are in a different realm of science. It's not like DNA testing where it's like, this is the process of DNA testing. You're dealing with a different type of process that you learn through doing. So he's trying to get to, well, there's no repeatable process. He's attacking really not her. She feels attacked, but he's not attacking her. He's attacking the fact that there's not a strict step 1, step 2, step 3, like there is for a DNA testing or a cell phone extraction. But, Brennan, you're going to have to ask Trooper Paul questions at some point, big guy. And I don't know if the crime scene spoke to me is really gonna work. So you're gonna get what you put out there with this, but we'll see. So that's what he's trying to get to, because there has to be some type of underlying methodology. And this hearing, attacks that methodology, saying, Your Honor, there's no real scientific methodology here, so the jury can decide for themselves. And that's what he's trying to do to keep this testimony out, or at least limit it.
Authors that have published similar things. And in terms of there being an organization that says, here is the standard for dog bite wounds,
Right.
I don't think that there is one.
Well, when you say you don't think there is one, if you're an expert in this field, you would know that there is not one.
Oh my
is
God,
there?
these sirens.
There is not one that I know of, correct?
Well, you're not guessing there might be one you don't know of.
I don't know of any published standard by an organization.
So it'd be fair to say, when you are giving an opinion, what you personally believe to be a dog bite wound, there is no standard in dog bite science that shows you what the standard is. There's nothing to compare it to.
Again, it's based on a combination of the experiences that I've had over the last 30 years,
Right.
observing, evaluating, and treating dog bite wounds, plus the numerous articles that I have read on dog bite wounds, their characteristics, morphology, patterns, and other things like complications, et cetera.
Okay, so to get back to my question, I know that you're using your experience and your memory, but there
And
is no
he's trying to get to
standard
there
of comparison.
that that's not.
There's no methodology
Right.
that is accepted as a practice.
I disagree.
Okay.
And that's your,
Can you share with
disagree.
us one of those articles that you've been relying on to combine with your personal experience to come to conclusions in dog bite analysis?
Well, there's the Munich that we talked about.
I didn't talk about. Can you tell us a little bit about it?
Oh, certainly.
Okay.
Great.
Okay, would
Good,
you
let's
like
go.
to?
Yes, let's do that
go
now.
through it together?
Yes.
I'm asking you to tell us about what you're basing
Let's
your
do that
opinion
now.
on, and you said it's Munich, so I don't know
She
much
said
about
W-
it.
Okay,
Munich.
so that's one of them.
Well, tell us a little bit about that.
Okay, well, in that article, the authors described a fatal case, but also described what some of the characteristics are in dog bite
Oh, Chad,
wound
I don't know if they'll
cases.
call true Paul. It was
What
it's just an
types
example
of
on
wounds you
scientific
see,
method
their
and methodology.
appearance, their distribution, their configuration, the different aspects like that. Many of them are parallel. Things that would affect the appearance of wounds that physicians know about, such as elasticity of skin and other ways that wounds can be distorted from one to another wound. So you have to know a little bit about wound characteristics, and basically things to look for in the forensic evaluation of dog bite wounds.
Did that article lay out a standard of methodology?
Yeah,
I guess
pattern
I don't
recognition.
understand what you're getting at.
And the
Rather than having a
defense,
particular case study where that article
the defense should have gone over this with her, because this is the core of the thing. It's not so much that the core of the inquiry here is not so much that she doesn't have a lot of experience, that she hasn't seen a lot of dog bites. It's that there is no methodology in this area. So her looking at something going, it's a dog bite, might be different than another doctor looking at something and saying that it's not. So if there's not a repeatable process, is this the proper grounds for an expert to come in on? And that's the heart of the hearing. So that's why he's really trying to get to, but what is the methodology here? Is there even a methodology here? And can this testimony come in? Because those are the types of technicalities that a judge looks for. Oh, this area doesn't meet the standard, which is why it was surprising that the cell phone throwing dude from the Murdaugh trial came in, because he was just like hurling a phone around his office going, well, it lit up when I did this. That's not a scientific process, test, or methodology. So that's what he's going to keep getting at.
talks about a person that was attacked by a dog and deceased, correct?
In that case,
Yes.
however, it
And
referenced.
and
I'm
it's,
sorry, Your Honor, if she could finish the question.
Yes, I'm going to let her finish.
please.
And Mr. Lessie, for objections, just simply objection.
I'm sorry, Your Honor, I will, thank you.
I'm sorry, Your Honor, it's
That
weird.
article, it was a case report, but
It's
it
a
was
weird
also
rule.
a review of previous literature.
Okay.
So in the review of the previous literature that had been published, they came up with recommendations. So yes, there are recommendations in that article.
In that article, it talked about a wound to the neck where the deceased bled to death, correct?
Yes,
Okay. It didn't talk about pattern recognition analysis.
I
in that article,
disagree.
did it? Okay. And did it talk about a standard of practice of methodology?
Recommendations.
No, but that's not what I'm asking you. I'm asking you, did it have a standard, a methodology that it discussed?
These were authors that were practitioners, and they weren't, I don't believe they were in a position to create a standard.
In
'Cause
fact,
they're
you can't
doctors.
point to one place where there is a readily accepted standard in the dog bite community
And that's
for
what he's getting
identifying
at,
dog bites.
that
You
there
can't
isn't
point to
one.
one article, journal, book.
That's correct.
And so because
And that matters
there is no
quite a lot.
methodology or standard for you to look at, it involves a great deal of your subjective opinion based on your experience treating dog wounds, doesn't it?
And she has
You
a
know,
lot of
with all
that.
due respect, Mr. Brennan, I'm not somebody that just came in off the street. I have at least 30 years as a physician, and I use
fair.
that information in helping me form my opinions about wounds. I've seen all types of wounds.
Okay, so my question,
I love that. My band director used to say all the time, you can't just bring some kid off the street, hand them a trumpet and get them to do what y'all are doing. I'm like, well, you can't hand me a trumpet and get me to do what y'all are doing either, but it is a skill. Not just anyone off the street can come in and do what she's doing. And I think that's fair, but he's not attacking her at the moment. He is attacking the underlying process, that there is no standard process. Why? Because treating physicians are like, this is a dog bite. And then you see it again and you go, oh, that looks like a dog bite. And then you see it again and go, oh, that's probably a dog bite. And then somebody comes in to treat them and you say, what happened to you? And they said, I got bitten by a dog. And you see it over and over and again and go, oh, that's a dog bite. Right.
was because there is no methodology, because there is no standard comparative analysis, you need to rely almost virtually on your personal experience treating wounds.
No, I believe you're again mischaracterizing it. I'm relying on my personal experience plus what I've learned from these numerous articles.
Right.
And so because there is no methodology and standard to compare to, you've introduced the idea that you have used a process known as differential diagnosis.
That's one of the processes used.
And as far as differential diagnosis, what that suggests is when, as a doctor or a person looking at symptoms, you try to rule out other conditions that have similar symptoms.
Correct.
Okay. And so you said, although that's traditionally used in a doctor assessing a cause of a patient's symptoms, you're using that in identifying dog bites, this differential diagnosis you speak of, right?
I used it to assist me, yes.
Okay. And so when you're using differential diagnosis, it means that there are many other ways or reasons why the same symptoms can occur.
Not always. Not always. It could mean that there's just one or two other conditions that would resemble this, but it's a process that a responsible physician would go through.
And in this case, you went through differential diagnosis to exclude other causes of these abrasions on Mr. O'Keefe's arm?
I did.
If you had used your training and experience and you were certain to a reasonable degree of medical certainty that these were dog bites, you would not need to go through differential diagnosis.
Oh, that's so incorrect.
Okay.
I'm not perfect. I'm not 100% perfect human being.
No doctor,
And
no
so
human is.
so I have to, as a responsible physician, in every case, go through a differential diagnosis to make sure I'm evaluating and treating the right thing if there's treatment involved.
When you chose
So I've seen a ton of questions from the chat, and I hope this helps because I'm going to answer them real quick. Alley Cat said, so there's no such thing as an expert because there's no standard. No, let's talk about it. And figuring out, Casey said, so she's an expert. Why does she need to rely on a methodology? When we look at the evidence code to allow an expert to testify, the evidence code sets forth when an expert can testify. So there are different prongs for that. The brief overview of 701 is that it is hold on, This is 702. There we go. An expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand evidence and determine a fact and issue. Done. We're here. The testimony is based on sufficient facts or data. There's photos, there's evidence from the coroner. Done. The testimony is the product of reliable principles and methods. That's what he's on about. And the expert has reliably applied the principles and methods to facts of the case. That's going to happen here. The question is that third prong. The testimony is the product of reliable principles and methodologies. That is the hearing here. Is what she is using to determine something's a dog bite a reliable methodology? So that is why we are in a Daubert hearing. He's calling it a Lanigan hearing. There is a ton of case law on this and what is an analysis and what is allowed, what needs to be evaluated to see if this is a reliable scientific methodology. So the factors that the court is going to consider at the end of the day are whether the scientific theory or process, 1, has been generally accepted in the relevant scientific community, 2, has been or can be subject to testing, 3, has been subject to peer review and publication, 4, has been unacceptably high known or potential rate of error. So whether there's an unacceptable rate of error is going to count against it. And 5 is governed by recognized standards. So in Massachusetts, they call it a Lanigan hearing because it comes from their case Lanigan, not Daubert, but they need to show those things. Is this something that's been subject to peer review publication? Is it subject to testing? Is it governed by recognized standards? And so he's attacking the fact that pattern recognition is not enough of a recognized standard. But the judge may use common sense. Some of you aren't going to feel assured hearing that, but the judge can use common sense in determining the depth of the expert's knowledge and qualifications and determine whether the expert's reliable and discussing something that's reliable. But there is a multi-factor test here, and we can get into more of what the test is at the end of the hearing today. But there's a multi-factor test here. And the factor that is the weakest here is methodology, whether this is replicatable. So that's why he is harping again and again on, but what is the standard in the community? So he can turn around to the court and argue, Your Honor, this prong is missing. And if this prong is missing, it fails. You know, this is not a 3-legged table, Your Honor. We need all 4. So that's why he's arguing with this expert over that prong, because that's his strongest path to argument. He's not arguing she's not an expert. He's arguing that this thing is not something that there's repeatable, reliable scientific methodology in. So no matter how many patients she's treated, it's not a proper subject area for any expert. So that's what we're at. Hopefully that helps. For all of you that gifted memberships, thank you. I'm going to pull those up.
Differential diagnosis. You recognize
Thank you
that these
so much.
abrasions could be caused by a lot of different mechanics of injury.
Thank
didn't
you very much, B2. That's incredibly generous.
I considered that they could have been
Thank
caused
you,
by
Sandra.
others, but I went through the process.
Well, you were uncertain, weren't you?
No.
Yet you went through this process of differential diagnosis anyways.
Yes,
That's what you do.
absolutely.
Okay. And when you did that, you decided that you should focus on car accident.
No, I didn't focus just on car accidents.
Well, what other subjects did you focus on in differential diagnosis other than car accident?
Could these have been self-inflicted, for instance?
You went through that process?
I did.
I didn't see that anywhere in your report
It's in
whatsoever.
my head. I didn't write it down.
Well, aren't you supposed to report the process you go through before coming to conclusions? Isn't that why you wrote a report in discovery and disclosure?
Yes, but it,
Okay. Is there anything else in your head that you thought about that you didn't put
Now
in the
that is
report or tell
condescending.
anybody? So we have car accident, we have suicide. we
No,
have
she didn't
dog
say
bite.
that.
What else
She
did
didn't
you
say
think of
suicide.
in your differential diagnosis?
She said whether the ones
well,
to the
I
arm are
thought,
self-inflicted.
could it possibly be road rash?
Okay.
That goes to car accident.
What else did you think?
Oh, I don't remember all the things I thought of at the time, but there, it wasn't a very large
Thank you,
list, but it
Kelsey.
was a list.
Thank
And
you,
it was a
Fiona.
differential diagnosis.
Well, if it was important enough to think about and distinguish and go through differential diagnosis, can't you remember what it was that you thought it could have been the cause other than
Could it be,
suicide,
could
road
it be,
rash,
could it be? She didn't say
car
suicide.
accident?
Well, of course, I mean, there are some things I thought of and immediately.
His use of the word suicide is going to piss me off because it's not precise, but she's talking about the wounds to the arm. The wounds to the arm are not a factor or cause of death at all of John O'Keefe. They're information to help us figure out or rule in or out a car. So that's what it's being used for. But I don't like his use of words.
Ruled out, you know, were these stab wounds inflicted by someone else? No.
Okay.
You know, so the list, there was a list that I went through in my head. Would it be worth writing down? No, I don't think so.
Well, was there any other significant causes that you
Eritrea, I'm
went
gonna
through
hold
and
on to
vetted
that
through
and answer it at a break.
differential diagnosis
Good
that you
question.
didn't write down?
Not that I remember at this time.
Frickin'
And that's
frack,
why it
this
helps
is the new
to write it
prosecutor.
down.
That's a fair question. That's a fair question.
So,
it's
one of
snarky
those,
AF, but that's fair.
Processes, causes of these abrasions that you went through differential diagnosis for was car accident, wasn't it?
Yes.
In fact, when you first met the defense attorneys, you had an interest in this case, didn't you?
She did.
I thought I could clarify
She had interest in this
the
case.
issue of what
Ooh,
those
that's
wounds were
loud.
caused by.
So you were learning about information about the case publicly before you got involved in this case,
No.
didn't you? Well, you knew there was an issue.
I heard, yes, I did know that there was an issue. I saw something in the Boston Globe, and Mr. Brennan, I wasn't following the case at all. I don't even subscribe to the Globe for information about this
You don't-
general region.
You don't have to be defensive about it. I'm just asking you.
Okay.
You knew
Just
enough
clarifying.
that
I
you
mean,
wanted to get
she's
involved
gonna be
and you made
defensive
some phone
based on your
calls to offer
questions,
your
dude.
services.
I didn't want to get involved, but I thought that I should.
I see. And so you learned enough through your study or the Boston Globe or television that you knew generally that there was an issue about the abrasions, correct?
She knows.
I knew there was a question, yes.
You knew that the defense was claiming that a dog caused those injuries.
I wasn't even sure who was claiming.
She knows and has worked with the LADA's office and works with a cold case DA who's good friends with Alan Jackson. And that's kind of how this all came to be. I wonder if we will see if she talks about that DA. Some of you know exactly who connected her and Alan Jackson, but let's see.
Claiming
If
what?
it comes
at that
up.
point.
So you didn't know much about anything, but you still made phone calls to introduce yourself to get involved in the case?
Again, I know that there are very few people in this country that have the combination of experiences that I do, and I thought that I could just clarify the issue and maybe, help people move along in the case.
Before you decided that you were going to offer your services, what did you know about the case?
I'm looking in the chat to see if anybody has it.
I knew that a police officer had died. I was a former police officer, so I knew a police officer had died. And I knew that there was a trial, and I didn't know details really, I just knew that, I believe I read that there was something about a car accident versus dog bites. That's about all I knew about the case.
Right.
Had you seen any photographs?
No,
Not until they were showed to
So
her.
just generally knowing that there was an issue, you thought you could help because of the word dog bite in your experience?
correct.
Okay. So when you
Charmander,
ruled
you're
out
the first
motor
one I
vehicle
saw.
accident,
Yep.
is it fair to say that your perspective was a motor vehicle accident would have caused injuries to the other parts of the body, and that's why you considered car accident as not part of the cause of these abrasions?
That was not the only reason.
That was one of the reasons?
Morgan, she was an
Yes.
officer.
Did you look at the wounds and you thought based on the accident there would have been broken bones or other injuries?
That was one of the reasons.
Okay.
That is going to be a problem. All right. Sorry, chat. That was me. The way I have my screens set up seems to be what's causing this issue. Again, new setup, new screen setup. That's my issue. Well, it's
so
technically a StreamYard issue.
Based
but
on those two reasons
see if
and
I can
other
fix it
reasons,
real
you
quick.
decided to exclude car accident as the cause of these wounds, correct?
that's
Correct.
And when you made that decision to do
I am
that,
challenged.
and
that keeps happening.
exclude car accidents, you didn't really have the experience in car accidents to decide whether a car accident was the cause of these injuries, did you?
Mr. Brennan, I've seen thousands of car
She's like,
accident victims
"But I
through
do
my
know."
emergency medicine career.
She's like, "Yeah, I do."
So I had plenty of experience.
Had you ever been trained as an accident reconstructionist?
No, I'm trained as a physician to treat car accident.
Was yours? Was yours? I had to say it. Was yours? Was your car accident reconstructionist trained as a car accident reconstructionist? Come on.
Victims.
But that's not what I asked. What I asked you is, you ever been trained as an accident reconstructionist?
No.
Have you ever taken classes and certifications in accident reconstruction?
No.
Have you ever gone to a scene of an accident and been asked to give your opinion and help reconstruct the accident?
No.
Have you ever served as a witness in court as an accident reconstructionist?
No.
In fact, when you decided that this accident couldn't happen, you hadn't even read the investigative reports, had you?
No, I didn't decide that an accident didn't happen. What I decided was that those injuries were not from a motor vehicle accident.
When you first gave your opinion in this case, she was done.
Wow.
Mr. Leslie, next question, please.
When you first gave your
done,
opinion in this
sir.
case, excluding car accident, you had
he
not
crosses
even
her like
read
this
the
in front of the
investigative
jury, they're
reports in
gonna
this
hate it.
case, had you?
That's correct.
Yeah. And when you were asked about materials that you reviewed to give your opinions, you said you were just trying to focus on the wounds and you hadn't read those reports, right?
That's correct.
Have you read the reports to
Yes.
date? You now have read the reports?
Yes.
Okay. When you excluded the car accident, did you know anything about this collision between the Lexus and Mr. O'Keefe? Did you know anything about it?
Objection, Your Honor.
Can you answer that question, Dr. Russell?
That's what this hearing's
Did I
for.
know anything
Yeah.
about?
Did you know anything about how it happened?
I was, somehow I knew that, well, I believe I knew that the car was backing up. That's what I was, somehow I got that information.
So
The
when
car
you were
backed up.
excluding the collision in this differential diagnosis, did you know how fast that Lexus was going back when it struck Mr. O'Keefe?
No.
Do you know how far it traveled when it hit Mr. O'Keefe?
Does it matter?
Objection, Your Honor.
So it's a question, the question's proper.
The question
Let's
is
see if
proper,
she
but
can
does it
answer
matter?
She may not be able to answer.
Does it matter?
Do you know how far the Lexus traveled backwards when it hit Mr. O'Keefe?
Excuse me. Why the fuck does it matter? Does it matter? Does it matter? And they're going to get to do redirect. Would the speed of the vehicle change your opinion? Probably not. But again, this I think is good for her if she testifies at trial to know exactly what his cross is going to be, because he's not holding anything back.
Your Honor, I'm objecting to the
I
the assumption in
understand.
it.
I understand, counsel.
Also, it's really annoying to me that this jurisdiction is just objection with no further anything. And the defense attorney is not having it. But I think it's fair to allow these questions. Again, we're not in front of a jury. This is an evidentiary hearing. More needs to come in rather than less. And so the court is going to allow more in rather than less. He's making objections for the record, but I think it should just be allowed. It's an evidentiary hearing.
Can you answer that question as asked, Dr. Russell?
As asked, no, I don't know.
When you excluded this collision as differential diagnosis, did you know the angle of the collision between the car and Mr. O'Keefe?
I'm
Objection,
going
Your
to
Honor.
see counsel at 7.
I hate the white noise machine. I think, well, I don't know what the defense is flustered about. Again, does it matter to her? Does it not matter to her? The defense will get to ask. So we're going to zoom past this sidebar as best we can and get back into the somewhat snarky, vigorous questioning.
O'Keefe, who had these abrasions on his
Let
arm,
me back up.
the Lexus.
I love the
about
ability to zoom.
Did you
so
know
much.
as the cause of
Oh,
the
gosh, that's a
diff-
long fucking question, Brennan. I had to back up like
Ma'am.
4 times.
when you engaged in differential diagnosis, excluding a car collision as the cause of these abrasions, did you know or learn any information
That's fair.
about the angle of the strike between the Lexus and Mr.
Do we have the information about the angle of the strike between the Lexus and John O'Keefe? Because if that was in the first trial, I fucking missed it. Do we know that? Is that information something that was brought up in the last trial? Because I watched the whole thing.
O'Keefe?
No.
Do you know whether or not
Information
the
does not
person,
exist.
John O'Keefe,
The limit
who
does
had
not
these
exist.
abrasions on his arm, do you know if that person used his arm in any way to defend himself
She's like, yes,
from
he
an
did from a dog.
oncoming vehicle?
I considered that,
You did?
yes.
And in considering that, did you consider the body position of John O'Keefe?
Oh, yes, I considered various possibilities.
Okay, what was his body position at the time the car allegedly collided with him?
Objection, Your Honor.
Use the word allegedly, I'm going with that.
What was his body position?
I considered several possibilities. I considered if he was standing, I considered if he was kneeling or sitting or even lying down. I considered multiple
Was
possibilities.
he standing?
I don't know, but I considered all of those possibilities.
Was he kneeling?
I
don't know.
considered it.
Was he lying down?
I don't know.
So you considered all these things, but you have no information, fact, or understanding of what body position he was.
Do you?
I went through the process of what the wounds would look like in those various positions.
I see. So if John O'Keefe was trying to defend himself, pulling his arm up to brace himself,
Defend himself from
what
what?
would the injuries have looked like?
Well, if they penetrated his clothing,
If
there was
what?
if there was penetration of his clothing,
Uh-huh.
from broken parts, for instance, they would have been quite irregular. There would not have been multiple parallel abrasions and punctate wounds that were seen in those pictures
How do you know that?
from my many years of experience.
Okay. Did you do any comparison analysis
She's giving it right
of
back
the
to him.
broken tail light in Mr. O'Keefe's arm
Actually, eventually, I did.
before you gave these opinions, did you?
I didn't need to because I've seen thousands of accident victims.
Every accident is dynamic and changes, isn't it?
Yes, but I
Every-
also,
But
I also
bodies are
had that in
bodies.
consideration. That's
Every-
why people train for the number of years that I trained.
Every accident is different, isn't it?
Yes, probably.
And so you can have a number of people in an accident,
Cars are
and they
still
can have
cars.
different injuries from the same accident, can't they?
Oh, absolutely.
Cars are
Right?
still
Car
cars.
drives down the street and runs into 20 people, they may all have different injuries.
I agree.
Same
But
car.
cars are still cars.
agree.
Might be the same speed,
But cars are still cars.
but they could hit people differently. Some people, unfortunately, they could kill, right?
Yes,
Some people could be catastrophically injured but
But
still
we're
alive.
talking about this.
correct.
Some people could have scratches and bruises.
Correct.
But we're talking
Some
about this
people
car.
could be in that type of situation, bounce off the car and escape without a scratch.
Possibly, yes.
I mean,
So there's no science or standard when you say car accidents would have had a certain result. The truth is you don't know.
there's no science or standard about car accidents having a result. Are we gonna play this with your experts too? You can't tell it's a car accident. Car accidents could all have different results. How can you say? And you know what? In this case, the coroner can't say. The coroner's like, there's injuries. Did it come from a car? Coroner's like, I can't say. Oh.
I disagree with you.
Okay. And so when you were excluding these causes, you have no idea his body position or angle, correct?
I went through various scenarios in my head.
But I'm asking you, not the scenarios in your head, Dr. Russell. I'm asking you about
I want her to say,
detail, fact.
I want her to say, no matter what position his body is in, a car doesn't bite. That I'm waiting.
Science.
I'm waiting for
okay?
her.
I'm asking you, do you have any idea the position of John O'Keefe's body when he allegedly was struck by the car?
Objection, Your Honor.
And I'm going with that.
I considered multiple scenarios.
Tell me the facts you have. Tell me the facts you have. You can tell us how is his body postured on fact. What facts do you have?
This is your opportunity to say, well, I went through all the reports from your experts, and they don't seem to have any facts about how this happened. So I'm basing it off of looking at the victim's body. I'm waiting.
Again, I considered multiple scenarios.
When you
She should give him the facts that she reviewed.
did you go to the scene of where Mr. O'Keefe was found lying on the ground? Did you
Why
go
would
and
she?
visit the scene?
No,
Did you
Why
take
would she?
and look at photographs of the scene?
I looked at some photographs.
What did you see in those photographs?
They were very difficult. It was very difficult to see much useful
weren't any
information
teeth.
in the
Well,
photographs.
when you're engaging in differential diagnosis and you're excluding causes of
I
abrasions
saw
in
Red
Mr.
Solo
O'Keefe's
Cups, got
arm,
confused and
wouldn't
stopped.
it be important to either go to the scene or look at clear photographs so you could see all the debris
No.
and the land and the turf and see what it looked like? Wouldn't that be important?
No, in the 30 years of or emergency medicine experience I've had, I've never gone to the scene of a car accident victim that was brought into the emergency room.
And you've never gone into court and testified as an accident reconstruction expert.
A reconstruction expert? No,
You've
but I've
never-
testified about vehicle accidents.
And you've never gone to court and
Victims.
testified as a
She's getting
dog bite
annoyed.
expert before this case, yes?
I was never asked.
And so, when you say what you used to do, you treated people who came in with injuries. I'm
If y'all
talking
wonder
about
why
when you're
experts
going
are
to
paid well.
exclude something as a cause. I'm asking if you have any experience in actually going out and looking at the facts and using science to exclude something fairly.
I used medical science.
Do you know what the ground looked like where Mr. O'Keefe lay that morning?
There was snow.
You know how many inches of snow were under his body?
Under his body?
Yeah.
No.
Do you know what the ground was? Do you know if it was smooth like a turf football field or
Does it matter?
frozen jagged like dirt tends to do in the Northeast during the cold winter?
I considered several different possibilities: grass, dirt,
Gravel.
asphalt. So I considered several different possibilities to see in my differential diagnosis.
You considered all these different possibilities, but you never even went and looked at the scene to see what it looked like, did you?
I didn't have to.
Do you know if
So
there was twigs or roots or brush nearby?
these weren't caused by
don't
twigs,
know.
so it doesn't
Do you know
matter.
if there was a fire hydrant nearby?
There was a fire hydrant nearby.
Do you know if there was a curb nearby?
That I don't know.
So you have no idea really, other than a fire hydrant, what this area of impact or alleged impact looked like, do you?
Well, again, a curb would not have caused those wounds.
So it doesn't
that's irrelevant.
Fucking matter. Yeah.
You have no idea.
I disagree.
I have an idea that a curb doesn't cause those
Did someone
lacerations.
tell you
Sir,
what
I
it
worked
looked
as an EMT for 7 seconds, and I will tell you that a curb does not cause those lacerations. Furthermore, I am a parent who has had children ride bikes. I, myself, I know, was once a child who rode bikes. I will tell you, without a shadow of any doubt, and to a medical degree of certainty that I do not have, that a curb does not cause those scratches and puncture wounds. It's a very, a very sharp curb does not cause those injuries, sir. And a curb covered in snow sure as fuck doesn't.
No.
Ah,
Okay.
also, I don't know if you're defending yourself from a car like this, or if you would put your hands out like this, or if you would try to jump. Superman.
You said that you ruled
Wrong
out
case, I'm
car
not.
accident or collision in part because there were no broken bones. Yes?
In part.
Which is
And
strange
we've
at the rate of
agreed-
Excuse me,
speed.
except for no skeletal broken bones.
Right.
Yes, there were broken bones in the
And we've
cranium.
agreed that car accidents are a dynamic process. Not all car accidents result in broken bones, do they?
That's correct.
It depends on.
Work with me, chat. Just fast forward to what it's going to look like when he tries to cross-examine the crash daddies when we get to trial 2 in April. Just put that picture in your mind.
on how and where and a number of other factors in the collision. Yes?
That's why it was only one of the factors I used.
Well, it's one of the factors you excluded. Do you know the difference in force between a head-on collision and a side swipe?
I have a general idea.
Is there less force when someone is hit on the side of the car as opposed to being run over?
As opposed to being run over?
Yeah.
Generally, yes.
Right. And I'm sure in your thousands of treatments, you have treated people in the hospital who have come in contact with a car who did not have broken bones.
Oh, yes.
Plenty of times.
Excuse me?
Many times.
Yes, but they weren't dead.
What's that?
They were not dead.
Right. Okay. Well, you don't know when Mr. O'Keefe died that morning, do you? Do you know what time he died?
I know when he was
haven't.
declared.
I have a range.
You didn't think he died from the abrasions on his arm, do you?
No, he did not die from the abrasions.
Clearly
He
did not
died
die
from-
from the injuries to his arm.
A break in the back of his skull from hitting the ground, right?
And hypothermia.
Oh, he died from a skull fracture and brain injury
And
Yes.
and hypothermia.
Hypothermia.
that.
Oh.
Not from an abrasion to his skull.
Right. The abrasion for his arm had nothing to do with his death, did it?
It did not cause the death.
Okay.
Yeah, nothing to
And
do
so,
with his different.
Is there a difference between the force when a car hits somebody directly on or hits them on a side?
Alita
Generally, yeah.
in the chat mentioned this attorney is being good at his job, but he sucks. He'd be a good defense attorney, not a DA. See, here's the thing. He is a defense attorney. He is hired as the special prosecutor in this case, but is by nature a defense attorney. So he is a defense attorney by trade.
Right. And you've seen
But I
many
think
times
all the
somebody
defense
has been
attorneys in this
contact
case
with
used
the
to be
motor vehicle
prosecutors.
with no broken bones, many times.
I
is not
have
uncommon.
seen that, yes.
I mean, there's a difference between being run over and hitting the side of a car, isn't there?
That's correct.
Yes.
So if someone didn't hit them, they just clipped them, that might be different than being run over in the middle of a crosswalk in the middle of the car, yes?
Yes, that'd be correct, but you have to put it in context.
Now, you said in addition to your
hate the way he
experience
says,
treating injuries, you also have experience as a police officer.
Yes,
Yes. And you've responded to many car collisions as a police officer, didn't you?
I did.
And when you respond to car collisions, whether it's a pedestrian or another car, there are certain things as a detective you detect that are in the street, right?
As a detective,
Yeah, a detective
you
or a police
detect?
officer, you go to a scene
Fucking hell.
and there's a collision, you certainly see things often as
Yes.
a result of the collision, don't you?
yes.
You see things.
Tell us some of the things that you'll see as a police officer after a collision. What do you
Oh,
see?
After a collision, you oftentimes see debris from the car.
Right,
from the
debris from the
vehicles,
car.
yes.
You can see rubber, right?
Not always.
Probably, I don't know if I have, but yes,
Not
Sometimes
always.
metal pieces, parts of the car.
right.
And
Plastic.
sometimes, when there's a
Teeth.
collision,
Just kidding.
maybe often, you see glass, don't you?
Yes, you do.
Yeah,
I'm
glass
being
breaks
snarky.
when a car collides with something, oftentimes, doesn't it?
Yes.
And so when you were doing this, engaging in this differential diagnosis, did you consider the circumstances, the physical evidence at the scene from where Mr. O'Keefe was found?
I considered the possibilities, yes.
Okay, well, there's a phrase, getting knocked out of one's shoes. You've heard that phrase, right?
I've heard the phrase.
Well, you've heard the phrase in relation to car collisions, haven't you? A person getting knocked out of their shoes.
And other things, yes.
Yeah, but not other things. We're talking about car collisions.
Okay.
That's what we want to talk about today.
Okay.
You've heard the phrase knocked out of one's shoes in car collisions, haven't you?
Yes.
Yes, because the force is so great when a car hits a body, it moves the body, and the shoe from friction on the ground can sometimes be left behind. Yes?
I don't know the actual causation, but yes.
Well, you did know in your review of this case that at the very area where that car backed up and Mr. O'Keefe was found, one of his sneakers was found next to the curb on the street. You know that, don't you?
Objection, Your Honor.
Are you aware of that fact?
No.
Okay, next question.
You were never given
Interesting.
any of the information, the physical evidence at the scene where Mr. O'Keefe was found to help you engage in this differential diagnosis?
Interesting.
I eventually saw reports.
So you do know. You do know about the sneaker.
I also, well,
But
I
no, no.
don't know that. I don't know where the sneaker was found, no.
That's fair.
Well, what do you know about the sneaker? It sounds like you know a little bit about the sneaker. Tell us
No,
what you...
well, I know that in hypothermia, there's a condition called paradoxical undressing, where people are sometimes are found without their clothes and shoes.
Was
Because
Mr.
and in this case, there was hypothermia.
What?
Do you have any opinion
That's
that
not
Mr.
gonna be
O'Keefe
helpful.
undressed his shoe before he died?
I have no opinion about that.
Do you have any information, evidence to support such a comment like
She's saying
that?
there's options.
I'm just advising you that there is
There are
a
options.
phenomenon called paradoxical undressing, so that is possibly a cause.
In that phenomenon, does somebody take off one shoe and leave all their other clothes on?
It's possible they could, yeah.
Right, and you have a case that you've seen
No,
just like that?
I have not.
However, with the
Okay.
head injury and the
And so,
testimony
in
regarding the
this
head
case,
injury,
at
he
what point did you learn that Mr.
wasn't
O'Keefe was
doing
knocked out
that.
of his shoe?
I don't know.
Objection, Your Honor.
Phrase it
misstates
differently.
with the knocked out of the shoe is the issue.
At what point in this case did you learn that Mr. O'Keefe's body was about 7 feet off the street, fully clothed, not undressing himself, and that his sneaker was on the roadway right next to the curb?
Objection, Your Honor. Same basis.
So, did you learn that fact?
No,
Next question.
So as you sit here and
There we
testify
go.
today, you didn't know that?
that's correct.
When you're ruling out car collision in your differential diagnosis, wouldn't it be helpful to know a little bit about the physical evidence of where it was found at the scene?
Again, my focus is injuries. The injuries caused by car accidents, not the scene itself,
Right.
injuries. So, so that's what I focused in.
A dog wouldn't knock somebody out of their shoe, would they?
Excuse me?
A dog wouldn't knock somebody out of their shoe, would they?
I don't think so.
Okay.
I mean,
When
wouldn't knock
you
them
were
out of their shoe.
excluding
Could they take
car
off their shoe? I don't
collision
know.
as the
Depends.
cause of these abrasions,
I mean, I don't know.
and you consider circumstantial evidence as a police officer, if there was trace evidence on that shattered taillight, would you want to know about that?
Yes, I would.
Yes. And DNA is a form of trace evidence, isn't it?
Yes.
It's a pretty sound piece of trace evidence, wouldn't you say?
Well, depending on
Yes,
how
if
it's
collected
collected.
properly and chain of evidence, yes.
Right. One of the most formal pieces of scientific evidence that is used in medicine and science, isn't it?
Depending
In
on how it's
forensics, yes.
collected.
Yeah, forensics. And so when you used differential diagnosis and excluded the car collision as the cause of the abrasions to John O'Keefe's arm, did you know that there was DNA on the taillight of the defendant's car?
I did not know that.
Would you want it to have known
I
if there was
think
DNA? Particularly, would you
she
want
would
it to
wanna
have
know that.
known if the DNA on the taillight of the shattered taillight was John O'Keefe's DNA? Would you want to know that in your differential diagnosis?
That would be helpful. However,
right.
again, that the car accident did not cause that configuration of wounds.
So it doesn't
And
matter.
when you're considering the cause of the wounds and you're trying to rule out car accident, you know that that taillight had been shattered, leaving glass and jagged edges.
Right. And she's like, look,
If you had known there was
he could,
John O'Keefe's
both could be
DNA
true,
on
is
that
what she's
taillight,
saying.
would have you
So it's not
wanted
one
to
of the
have
things
taken a
that
closer
she's
study
going to say no.
of the taillight casing and the broken glass?
I don't think it was necessary. Those wounds are so characteristic of a dog attack.
Do you know there was other trace evidence on the back of Miss Reed's car that morning?
Tell me more
Such
about
as?
that.
Hair?
No.
You didn't know that one of John O'Keefe's hair was left on the bumper?
I
No.
got questions about
And
that.
engaging in your differential diagnosis, considering the mechanic of injury, wouldn't it be important to know that the trace evidence coming from John O'Keefe was left not only on the defendant's car, but in the particular...
But wasn't the defendant's car at John O'Keefe's house and in his garage, and he was getting in and out of the car all day, but then the car was transported like all over Hellingone, and then the hair was still there?
area
So many questions.
where the damage to the car, the taillight.
Objection, Your Honor.
Were you aware of that fact, Dr. Russell?
No.
Next question.
When you were excluding a car collision as the cause, did anybody share with you the digital forensics, the black box information
Do you
showing
have
and
that?
demonstrating where the car was, the speed it went back and the distance? Did anybody share that with you?
No.
Did you know that John O'Keefe had a cell phone?
Not surprised.
And
And no one would be.
do you know that at a certain point when that car left, his cell phone, which was found near his body, never moved? Did you know that?
I read
Oh,
that,
okay.
yes.
Okay. And when you were using differential diagnosis and thinking about the potential causes of the abrasions in the arm, did it seem important to you that all these facts coincided? The car reversed, the damage, John O'Keefe on the ground, the phone under him.
Objection, Your Honor.
I'm going to allow that question.
Again, evidentiary
Consider
hearing.
those things, Dr. Russell?
They still don't
As I
change what
mentioned
she
earlier,
thinks
I
about what happened to
considered
his arm.
various possibilities of a
Right.
car accident, and a pedestrian accident, I should say. And I went through many scenarios in my head, and no car accident scenario could create that configuration of wounds that's on the arm.
Right.
You've done advanced studies on wounds related to car accidents and broken taillights?
I've seen thousands.
Oh, no. Have you done any studies?
I-
Do you have any journals that you rely on to say that there's a expected
And that's the point.
pattern that's going to happen when a taillight intrudes through a sweater and into one's skin?
But
I
if the
have-
car was
yes, there are
moving,
many textbooks that I have relied on.
Okay.
It's a fundamental.
the thing is, if the car was moving and ripped the sweater, wouldn't the sweater keep ripping and not be punctures? These are the problems with some of the questions that he's asking, but also she's not answering directly some of the questions, and they're just going to keep going back and forth because he is trying to undermine the methodology and this witness too, but the methodology here, and say, but there's no methodology here. That's the prong he's attacking and continuing to attack.
Area of study in forensic medicine and emergency medicine. And in fact, the examination of the exterior of the body in a motor vehicle accident case is emphasized, and special lectures are given about that topic to the forensic doctors.
You never examined John O'Keefe's body.
By photographs, yes.
You never examined his body.
Personally, no.
No, personally, you never examined his body.
I never touched his body. I examined
No,
the
no, you
photographs that
didn't.
were taken in the hospital and in the coroner's office, medical
you're-
examiner's office.
When
And
you're
the
treating
Coroner report.
at the hospital and people are coming in telling you there was a dog bite, you're relying on that reporter's history, aren't you?
Usually, yes.
Or an eyewitness who saw it and told you about it.
Correct.
When I asked you before when we were here the last time about any cases where you had to make a diagnosis without information, you couldn't point to one. I asked you to give me one example, and you couldn't give me an example, could you?
I don't remember patients' names.
And so when you rely on the reporter as a medical expert, you take what they say, right? And you assume it's true.
Oh, not always, no.
I see. You
No,
look and see if it's
absolutely
not.
Objection, Your Honor.
Excuse me. One person speaks at a time.
Please.
Let her answer, Mr. Brennan.
No, I don't always take what they say as true because there's many reasons why people do not tell the truth.
Did somebody ever come in and say it was a dog bite and you did differential diagnosis and pattern recognition analysis and determined they were lying, it was not a dog bite?
No.
In all the hundreds, thousands of cases, never has anybody reported to you a dog bite and you determined independently through your powers that it wasn't a dog bite.
Not dog bites, but other wounds, gunshot wounds, stab wounds,
Yeah.
many other kinds of wounds. People report that they occur a certain way, and actually they have occurred a different way.
With respect to dog bites, every time you've treated a patient, they've either told you what happened or somebody with them has told you what happened.
Or they didn't know what happened.
Okay. In this case, when you were excluding the collision as the cause of the abrasions on Mr. O'Keefe's arm, did you look at witness statements?
As far as I know, there were no witnesses to the event.
Okay.
Right.
Well, did
Well-
you read the testimony of Officer Sarif? Because the witness who talked to him was Karen Reed. Did you read that?
Objection, Your Honor.
So ask the question differently, Mr. Brennan.
Okay. Did you know that Officer Sarif reported that Karen Reed said, "This is all my fault. This is my fault. I did this." Did you consider that
I
or
don't
know
think
about
that's
that when
exactly
you
what
made
Seraph said.
your differential diagnosis regarding the collision?
At some point, I did know that there was a statement like that.
Well, not like that. Did you know about this statement? This is all my...
None of this is relevant to her opinion about the arm, though.
My fault. This is my fault. I did this. Did you know about this statement?
Objection, Your Honor.
Did you know that statement? I'm allowing the question.
No.
Let's move on.
Do you know
Mr.
about the statement to Mr. Flamati? I hit him, oh my God,
the
I hit him.
judge saying, "Let's
Did you
move
know about
on."
that statement?
Not that statement, no.
Does it change your
Did you
opinion
know
about
about
the
the
arm,
statement
though?
that she repeated repeatedly? I hit him. I hit him. Did you know about that?
I learned that there was some question about whether there was a statement or a question, did I hit him? I learned that. But that doesn't, I mean, okay,
It
you
doesn't
learn that from?
change.
I don't remember.
Okay.
That's
You
not
said that
good.
you had experience in domestic violence cases? Okay.
For an expert, if she is relying on reports, you want the expert to say, where did you get that from? I read these reports. You want the expert to be able to line out where the information she is intaking comes from, because then if any of that information is not good information, she can say, this information came from this report and this information came from that report. For her, none of this matters, right? So for her, she's like, none of this is relevant to the injuries on the arm. The injuries on the arm, for her, didn't come from a car. So the rest of the stuff going on with the car is not relevant to her because the injuries from the arm didn't come from a car. That's all she's being asked to determine. But it's not great at all when he's saying, where did that information comes from? As an expert witness, she needs to be able to well identify, this came from this report, this came from that report, because not only does it help her, but it helps the attorneys that call her as a witness or any expert witness say later in argument, look, and this report's based on that information. And ladies and gentlemen, you know that this information is not XYZ. So it's not helpful when she is like, I don't have where that information came from. That's not helpful for her as an expert, but she is not testified as an expert like this. It seems very often. And that is where we get some of this discomfort from this witness, which is not great
Did you know that it's reported that the defendant and Mr. O'Keefe got in an argument shortly before this happened?
Yes, I know that.
She's been an expert, but not like this. She's not been an expert in this area.
When you were considering the cause of these injuries, did you consider Ms. Reed's statements herself to not just witnesses, but to the public, to national magazines and programs? Did you consider any of that?
I don't read the national magazines.
I have no idea.
Well, would it help you if you knew she told Boston Magazine that
No.
maybe John hit the back of her car, telling her to stop,
No.
and then she ran over his foot, or she clipped him in the knee, and in his drunkenness, he passed out?
Doesn't help
Would
her at
that
all.
help in your differential diagnosis?
Objection, Your Honor.
I'm going to allow that.
No, it
It
wouldn't.
wouldn't help because those wounds were caused by a dog.
Well,
Right.
if you believe that statement that she said about running over his foot and clipping him, it
Well,
would
then
help
his
you
foot would be
conclude that it wasn't
broken.
a straight-on accident, that it was on the side, right?
Objection, Your Honor.
I'm going to allow it.
Stop objecting. Just let
Even
this
if it
go.
were on the side, the car did not cause those injuries.
Right.
And we talked about when someone's hit on the side, they could brace or defend themselves, correct?
Oh, correct.
Right. And did you know that if John O'Keefe was standing up and his arm was bent, it would be about the same height as that taillight?
Yes,
How did you
that I
know that?
understand. I've been hit on the side. I know about side injuries,
Uh-huh.
side swipe injuries.
Yeah, a clip. It's different, right? And so knowing that his height matches up with the taillight, what other evidence would you want to know before you excluded the taillight as the causes of injury?
It's going to be harder
To
for
be
them
thorough,
to take
what
this
else would you
tack
wanna
at
know?
trial, though.
Well, I see pictures of the fragments of the taillight, which I eventually did, and were there any pieces of metal that had the configuration, anything that could cause those parallel lines with the punctate injuries in between?
How about taillight fragments?
James in the chat said, I think we
Yes.
just got a
Little pieces of
preview.
glass,
I think
right?
so, too.
When glass shatters, it shatters randomly, doesn't it?
Well, it depends on what kind of glass. So,
How about, I'm sorry, please.
It depends on the
it
glass,
depends
sir.
on what kind of glass.
I want you. I
Well,
need to
motor
interrupt
vehicle
you.
glass, a lot of motor vehicle glass is tempered glass, and that shatters a certain way
Okay.
and creates a characteristic injuries.
Okay. Tell me about your experience in Lexus rear taillight coverings. What is the pattern injury on that?
I'm not aware of any patent injuries.
And are
Right.
you aware when the rear tail light of a Lexus breaks, the different pieces it breaks into? Is it random, or is there a standard in how it breaks?
Like, I
I'm
don't know.
not sure,
It's not
but
a
I have
dog.
an idea.
I'm sorry?
I'm not sure.
Not a dog. She's like, I don't know. Not a dog.
Did you look at any photographs of the scene in the debris field showing the different size taillight fragments at the very scene where Mr. O'Keefe was found on the ground? Did you look at any of those
He's
photographs?
asking about glass.
I attempted to, but I couldn't see much detail.
Okay, so
Photographs were not good.
Okay, so you don't really have a command of what the debris field looked
Zing.
like relative to the taillight fragments that were on the ground that morning.
Again, I imagine various scenarios of what broken glass and taillight would look like. And again, I could not.
Chat, you are right. Chat is saying, we know that the taillight's glass. Or plastic. I misspoke. Yes, chat, we do know that the taillight is plastic. We saw it reconstructed in court during trial number 1. We saw them bring in all the pieces of plastic in the taillight casing. We know all of that. He's asking her about glass. Why? Because he's asking her about glass. There was glass that found on the bumper, and there are some of you in the chat that are saying it. And we know that John O'Keefe at some point had a glass with him when he left the bar to get into the car. So they are talking about glass, different than talking about plastic. Again, if glass or plastic is moving, I think what she should explain at some point is you would expect, and I think she explained this on the first day of her testimony, you would expect the puncture wounds in the clothing to tear because they puncture and then keep moving. And that's, I think, going to be determinative for her, is both the damage to the arm and the damage to the clothing. But we'll see. Again, this is a pretrial evidentiary hearing to see what this witness will testify to or not.
Come up with any scenario that would cause
We won't know
those
today.
parallel marks and the pattern that we described.
Right.
Well, I don't need you to imagine a scenario. I only want to talk
That's
about
her job
one
as an
scenario.
expert.
That's the scenario that led to the death of Mr. O'Keefe that morning. That's the scenario I'm asking you about. And the debris field that actually existed that morning. So what I'm asking you, when you engage in differential diagnosis and you take the position that this couldn't have happened, I need to understand what you actually know about the physical evidence that's at the scene. So that's what I'm going to ask you about, that scene. If you don't know, it's okay. But I want to ask you about that scene that morning. Do you know how many pieces
They
of
asked so
taillight
much on
were
direct, which is
found
why we're
on
doing
the
so
ground where
much in
Mr.
cross.
O'Keefe was found?
No.
Do you know the shapes and sizes of the shattered parts of the taillight that were found in that debris field where Mr. O'Keefe was found?
I've seen a picture of various safe, pieces of taillight, yes.
And if you've seen that, you would see that there are a number of different pieces of shattered taillight, yes?
Correct.
Of different sizes,
Yeah?
of different shapes,
Uh-huh.
different diameters, right?
Yes, they're irregular, very irregular.
Different, irregular.
Yeah.
Irregular. Many of them sharp,
Yes,
perhaps almost all of them. Yes?
possibly, yes.
Well, you say possibly because you never actually have looked at the physical evidence, you just looked at a couple of photos.
I looked at photos, correct.
And as far as the housing for the taillight, what is that made out of?
I believe it's made out of a plastic,
Okay.
and there's a metal around it.
It's metal.
Yeah.
What's the shape of the metal around it?
What's the shape?
Yeah, what is it, when you're describing the metal that you saw, what does it look like?
Well, it looked like there was some curves in it.
Curves?
Yeah.
Any straight lines in it?
Yeah,
Yep. Any jagged parts of it from the breaking?
yes.
Okay. And inside, were there other parts other than just the casing, like wires or metal sticking out?
Yes.
How many pieces?
I don't know how many.
Okay. Did you ever measure those angles or study the angles of the pieces of metal and the
No,
casing?
but
No.
And
the
you never
biomechanical
studied
engineers,
the angles or took measurements of any of the
did.
shattered taillight, did you?
she's not supposed to know everything.
No.
She is a piece of the puzzle, which the jury will
Now,
understand.
sharp objects
If the defense
can cause
explains it
puncture
well.
wounds, can't they?
Yes.
Yes,
Sharp objects can go through clothes and tear a, no, let
But
me
if-
finish, you can answer.
But if they're moving at speed, this
Sharp
is where she's going to
objects
go. But if they're
can
moving at speed,
Puncture a hole through something like a sweater, can't they?
They
Yes,
can.
but.
And if that object comes back out, it can pull the threads back out with it, couldn't it?
Theoretically, yes.
Yeah. And a sharp object, like glass, can poke or push a hole in a tear in a sweater and then rub up against the skin, causing an abrasion, couldn't it?
And, well, yes. Yes.
Brennan's
And
going to
if
start
the
to piss me off
glass
because I
and the
want to
angles
finish rereading
and the
Iron
shattering
Flame.
is irregular, it could cause
A
a
lot of-
regular
a lot of lawsuits
type
to read.
abrasions.
Brennan,
Not like that pattern, no.
No, that's not what I'm asking you. I'm asking you, can irregular glass that penetrates a sweatshirt or a sweater and rubs up against the skin, can it cause irregular looking abrasions?
Yes.
And if there's two pieces of metal or glass that are straight, could it cause a linear abrasion?
Yes.
Would you agree with this statement? In a car accident, linear wounds are most commonly caused by contact with shattered glass from the windows, particularly tempered glass, which breaks into small, sharp shards that can create linear cuts on the skin when the body impacts it during
it's
the
a long
collision.
question.
These are often referred to as dicing injuries in forensic medicine.
Yes, and so they're not really very long, linear. They are tiny linear abrasions or lacerations.
Abrasions come in all different sizes.
Right, but the ones that caused by
But
tempered
dicing
glass
is-
are very, very
Because
characteristic.
tempered glass is
Does
small
glass
pebbles.
cause a slicing pattern?
It can.
And it can cause a linear abrasion.
Yes, but there's a specific pattern with tempered glass.
I understand that you have an opinion.
Oh, no, it's fact.
Okay.
Sir, if you're going to start to get into dicing injuries and the pattern that tempered glass makes, then we are back to, oh, you can recognize the pattern of injuries because certain injuries caused by a certain thing happen the same way. Tempered glass injuries have a pattern that looks like this, which means she's going to be able to bring in articles if he tries to go down this road later and say, no, you can recognize the pattern of injuries by tempered glass, just like you can recognize the pattern of injuries by something else. So I love it's not an opinion, it's fact. She's like, no, that's factual. Tempered glass causes a specific, if anyone has unfortunately experienced tempered glass shattering and causing you injury or seeing it, when she's talking about it being small, right? That's funny though. No, it's a fact.
Or abrasion.
Yes,
I
but there's
backed
a
up for a
specific
minute.
pattern with tempered glass.
I understand that you have an opinion.
Oh no, we're well in
Oh, no, it's
hypotheticals
fact.
here.
It's in textbooks.
Yeah,
We're
it's in
well in
textbooks that
hypotheticals
glass
here.
can cause linear abrasions.
The tempered glass pattern is in textbooks.
Glass from this broken taillight could cause linear abrasions.
That probably, yes, I agree.
Okay. So the glass that was in this debris field that you got a little look at, it had sharp edges, some of it, right? Yes?
Yeah, I
Ha-
imagine so. I don't know for sure.
Okay. Do you know if it had parallel edges?
Parallel?
Yes.
I don't know.
Okay. Now, when you're looking for trace evidence to see if something caused an injury, you look for remnants of that evidence, don't you?
Yes.
In this case, you didn't do any study of the clothes, and you didn't do any study of the actual
Not her job.
Mr. O'Keefe's body, right?
I did not have hands-on.
Okay.
This is the most defense
but
attorney line of questioning ever, which is, and you guys have seen it trial after trial after trial, ask them all about stuff that's literally not their job, not her job, not what she's here to do, not her job, not what she's here to evaluate. But it is, we don't always see that with people who are just prosecutors all the time. They cross-examine differently. He is a defense attorney all the time. So you're definitely seeing this line of more defense attorney style questioning, almost similar to Alan Jackson's style, but he doesn't change his tonation as much as AJ does. AJ's tonality changes quite a lot. Brennan's not as much. So it's interesting to see that it's still, let's ask you about everything that's not your job. Sir, there's no jury here.
You did learn.
Can we just talk about
that there was
methodology
something
again?
remarkable in Mr. O'Keefe's sweater, didn't you?
Can you be more specific?
I can. Glass shards or broken taillight plastic shards.
Well, which one?
You understand they were found
Glass or plastic?
in Mr. O'Keefe's sweater, right?
Doesn't surprise me.
Well, I know it doesn't surprise you, but the question I'm asking you is when you decided to engage in differential diagnosis and you decided to exclude collision as the cause of this abrasion, didn't you want to know all the facts and information in considering whether it was the taillight that caused the abrasion? Didn't you want to know that information?
Yes,
Okay. And when you were considering that information, did you know from the criminalistics reports that shards of that broken taillight were littered in his sweater?
Littered's a strong
I did
word.
not know that.
When's the first time you learned of that?
Right now, I
Right now.
guess.
Right now. And so when you've prepared for this case and you've received materials from the defense, nobody is.
I think he should have saved this questioning for in front of the jury, because in front of the jury, this might seem like a gotcha moment. This is going to now be prepared. But again, it doesn't change her mind about none of this is going to change her mind. So if you want it to feel like a gotcha moment, then do it at trial. But at trial, there would be an objection saying that misstates the evidence. So it's interesting that he's going down these roads that are so far afield from methodology, because that's really what the key argument is here. But he's giving her a preview of his entire cross-examination, which gives her time to prepare for it. There's nothing that says she can't review more materials based on his questions. It's not going to change the judge's ruling here, but if she testifies, she can and supplement her report.
Ever sent you,
So.
ever,
What, the defense
the
didn't give it
criminalistic
to you? It doesn't
reports
matter.
that show taillight shards were in his sweater where the abrasion was? No one ever showed you that?
I don't recall
New
seeing that at
information
all.
in that sentence.
Well, talking about being a detective and using circumstantial evidence and trace evidence,
Commentary, sir.
I want you now to consider this new evidence that you didn't know before you testified at the voir dire and the trial and the
Show
first
her.
Lincoln hearing.
Show her the report.
I want you
Demand the report.
Let's hear the question first.
Demand the report. Show me the
when
report.
you were ruling out the taillight as the mechanism of injury, when you excluded it in your differential diagnosis, and you said to a reasonable degree of medical certainty that these injuries that you looked at were caused by a dog bite. Now that you know that there's a debris field of shattered taillight right near the body of Mr. O'Keefe, and now that you know in his very sweater, where the abrasions, the same arm under them, is littered with shards of taillight from that Lexus,
Show her the report.
does that in any way change your analysis in your differential diagnosis, excluding the car as the mechanic of injury for that abrasion?
Objection, Your Honor.
So I'm going to allow that minus the police officer part, the detective part.
Minus the
No,
commentary.
it doesn't change my, my conclusion that those injuries, those abrasions were caused by a dog bite.
How do you think the shards of taillight got into his sweater?
They could have got into the sweater from an accident, correct?
From an impact with the taillight, yes?
Could be.
Right. And when the taillight breaks and there's jagged, irregular, linear, sharp edges from that break, what do you think is going to happen to the skin when those shards impact the skin?
Bruising.
They could cause injury,
They,
yes.
they could cause puncture wounds, couldn't they?
Yes, they could,
They could cause scratches, couldn't they?
but not in that configuration.
I need to ask you the question so you can answer my question.
Well,
They
she
could
did
cause
answer your
scratches,
question.
couldn't they?
They could
They
cause
could cause
scratches.
scratches.
And you have no studies on how abrasion looks after an impact with a taillight that is shattered. You don't have any studies or comparative analysis there, do you?
Treating
I have no
patients.
studies, I
with
just
car
have my
injuries.
years of experience.
Right, treating people.
You know what wasn't found for trace evidence in that sweater? DNA of a dog.
I understand that.
You know when dogs bite, saliva, foam, sweat in their mouth, correct?
I also understand that there were issues with the collection.
Well, we're going to get to your claims and see if there's any basis for it, but that's not the question I asked you, but I will invite you to talk about that in a second. Looking forward to that. What I'm asking you,
The commentary.
you know when dogs bite, they can froth at the mouth,
Yes,
sweat,
What?
probably.
yeah, saliva,
Saliva, yes.
right? And when they get active and aggressive, it increases the production of those viscous materials, doesn't it?
I believe so.
Yeah. Well, it's in some of those studies and reports and books you've studied all these years, isn't it? That that's exactly what happens?
If it's in
That
those, she should know it.
That they increase their production of
Yes.
saliva? No, I haven't seen that, but
Okay.
it makes sense.
And so when the dog
If it's in what
bites
she's
a
citing,
person,
she
if
should
they're
know
biting
it.
through material, that saliva naturally could be embedded in the material, couldn't it?
Could be, yes.
Yeah. And something like a sweater, right? It traps liquid, doesn't it? Been out in the rain in the sweater. You don't want to wear a sweater in the rain. You'd be soaking up.
Like if you're laying under the snow and then it's thrown onto the floor of an ambulance and then emergency room.
All day, right?
That makes sense,
Yeah.
yes.
I mean,
There was
Okay.
no dog DNA found anywhere on the holes in that sweater, was there?
No,
You understand that the crime lab took swabs of every one of those holes, right?
I don't know how many holes they took, but
Well,
yes.
before you
multiple.
discount or allege a conspiracy about DNA taint, wouldn't you want to
she
know
didn't
what
allege
they
a
did before you criticize them?
snark.
I know that they took swabs.
Okay. Do you know that they took swabs of every hole?
No,
Do you know that they then packaged them and they tested and they sent them to UC Davis?
I know there was an interval of time
Well,
between the,
people are exonerated.
Your Honor.
Hold it, I just need to hear the answer. Next question, please.
People are exonerated decades after they've been wrongfully convicted based on DNA. Yes?
yes,
DNA lasts for a long time sometimes, doesn't it?
it can.
Okay. And so you know that the DNA or the samples that were swabbed from the sweater was sent to UC Davis. You know that.
Yes,
And you know when they did the analysis, there was no dog DNA,
right,
right, on any of those holes.
right.
And you've opined that these are bites.
There
teeth
may have
going
been
in
bacon.
and out of those holes all the way up and down the arm.
Yes,
Yeah. Now, it is remarkable that there is no dog DNA on any of those holes in the sweater, isn't it?
Objectionable.
again, there's an issue with the collection and transportation of that.
I'd love to talk to you about that. We're going to, but you got to get through my questions first. It is remarkable as a
She's
doctor,
answering your question.
as a scientist, that there is no dog DNA in any of those swabs or holes. It's remarkable, isn't it?
Remarkable would not be the word I use.
Extraordinary.
No, I disagree.
Hard to believe.
I'm using a remarkable at the
I
moment.
disagree.
Okay. Now,
Not sponsored.
there is no
Probably should
dog
be.
DNA. Do you think somehow
it.
that hurts your cause or your case for your opinion?
Objection, Your Honor.
That's a fair
Do you
question.
think that in somehow
I like that question.
Challenges your opinion that
I
there's no
like
dog
the
DNA?
question. I hope he gets back to the question. I'm surprised the judge sustained it, actually. But the question of, doesn't this change your opinion, is a fair question. And she's held her ground well, I think, with that. There are things I'd like to see her do better, then there's things I'd like to see him do differently too. But that's what we're here to do, is give
DNA.
commentary and evaluate.
No,
Because many times you've interrupted and tried to talk about a suggested or a supposed taint that doesn't exist.
She didn't
And I'm
say
just
that.
curious, why is it so important for you to discount dog? Why is it so important for you to discount the fact that dog DNA does not exist on any of those holes?
Objection, Your Honor.
I'm going alone.
I'm aware of the many of the steps that are involved in the,
She's giving her opinion. And when he says, isn't this there? She's saying, but there's a problem. I don't think that's her interrupting.
collection, preservation.
He's gonna
and
try to make taint
transportation of
happen today.
evidence. And there
Forget
are
fetch.
multiple places where that can go wrong. So the absence of the evidence is not as remarkable as the presence of the evidence.
What training and experience do you have with regard to DNA evidence? Your answer, not very much. Does that still stand today?
Correct. I've had lectures, but, you know, I'm not a DNA person.
Not very much.
So it's not
Right.
really up to her
And so
to
now you're
decide
saying, you're suggesting,
if
without any
the
fact,
collection is an
that many
issue.
things could have gone wrong.
Absolutely, with any specimen.
Right, so you're willing to come into court and just float an idea without a good faith basis or fact?
Objection, Your
That's a
Honor.
strong allegation. Yep,
What went wrong in the collection of this DNA? What
that
went
should
wrong
have
in
been
it?
sustained.
I can't tell you what went wrong, but I can tell you that there were possibilities that, that there were errors at various steps.
Okay, well, if you want to claim and allege an error to demean or discount the evidence, tell us what the error was that happened with the production,
It's a fair
the
question.
preservation and testing of this DNA. What was it?
I can't tell you the exact error, but there's, first of all, the decedent was in the snow for a while. So it may have washed off some of
But
the
that's not
evidence.
What evidence
error.
do you have that it washed off
I don't
evidence?
have any proof, but I'm just, you asked me possibilities.
No, I didn't ask you possibility. You're raising possibilities. I'm asking you what evidence, what fact do you have that DNA was degraded or taken from that sweater because he was lying in the snow? What evidence do you have?
I don't have evidence. I'm considering different
Lady,
possibilities.
Lady
What
Witch and
about
I in the
the-
chat are on the same page. They used one swab for the whole sweater, which was also a problem for me. But this is not a problem for this expert. This is a problem for another expert. The problem is this expert hasn't said, of the reports I read, a question was raised as to this. And that's why this back and forth is happening, because she didn't simply say, I reviewed all of these reports and the report raised an issue or a question about the DNA. And so I know that that's an issue because another report raised it. So that is on my mind. So am I surprised there's no DNA? No, based on this other report. She hasn't answered that way. And this is going to make everything more difficult going forward because it probably came from conversation with the defense attorneys and not from a report. And that's the problem. She needs to have more reports if she's going to say, yes, but I didn't consider the DNA or lack of DNA an issue, because she needs to know that.
Preservation of it. What evidence do you have before you make such a claim that somehow there was an irregularity or a taint? What evidence do you have that there was something about
What report?
the accumulation of this evidence, this item that was tainted?
I didn't say, or I didn't mean to say, that there was a definite error in the process. I'm telling you that there could be. So that's why
It's
a
not
negative
shocking to
finding
her.
is not all that remarkable.
When we're in a courtroom, you know as an expert witness and as a doctor, you can't speculate. That's not a reasonable degree of medical certainty, is it?
You asked her
I'm telling
about
you, with
possibilities.
a process, just like, when blood is drawn from a patient, for instance.
This is coming from somebody who says
When it's an expert, it's not speculation, it's opinion.
they don't know very much
Me
about
being snarky.
DNA. You're floating an idea that you have no
It's a fair
factual
question
basis.
based on
I'm
her
talking
answer.
about a specimen in general.
I'm not talking about
It doesn't have to be DNA specimens. Specimens in general there can be errors in the process.
But
They
we're
can go into
talking
red
about
solo.
DNA here because you brought it up last hearing. You suggested that there was an irregularity at the last hearing.
There could
Did
be.
she?
You asked, for an explanation why DNA was not found. Well, that's a possibility.
So when you're using words like something could have gone wrong, you're not suggesting in good faith, and in fact, that you believe something went wrong, are you?
Objection, Your Honor.
No, I'm going to allow it.
No,
Are you
based on this line of
suggesting that, Dr.
questioning,
Russell?
she's allowed to.
I'm suggesting there's a possibility that something could have gone wrong.
Oh, but you can't tell us what that was.
No, there are multiple steps.
Tell me one of the steps that went wrong. Tell me anything.
No, I can't tell you definitively that anything went wrong on a particular step. I'm telling you
Then you
that there
can't
are
rely on
multiple
that.
steps where error can occur.
Not
That's
the-
all. So, and any physician even, not only scientist, but physician knows that not all test results are 100% accurate.
All right, let's wrap this up. So
Okay.
you've been through the UC Davis report.
I doubt that
Yes.
we're
You've been through
wrapping
the
this up.
Now you know there's a criminologist report and they swabbed all the holes, right? There is an absence of dog DNA. We agree about that, right?
That's what you tell me.
Right. And we also agree that you have no actual science, medicine, or fact to suggest that there was anything wrong
compound.
whatsoever with the collection, preservation, and testing of this dog DNA?
I have no evidence, that's correct.
Okay.
That was a difficult line of questioning for her.
I want to now turn to the actual exhibits and photographs and ask you some questions about the photographs and about some of the statements you've made prior about those.
Okay.
Okay?
Brennan, the fact that you didn't say, look at this photograph, is really just a missed opportunity, sir. Oh, shit. Why are we dramatically pulling out stacks of paper and banging them on the lectern?
Can I have exhibit 5, please?
He's just like, whoop, here are all of the papers. Why are we zoomed in so much? Zoom out. Look at this photograph.
You've seen this exhibit before.
Yes,
You've testified about it a number of
Obviously.
times.
yes,
And you understand this is a photograph of Mr. John O'Keefe's right arm.
yes,
You've described different abrasions on that arm on different dates in court, haven't you?
yes.
I want to start from the left to the right. And although we haven't used numbers, I'm going to characterize it as a number so we know which wound we're talking about, so that we can discuss the different statements you've made about
He's
each
going
wound.
to try to go one by one through each
The wound
scratch
closest
or
to the
puncture.
shoulder. You see that wound?
Yes,
I'm going to call that wound number 1, if you don't mind.
okay.
When you look at the wound closest to the shoulder, is it fair to say that you've given different versions or statements about what you think was the cause of that abrasion?
Not that I'm aware of.
Remember testifying in the voir dire in this case when you first came in before the trial?
Yes,
And you described that that is a pattern, saying there are 2 wounds with perhaps potentially a scratch in the middle?
yes,
Okay. And do you remember saying in that voir dire that they were consistent with teeth marks?
with teeth marks?
Yes.
I believe I do.
And do you remember when you first testified in this case at the voir dire, you said they could also possibly be consistent with nail marks?
Yes,
Okay. So when you were looking at this, and isn't this an example of no methodology in dog bite science? Because when you're looking at that, there's a very big difference between what teeth would have caused and what nails would have caused, isn't there?
no,
Oh. Teeth on a wound start with a puncture and then pull down, or the bottom teeth puncture and then pull up. Is that fair to say?
not always.
And a nail, a dog's nail is shaped kind of like a horseshoe, right? The nail. And so when it pulls, it's going to leave a very different pattern than a tooth, isn't it?
Not necessarily. It depends on how deep the contact is between the nail or the tooth and the skin.
Suffice to say, when you first testified under oath about wound number 1, you expressed uncertainty whether
She's
it
going to
was
say, like car
teeth
accident, bites are
or
dynamic
whether it was nails.
because there's
Yes.
multiple forces moving.
And so you didn't have any standard criteria to look at the wound to try to match up a comparative analysis. There's nothing specific where you would have a standard where you would say, well, this is what I would need to determine it's a nail, and this is what I'd need to determine it's a tooth. You didn't have that, did you?
There is none. And in the literature, authors have mentioned that it's very difficult to tell the difference between a claw wound and tooth mark sometimes.
When we look at wound number 1, when you originally said it was either teeth or nails, you then testified at trial, and you said the same consistent thing at trial, that this could either be teeth or it could be nails.
Would you repeat that?
Sure. After the voir dire, when you said that this wound, number 1, could have been caused by a dog's teeth or a dog's nails, you then testified a few days later at trial And you said the same thing, didn't you? That this wound could have been caused by teeth or nails.
That's not you. You don't need to
May I
check your
look?
glasses, your prescription, or your
remember?
television. That
It
is the way
sounds
it's
right.
zoomed
Okay.
in the feed.
Well, I want you to look and be sure. It is trial transcript, page 20, line 3.
This is a great question. Miss JJ in the chat said, wait, now he's an expert on dog bites. That is the job of a lawyer. The job of a lawyer is to intake as much information as possible to vigorously question the expert, and oftentimes get your own expert to explain it to you so you're on level footing. Not that you are an expert to testify in court, but that you know enough to vigorously question. Lawyers intake quite a lot of information and assimilate it into generally, or should assimilate it into good questioning.
Dr. Russell, do you have the
yes,
same transcript as us?
he's
Yes.
going to learn a lot.
Okay. When you were
we
talking
s-
about the number
We saw that to great effect, I think, in this trial the first time when Alan Jackson was cross-examining Trooper Paul. If you remember that cross-examination, Alan Jackson was getting into the deep details of physics that are way beyond my pay grade with Trooper Paul, but pointing out that they were also way beyond Trooper Paul's pay grade. And they were things that are going to come in later in trial after that cross-examination when the defense brought in the biomechanical engineers, because Alan Jackson has a deeper understanding of physics. It's why you'll see when there is an opportunity to build a team or to build a defense team, you will see different attorneys coming in for different experts, or one attorney, often this happens with tech, one attorney who knows the ins and outs of tech, and that is the only attorney that's questioning anyone regarding to anything tech, because that is what they know. So when you have the opportunity to build a team, you bring in people who know an area well. And do you want to know how knowing an area well happens in law? Often you got stuck doing a thing the one time and somebody said, do you know anything about this? And you go, yes, I know this, this, and that. And they're like, perfect, you're the expert. And then that's all you do all the time. And then you become an expert. So it ends up being one of those things where you kind of self-select down. I often was asked about tech. I did quite a lot of the tech stuff because I enjoyed it and I could simplify it. So you end up with lawyers kind of self-selecting into areas where they deal well with experts, and then you get brought into other cases to do it, and then you become the expert on the thing. It's really very much a watch one, do one, teach one type of a situation.
of patterns, you started with the upper part of the arm, you talked about the parallel lines, and you said they were inflicted by either teeth or claw marks.
Line 3?
Well, start at line 3. Teeth or claw marks is actually line 5.
Line 5 says the word photographs here.
Okay. You must have a different version than us. May I have a-
Are you talking about the trial?
I am, so you have a different copy than we do. My apology.
Yeah, you all need to be on the
29
same page. Literally need to all be on the same page. Or as they would say in South Carolina, singing from the same hymn book, which is one of the colloquialisms from South Carolina that I enjoyed.
No, I'm going to have to show her my copy. only
Lyndon,
because
yes,
there's
Lyndon
different
said I was
versions
just
of
thinking about
the
James Egan and his
transcript
medical family yesterday.
It's not going to reconcile.
What
He was
I have
great
that
at crossing
Mr. McDermott
experts.
copied on the trial transcript is what you just read from page 20, starting at line 3.
And that's what we have, but it's not the copy that Dr. Russell has. So if the court would allow me, I'll show her my transcript.
All right, I thought Mr. McDermott's copy went to Dr. Russell.
Kenzie, thank you for that. I'll take a look
Go ahead, Sherry.
later. I'm probably not going to get to that today, but I'll take a look. Thank you.
Okay. Okay.
Do we have a second copy of this trial transcript that I can give her?
Why are the transcripts different? Can somebody explain why the transcripts are different?
Here you go.
Femme fatale, yes.
Similarly said
And the
that
chat
this was caused by
regularly.
either teeth or claw.
The chat regularly talks about their experience with MVAs. So they are going to continue to fight to keep this out. We will see what the court does. But yes, it is there are lots of questions here.
Claw marks.
Who said one has the Snyder
Yes.
cut?
And so there was
This is
obvious
why I love the
uncertainty
law
by you
nerds.
whether this was teeth or claw marks when you testified at the voir dire and when you testified before the jury at the first trial.
Yes.
You told counsel, when you had your direct examination on the last case, that between the time of the trial and between your testimony at the first hearing and this Lanigan hearing, you had not reviewed any further materials.
No, I don't think I said that.
Oh, you did review
Flanagan,
further
Daubert,
materials,
same.
In the process of writing my report,
which Mr. Lisi helped you with, yes?
Objection, Your Honor.
in the process of writing my report, I did review articles. I re-reviewed the photographs.
What she's allowed to do.
And my opinion even, became a little clearer.
So when you testified in front of the first jury,
That's not what she
expressing an expert
said.
opinion, you weren't very clear?
No, I was certain that these were either teeth or claw marks.
Okay. But things have evolved, haven't they?
Yes, I have.
Oh, dear.
In the course of
Oh, he's so happy
reviewing
with that
and
answer.
also being challenged, I'm being challenged, so I need to re-review everything. Yes, things have evolved.
So things have changed.
Changed? No.
Well-
It's one of the, I said teeth or claw marks.
Well, it's not one or the other. You're supposed to testify with specificity.
That's not going to go well in trial.
Again, in the articles, in the literature, medical peer review literature, it's mentioned that it's very difficult in some sets of marks to determine what's a claw mark and what's a tooth mark.
So based on your reading of the literature that tells you it's very difficult to distinguish, you nevertheless then come into the hearing and you change your testimony and distinguish, because what you said now at the last hearing is this wasn't claw marks. Your position is that these were teeth marks, not claw marks.
I
That's-
also mentioned
that's
that
tough.
I saw some punctate wounds up here, these
That's-
two little wounds up there.
She's trying to avoid the
And that
answer, but
helped
that's
clarify.
tough.
That picture hasn't changed since you looked
Yeah.
at it before voir dire.
That's not going to go well
Perhaps
at
I
trial.
didn't see them the first time. They're very faint.
You made a mistake.
No.
dear.
Either teeth or claw marks included both of those.
So because you overlook certain things,
That's not good
your
for her.
opinion you gave to the jury was not an accurate opinion.
At the trial? Is
Yeah,
this
at the trial.
Is this the trial?
Yeah.
This is the trial. It is inaccurate. It's
Well,
either
the-
teeth or claw marks.
Well, that's not what you're saying now. Now you're saying it was teeth, not just teeth. You're saying it was canine teeth.
Yes, I believe now
Right.
that
Well, that's what
they
she
are,
said before.
more likely canine teeth.
Well, you didn't say more likely. You said to a reasonable degree of scientific certainty.
Well-
Is it more likely or is
medical.
it to a reasonable degree of scientific certainty?
Reasonable degree of medical certainty.
Is that what you're saying?
Yes,
To a reasonable degree of medical certainty, those are now dog bites.
those are, teeth marks.
These right here.
Correct.
All right, and to a reasonable degree of,
It's my opinion that to the reasonable degree of medical certainty, those are marks made by teeth.
and the teeth that you claim that these are now made are the canine teeth.
Yes, I believe so.
Well, not you believe so. I want to know if you're certain about this, a medical certainty.
Yes, to a reasonable degree of medical
Okay.
certainty, those are made by canine teeth.
Okay. And so your opinion from the time when
Is
you
it
first
those are teeth?
testified at trial, the opinions you gave to the jury, it's now different,
I don't see it as different.
okay?
And a jury may or may not.
What else did you overlook in this wound when you
But
first
it
gave your
is,
opinion
I
to the
can
jury?
see
What
why
else
he's
did
asking
you
it's
miss?
different. At trial, she said either teeth or claw marks, and she said, I have had more time, and so now I am certain it is this. But that's not necessarily going to play well, depending on how evidence comes in at trial, if this witness comes in at trial.
I don't think I missed anything. There's another abrasion in the middle.
Well, no, we're not going to move on. We're going to stay right here in one until we're done.
Excuse
staying
me. I
on
mean,
this-
there's an
feels like
abrasion
he
right
has
there in the
her.
middle.
What's that caused by?
It could be caused by one of the incisor
Well,
teeth.
when you say it could be, I want you to use science
Oh, boy.
and not just speculate. How many incisors are on the top row of a healthy dog?
6.
And the bottom?
6.
Okay. And if a dog has healthy incisors that are not irregular, that are even, you know it's not going to have one incisor leaving a scratch and the other one's leaving no mark.
No, I disagree with that. It's very possible. Skin is very elastic. And teeth are not always the exact same
Right.
height and have the exact same configuration.
And if they're irregular, one's bigger or missing or there's a gap, it could leave an irregular mark. Could.
It could.
But you don't know that. You don't know anything about the dog that is claimed to have caused this wound, do you?
I don't know about his specific teeth, no.
And do you know whether there's any irregularities in Chloe's teeth that would cause this irregular scratch by the incisor in the middle and leave out any other marks?
Even if there were no irregularities, the fact that skin is elastic and that it could mean that not all teeth made contact.
Do you know anything about Chloe's incisors on the top and whether there's any irregularities or missing incisors? Do you know?
I don't know.
Would it help you to know that?
It'd be nice to know, but
When you say
I don't
nice,
need
when you say nice, is that a medical term of yes, it would be helpful to know that?
Rude.
it could be helpful.
And so when we look at wound number 1 that you now say is a bite mark, not a scratch mark, caused by canines, how many canines do you think caused these 2 linear lines?
I believe that those are caused by 2 canine teeth.
Okay, so did the teeth start at the top and work their way down, or did they start at here and work their way up?
I can't say.
Well, wouldn't you, if you're going to say the canine teeth, wouldn't you want to look at the wound and see where the puncture starts and then where it tears from? Wouldn't you want to know that?
You know, excuse me, there is no puncture. There was no puncture in this wound.
Right. And when a dog bites, the bottom jaw with their canines grabs and anchors, and then the top pulls and tears. That's how a dog bite works, isn't it?
Sometimes, if both the upper jaw and the lower jaw actually make contact, but not always do both jaws make contact.
It's a third-prong lever, a jaw, the way it works. It traps and
Did you just
pulls.
say a third
Yes?
prong lever?
If there's contact, yes,
Right. And so
with both jaws.
most animals don't just bite with their top teeth and drag.
It happens quite a bit.
What happens with frogs, right? There's
I don't know
vernal
anything
pull
about
in the area.
frogs.
It
I'm
doesn't
sorry.
happen with dogs. Dogs bite and pull.
They try, but they don't always contact with their lower jaw.
Did you look at the underside of Mr.
Right,
O'Keefe's
'cause
arm to see if
people
there was
also
any
move away
punctures
from
or abrasions
teeth.
as an anchor that would allow the top canines to pull on this?
Y'all, I didn't think we were
And
getting to
what'd you see?
frogs.
I didn't
Not
see.
on my bingo card.
And so what would have had to happen in your version of events is that the dog would have had to not create a puncture, but just scrape with its top 2 canines and not anchor into anything else.
And that happens often.
And you can't tell whether the canine started here or started here.
That's correct, I'm not
Right.
sure.
Well, here is not a puncture, but it's a rounder wound. We're still on wound number 1. The right linear abrasion, it's wider and rounder, isn't it?
It appears to be,
Okay. And this is a little more narrow up here than it is down here.
correct.
Right? But there's no way the canines from the top mouth could have started here and worked their way down here. There's no way that could have happened, right? Because this arc would mean that the dog's mouth is backwards. The dog's mouth is backwards if it went this way.
I'm not sure I'm understanding what you're
Yep.
saying.
You see that this here, 2 teeth, if
We're
the
gonna go
dog's
through every single
canines
one.
started here and worked their way down this way, they don't line up. They're not even. It's backwards.
It would be an odd configuration. for
Well,
the-
odd it would be like
That's
Ripley's
a
Believe It or
good
Not. The
admission
dog would
for the
have to have their teeth
prosecution.
the opposite way.
No, I could see how that could happen.
Really?
Yeah.
Okay. And these 2 scratches, there is no puncture, you say. You
It's a
don't
good
know
question.
what direction it's going in. There's no anchor on the bottom. But yet, your opinion is that these are dog bites,
I believe they are, yes.
based on just simply looking at them, and you've seen something before in your experience that makes you think it looks similar.
again, based on my 30 years of experience.
But you don't have any comparative sample or any type of model where you're looking at this and matching up particular points of interest with specificity, like a fingerprint, a swirl, or a whirl. You're not looking at this and saying, well, this is endemic of a dog bite or a canine. There's nothing about this that is particular or specific.
The pattern is fairly specific. It's highly specific, actually.
This pattern here
The
can only
pattern
be
of
caused by
the whole configuration, the whole arm.
Let's start with this one, though.
Yeah,
There's
but you have
nothing-
to take things in context.
We're going to go through all of them, then we can talk about all of them in context together. Because I know what you said at the last hearing, but I'm talking about these. There's nothing about these that are particular or specific or endemic to a dog bite, is there?
If the arm only had those two
Right?
abrasions,
Uh-huh.
yes, it would be extremely difficult to say that those were dog.
Well, it's
And
not
that's
difficult. There would
fair.
be no objective evidence that it was a dog bite. It wouldn't just be
But
difficult.
there aren't just
It
those
wouldn't
two,
be
is
accurate. There's nothing
the-
about
is the
these.
thingy.
It's just dog bite. There's no puncture. The abrasions consistent here. They're different.
There's a
Objection, Your Honor.
Why?
Shouting objection adds to the overlay.
What would you like me
So
to do?
when you start to stand and say object, that's fine. Dr. Russell, you finish your answer, and
I'm
Mr.
bad?
Brennan, wait until she finishes her answer before your next question.
I'd like to see the court side.
Oh, shit. Objection, Your Honor. What would you like me to do? Oh, back to the white noise machine in the jury box. We're going to zoom past this sidebar. Oh, the attorneys are getting frustrated. Are they taking a morning recess? Did we miss it? It looks like they might be. Let's see if the court says it on the record real quick. It looks like they might be. I just want to see how long so I know how far to zoom. This is why we leave zoom room.
All rise to the court, please.
I want to see if she says how long. Nope. They're not going to say. All right. It looks like they're taking their morning break. So we're going to zoom past the morning break because we have the power of the zoom. Yay, us. All right. We'll just swoop so we can zoom. I'm going to turn this down a little bit. I'm going to answer some questions and then we'll zoom because it's a good natural spot to answer a few questions because there are lots of them in the chat and they are all very good. We will get to a few. We'll zoom. We'll get to some more in a minute. Josh said, so can dog bite evidence be used in any case? It depends on the expert. It depends on the case. It depends on the facts. And it depends on the hearings and it depends on the judge because we are going through the factors of a Daubert hearing in Massachusetts. The case that codifies that is Lanigan, but we're going through that hearing to determine if that's going to be used in this case. Oh, well, they made it easy to see when the break is by just fading to black. All right, let's see if I'm going to turn this down and zoom so we get back. Ah, you've all missed it. Here we go. Back to the only fan. Back to just the fan. Let's see. Peppermint asked, is Brennan permitted to reference this voir dire during trial? Yes, he wouldn't call it that, but yes, he's allowed to say at a hearing on this date you said this, and he's allowed to go through all of the hearings. So yes, he is absolutely allowed to use these. La Mama T said, is this deposition rules? No, but the rules are a little less strict because we are at an evidentiary hearing, not at a trial. All the snark seems a bit much for court. I think that Brennan's snark is lower than some of AJ's snark that we saw in trial, but I also think that the perception of lawyer snark will widely vary based on your perception of a witness. So for witnesses you very much like, a level of snark is not going to be as appreciated. For witnesses you don't like or you think are lying about something and they're getting nailed by questioning that you want to ask yourself, any level of snark is permissible. So this is less snark than we saw from AJ during some of the questioning at trial. But it's going to depend on the jury, and it's going to depend on how much a jury likes a witness, right? If you don't like a witness and they're just getting question after question after question, you're like, get them. But if you really like a witness, you're like, hey, back off. So the attorney needs to be able to read how a jury perceives a witness to the best of their ability, because it matters, and you treat likable witnesses differently. This is not in front of a jury, so it does not matter as much. All right, it looks like we are just getting back to court. We have zoomed adequately, so let us rejoin court. That is not unmuted just yet. The judge is on the bench. There we go. Let us resume.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. I think we had Exhibit 5, please.
And we're back to the questions.
Dr. Russell, we were talking about these 2 scratches.
I think
or
everybody needs a
abrasions
snack.
as wound 1.
I've still got
I
some.
want to continue asking some questions about wound 1. And I had asked you, now that your position is that these were caused by the canines of the dog.
All right, I've got more
was
questions,
it the upper
but I'm
or
going to get to
lower
them next time we
canines?
zoom.
I
Marta
can't
said most
tell
likely a dog, not a wolf.
100%.
Yes, probably not a wolf.
Well, not 100%. What's your opinion? Are these upper or lower canines?
I believe they're upper canines.
Okay. And why do you believe these are upper canines as opposed to lower canines?
Because when the
I didn't remember that,
mouth of
Jen.
the dog opens and attacks, it's usually the upper canines that grasp first.
Sorry for the jump scare music
And
to my
you're saying
soul.
because there's an
I was late
absence on
today.
the other side that this must be the upper canines? Is that your logic?
I'm saying because it's usually the uppers that grasp first.
There's nothing in methodology or comparative study that would tell you that these are consistent with upper canines. You're just deducing that based on there's only one pattern instead of 2?
There's nothing that makes it definitive, correct?
Well, not just definitive. There's no cues. There's no clues. There's nothing here that says to a person or even an expert that these
Notice how he
are
keeps
caused
talking about
by
methodology.
canine teeth.
Well, the other consideration is if the victim was trying to defend himself, it's the upper canines that would impact first on that surface of the arm.
What if the victim was defending himself from a 6,000-pound car? That would be a different type
I
of
don't
wound than
believe
this?
this is not caused by a car. I don't
So
believe
what
so.
evidence do you have that the
like,
victim
right,
was
yeah,
defending
no.
himself, which caused the shape of wounds?
Again, it's very common for someone who's under attack to take their arm and flex it in front of them to protect their vital organs.
Okay.
The neck, head, face.
So if Mr. O'Keefe is flexing his arm to defend himself, that doesn't answer the question, what identifying feature with specificity in these support any conclusion that it was a canine tooth that caused either of them?
Well, first, in general, it's the canine teeth that are going to impact because they are much longer than the incisor teeth.
Right. The question I have is, look at these 2 scratches here. What objective evidence do you have, based on methodology, comparative analysis, what evidence do you have that either of these were caused by a dog tooth, a canine?
Again,
Right, how do you
the
anchor
methodology
that
is that I
basis?
looked at the overall pattern of the wounds on the arm, not just
Right, you
those
can't just
2
isolate
wounds
2.
up by the shoulder, but the overall pattern.
Right.
So your testimony is, if I look at everything together, I can have an opinion. If I look at this separately, it means nothing.
If I look at it separately, I cannot be as definitive, correct?
Well, not as definitive. I'm asking you for an opinion. You don't have any evidence that this has any relation to a dog bite. Without looking at the whole arm and giving that general opinion we'll get to, you have nothing as far as facts or comparative analysis or studies that would say that this was caused by canines on a dog, do you?
It's consistent with 2 canine teeth. There's a distance between those parallel marks.
Did you measure the distance between where this begins or ends, because you don't know, and this begins or ends?
I would have loved to,
And
but
if I could just finish, I'm sorry. Did you measure the distance between this and this and this and this?
I could not measure it because there's no ruler in that picture.
You know that when a dog bites, the canines don't move. Unlike paws that might open or close, the teeth stay the same distance apart, don't they?
Correct.
There's nothing
But
that you know of in any
flesh moves.
dog science that canines, when they bite, they open or close, they get wider or more narrow. They're always the same distance, right?
With it, for that dog, yes.
People are squishy.
That dog.
Assuming that they're healthy teeth, yes,
And you don't know if they're
Fair-
healthy
that
teeth
is
or
a
not
fair
because
point.
you never looked at Chloe.
correct.
Okay.
Well, she never said it was Chloe. She said dog.
And you're not saying there's any punctures anywhere in here, are you?
I don't see a definitive puncture.
Well, do you see a puncture that's not definitive?
At the very lower aspect of the photo, this area is not well defined.
So you're saying this is possibly a puncture?
I can't rule it out by that photograph.
Well, couldn't you rule it out through other analysis and evidence? Couldn't you rule it out, as we just spoke about, because if this was the puncture, that means the bite is going this way. And
That's
if it's going
making it
this way, the arc is in the total opposite direction. Couldn't you rule it out just on that?
I couldn't rule it out, but it certainly makes sense that it would not, that the punctures would not be down below.
Well, not does it not make sense. It makes no sense that it would go this way. It wouldn't be going up if the dog has an arc going this way. The arc would have to be this way.
It depends on the position of the victim.
A dog's arc is not going to change depending on the position of a victim.
No.
And the dog's canines are not going to move depending on the position of the victim.
That's right, but if he's bending over, and depending on the position of the arm, the wound can change, the wound can have a different appearance than what you would expect.
Okay. Let's move on to number 2, which I'm identifying as these 2 linear scratches and then the scratch on the bottom. You've testified about this wound number 2, although you didn't characterize it as wound number 2, right?
Yes.
Okay. When you first testified under oath in the voir dire about wound number 2, do you remember what you said that you thought that might be?
I believe I said bites or scratches.
Teeth or claws, right?
Yeah.
Okay. Now, at trial, did you change your opinion at all about teeth or scratches?
Did
I'm
she
not
say
sure.
teeth or scratches, or
Do you
did she
think
say
you said
bites
at
or
trial
claws?
that this was not scratches, but most likely teeth?
I may have said that.
Okay. And then
Turn my
you
heater back
testified
on.
at this hearing, didn't you?
Yes.
And now definitively, you're saying this wasn't scratches at all, it was teeth.
I got a new heater for the office.
Definitively, I cannot
Prepared
say
for this
that.
winter.
They
Okay.
still could be scratches. There's a possibility that 2 adjacent nail marks made that.
So you're saying this could be nails or could be scratches? I mean, this could be nail
Bite
scratches
or-
or could be teeth?
Yes, there's a possibility that those could be scratches.
Okay. When you were asked on direct examination, that wasn't your testimony, was it?
She's saying could be teeth, could be scratches, couldn't be tail light, is
I
what she's
turned you
saying.
to page 101, line 13.
On what day?
Sorry, the last hearing date, it's the thickest of the 3. Yes, it's page 101, line 13. May I approach to help you on that?
Yes. One.
It's the thick one.
He's like the thickest of the 3. I would make a joke about which books of the series I'm reading is the thickest of the 3, but I have no idea because Audible. Oof, that flipping.
Okay.
Okay. No, that's the wrong site, so we're gonna, you got that one. At that hearing, when you last testified, did you say that teeth made those marks? You were unable to say which teeth, but it was teeth?
Yes, I believe I did.
Okay, so your position from the voir dire and from the trial testimony changed regarding this wound when you last testified at the Lanigan hearing?
I still think
She
that
said
they
it
are
clarified.
probably teeth, but I cannot 100% rule out scratch marks.
Did you say something like, I'm not sure exactly what teeth made these? They could, one of them could, one set of these could be canine, one part of this, and an adjacent incisor tooth, but I'm not sure on the second set?
Again, it goes to the fact that, the wounds are not very specific for differentiating between between teeth and claw marks. However, it's in the setting of a pattern, one can get a whole lot more information, and that is supported by the articles.
So getting back to wound number 2, when you described this for Mr. Alisi, he suggested to you, so even though you may not be able to identify the specific aspect of the dog dentition, you're able to identify this is from some aspect of dog dentition. Is that what you're saying? And you said yes. So you were saying at the last hearing, this is from dog dentition. Dog dentition is different than
Nails.
toenail marks.
Or paw marks, yeah.
So your testimony
Yeah.
that you offered the jury in this case was different regards to wound 2 than the testimony you offered the court at the first part of this hearing.
The jury?
Yeah, the jury. When you testified at trial, you said it
Right.
was claw marks or teeth.
Uh-huh.
You said at the last hearing this was dentition, teeth. So the opinion has now changed.
I think for the most, well, I'm sorry if maybe I made a mistake.
No, I don't think so. I think your opinion has changed. You said this was either claw marks or tooth marks. You weren't sure. There was uncertainty at trial. At the Lanigan hearing, when you were asked by Mr. Alisi, he asked you specifically if this was dentition, and you said it was.
Objection, Your Honor.
Okay, so ask the question differently,
Okay.
without the commentary.
You're saying now this is not scrape claw marks or toenail marks. This is by teeth, dentition.
I actually think it could be either.
Okay. Now, would you agree that is different than what you said the first time you testified at this hearing?
It sounds like it.
So you've gone back and forth kind of a little bit.
It's not a definite, it's not, in and of itself, that set of abrasions is not definitive.
Well, you didn't offer the jury the opinion that they weren't definitive or that you had confusion, did you?
I'm getting a little confused because at the jury,
Michelle, they are
you
allowed
told me
to
that I
reference the
said
first
it was
trial.
one or the other.
Right.
When it comes up in the second trial, they won't call it the first trial. They will call it a hearing on this date, a hearing on that date. But yes, this is the thing with retrials, is that everything you said in the course of the first trial and everything you said getting ready for the second trial comes up. So when we saw trials that had a lot of depositions and depositions from multiple proceedings, you saw binders and people flipping back and forth with all the different dates. We're going to see that here, from the voir dire to the trial to this hearing, and if she testifies at trial, to the trial. So it will be 4 different or 5 different hearing days that they will be going back and forth with for transcripts. But yes, they are allowed to talk about it. They aren't allowed to call it this trial. And for those of you just coming in, this is an evidentiary hearing before the retrial of Karen Reed. And there's a brief excerpt in the description, and the chat can catch you up. It is a retrial after a undecided jury on a second-degree homicide case with quite a lot of questions.
And then you changed to it was
still.
dentition, and now you're back to
The questions abound.
claws or teeth?
I think it's still teeth, but yeah, I can't rule out the claws.
And because you have no comparative standard, you don't have a standard in the industry where you can look at this and say it has 6 points of contact or 6 features of similarity. You don't have anything like that. You're simply relying on your personal empirical experience.
Yes.
Well, no, I also saw these 2 punctures, the punctate wounds right there.
Okay.
And that made me think that it was more teeth than claw marks.
This here you're describing
Yes.
as punctate?
Punctate,
Now, you
yeah.
never got the benefit of seeing Mr. O'Keefe, did you?
Personally,
Lewis,
no.
yep, I'm covering the retrial when it starts.
Did you know he was Irish? Light skin?
Makes sense with that
yeah,
name.
Freckles? Moles? Look at these. They're all
So
over
is
his
he
body. You
asking
don't
if
think the
those
dog
are
was
freckles?
puncturing up all over here, did you?
No.
Is he
Right,
asking if
so
those are
these
freckles?
the same. These little things, these skin blemishes, same as these all over the body.
Oh, you're a
think-
doctor?
Do you think that
See, it's hard because in front of a jury that doesn't play well. But for the law nerd audience, it might. She's like, oh, you're a doctor. This does not play well for an expert in front of the jury. The expert has to be above it. The lawyer can get snarky. However, we're not in front of a jury today, but she's like, oh, you're a doctor. Now, he's asking if those could be freckles.
Makes sense with that name.
freckles, moles? Look at these. They're all over
Oh
his
my
body. You don't
God,
think
I
the
had to
dog was
rewind.
puncturing up all over here, did you?
No.
Right, so these are the same. These little things, these skin blemishes, same as these all over the body.
Oh, you're a
think-
doctor?
There's no question.
Do you think that what you're describing as dog puncture wounds, you could be mistaken for just his...
The thing is, she's giving him a win by reacting because he's trying to get under her skin. And you got to kind of gray rock with this attorney because he wants her to react. And now she is giving it to him, which means he has started to get to the point where he's under her skin. He's not bothered. He wants to be under her skin. That's what he wants. So you are giving him the win. But I think it's funny. He's not going to be annoyed. He's going to lean in because he wants her to have answers that are difficult for her if she testifies in trial. So letting them know that you have ruffled them is not helpful if you're the expert.
Skin and the different
It was
types
funny,
of
though.
marks on his skin, like freckles or moles.
I don't believe so, particularly since they're right where those wounds are, the abrasions are.
Well, wouldn't the skin blemishes be there before any abrasions?
I haven't seen a picture of him before this incident.
Right, okay. So to get back to, we're now at, this is either a dog bite or it's a scratch. What is it about the top two that tell you it's a dog bite?
Would you rephrase that? Or, I mean, would
You're
you say it
saying-
again?
You're saying these are either dog bites or scratches. That's what you're saying. You're not sure which one, but it's definitely a dog. That's your position.
Yes.
Okay. What about these two are telling you that this is a dog bite?
I think I said it already previously, that they're parallel. They're parallel lines that seem to have these punctate lesions associated with them. And they're in and around the other lesions, I believe, are dog bites.
When a dog punctures and pulls, there's not an island of skin and then it goes back to the pull. The puncture starts at the pull and then it goes to the bottom, doesn't it?
There are no complete puncture wounds on this arm.
Well, you just cited puncture wound as the reason why you think this was a dog bite. You said these aren't.
She said complete.
That is
skin, these are not a skin condition, rather they're puncture wounds, and that was the basis for saying these are bites. If
No.
you don't know if these are puncture wounds or not, how can you say these are dog bite?
First of all, I did not say, with all due respect, I did not say they were puncture wounds. They are punctate lesions.
Okay. And so
They're different.
the punctate lesion, is that caused by a tooth?
Yes, I believe it is.
And you know when a dog punctures, it then tears and pulls.
Only if they penetrate the skin. They have to penetrate in order to pull,
Okay. And the
to create a laceration and pull.
and a puncture is not a penetration?
A puncture is, a punctate lesion is not.
And so what about these two linear abrasions? What science, what comparative analysis, what evidence do you have that these are caused by teeth
It's part of the pattern,
of this whole pattern?
of this whole pattern.
But just like wound number one, independently, this doesn't tell you anything. You can't give an opinion to a reasonable degree of medical certainty that this was caused by a dog standing on its own.
By itself, it's consistent with, but yes, I cannot say by itself that it's
Which I think
Caused
is
by a
fair. Because
that
And this-
lesion by
and-
itself.
the
and there's
determination is
nothing
made by
about
pattern
these
recognition. If there's no
scratches that are
pattern,
consistent with
it
the
doesn't
horseshoe
help. It's
shape
everything together.
of a nail of a dog, is there?
You mean the horseshoe shape of the jaw?
No, the
of a
dog's nail, the dog's nails,
paw nail,
toenail,
toenail?
yeah.
There's nothing specific, no.
So again, to have any real opinion to a medical degree of certainty, you need to look at everything together. You cannot look at this and tell us any specific identifying feature that would support an opinion or conclusion to a degree of medical certainty it was caused by a dog bite or a dog scratch.
Mr. Brennan, that's the way medicine is. You know, in medicine, you don't just look at one
It's
complaint
factors.
or one wound or one test and make a diagnosis. You usually need several supporting tests or other lesions to corroborate a diagnosis. So that's part of medicine.
So you would agree with my statement, what I just said?
Would you repeat it?
Of course.
He's like,
So
if I
there's
can.
nothing specific with regards to these 3 scratches in and of themselves, without looking at the entire arm. There's
She said
nothing
it's
about
consistent.
these 3 that you can say with specificity that supports an opinion that they were caused by a dog bite or a dog scratch.
I disagree. I think the combination of the punctate lesions right there and there, along with the linear parallel abrasions, supports that assessment.
Do you have any
Well, the Massachusetts just came out with the linear.
papers, any studies
Love it.
that show that a scratch like this, that would look like this, is a dog bite or a dog scratch based just on the appearance of these 3 scratches?
Regard to the wounds.
Just on the appearance, no. Usually the studies that I've read have pictures of multiple lesions, and in those pictures of multiple lesions, there may be lesions like this, individual lesions.
You can't tell, in your opinion, these are dog bites or dog scratches, so is there anything specific about them that can lead you to a reasonable conclusion, to a reasonable degree of medical certainty, that these were caused by a dog? Putting aside the whole panoply of scratches, these here, what about them is unique and distinct?
Sorry, I was just trying to move the closed captioning so it wasn't covering the photo.
I'll allow just that, because it's been called.
It's been asked and answered, is the thing.
What about them?
Like,
Okay, again, they're consistent with dog bites and scratches, and together with the overall picture of the numerous wounds, it paints a picture that makes me sure that this is from a dog attack.
Okay, I won't ask again, but I wasn't asking about the overall wounds. We're going to get to that. I was asking just about these 3.
Right.
But
And
I'll-
she's not gonna
I'll
answer
leave
it
your
that
answer
way.
as it stands. Let's
yeah,
move to
she's not
wound
going to
number
answer that
3.
way.
Now, wound number 3 really is a
He's gonna
collection of
go-
scrapes. And you
he's gonna
gave
go
some
injury by
testimony
injury.
about the first 2. So if we look at 1, 2, 3, 4, 5. So in wound 3, we have 5 larger abrasions on the top of the elbow. Do you see that?
I do.
And then you see a couple of dots down here. Yes?
Yes.
And I want to ask you some questions, and what I'll do, even though this is wound 3, I'll talk about scrape 1, 2, 3, 4, and 5, so we know what we're referring to. Is that fair?
Yes, but
Okay.
again, any one little tiny part of the image or wound is, it's not going to be sufficient to make a diagnosis. I need the pattern.
You never recognized that in your voir dire testimony or in your trial testimony before the jury, that you needed the collection of all abrasions to have an opinion. Instead, isn't it fair to say that you were talking about individual wounds as if they stood on their own?
I believe that
Objection, Your Honor.
I think that
Can
misstates.
you answer that? I'm going to allow
that
if
is
you can
unfair.
answer it.
That's incorrect.
I think
It
that
wasn't until
misstates.
Mr. Alisi directed you that you started talking about dog attack and collection of wounds as a whole.
That is incorrect.
Okay, so looking at these wounds, wound number 3, and I know it may be a series of wounds, it might not be one wound in your opinion, but let's talk about this collection of abrasions, okay? Do you remember in the voir dire talking about this collection of abrasions, and you were saying they were consistent with teeth or claw marks
At Donna, yes,
Okay.
the defense
Is
does
that
get
what you
to do a
said at the voir
redirect.
dire?
I'd have to
Whatever
look
Brennan
again.
has done.
Okay, well, why don't we look at page 38, line 13?
Mine is gone. I don't have a voir dire.
Okay, we'll have to get you one.
Yes.
Thank you.
Thank you very much. Yes, it's 48, line 13.
And that was Miss Little. No, it wasn't. That was,
What page?
I forget the prosecutor's
That
last
one's
name
not right
that
either.
handed that up.
No,
So yes, they will redirect, but the defense did get almost a whole
Okay.
day of questioning this witness. So the court's going to allow the prosecution a fair bit of time.
let me withdraw that
The
question.
court set apart the entirety of today to do this.
Did you testify previously that these are consistent with teeth or claw marks?
Did I testify when?
Previously?
Possibly, yes.
Okay. And do you have a different opinion today whether these are teeth or claw marks?
No.
So you think that these could either be teeth or claw marks?
I think they're more likely teeth marks,
Which one of these 5 do you think are teeth marks?
all of them.
You think all 3 are teeth marks? Do you think a dog bit Mr. O'Keefe and inflicted these at the same time or different times?
I believe that this was this configuration, this collection right
Yes.
here.
Yeah.
I believe this is one bite.
One bite. And so if we were to follow your theory, this was one bite, this would be the arc of the dog's mouth?
Yes, it could be.
Well, is there an arc here?
Well,
There appears to
skin
be.
is dynamic.
And we know that when a dog punctures it, then from the top teeth pulls down, the bottom pulls up, right?
Push it,
So if this is the arc of the dog right here, and it's like a half of a sun or a half moon over the elbow, you claim these
I
2
want-
dots are consistent
me.
with puncture wounds?
no, punctate lesions.
Oh, punctate lesions, I'm sorry. Which teeth, upper or lower teeth, do you think caused these 5?
I believe those were the upper teeth.
So you believe this is a canine on the left, number 1, and a canine on the right, number 5?
It could be.
Okay. Now, if here's the arc of the dog's mouth, and this is a canine on 1 and 5, where do the canines puncture and pull? Up or down?
I'm sorry, say that again?
Where do the canine teeth puncture? From the bottom or from the top?
So if these are, let me use my,
So what he's
Mark,
saying, or what he's trying to say, is that the tooth would go in if the arm is up and is 90 degrees towards the dog. He's trying to say that the bites would go from the top down, and she's saying right. But if those look like punctures towards the elbow, why are they going from the elbow back towards the arm instead of from the arm and down away? So that's where this questioning is going.
my pointer here. If these are canines, and this could, by the way, be this also could be 2 separate bites, but if these are canines, they usually would start on the, based on this picture, the upper or higher area and
Right.
pull down.
Right. They would have to start up and pull down if that was
Mari
a arc of
HK
the
said
mouth,
we don't
wouldn't
know
it?
how he was positioned.
But you see the
I'm going off of what this doctor testified to based on her hypothesis. So no, we don't know, but this doctor said that was her opinion of how he was positioned. So I'm going with that because that is what we are here to see today. So we are here to see if that makes sense and if she'll be allowed to testify to it. But that's what she said happened. And it is her job to put this is how these things happened. That's what she's being offered for. So her job is not here to say it could be this, it could be that. Her job is to say, this is what it is, and this is how it happened. So that's why while we're talking about her testimony, using her explanation.
the bottom of these wounds, right? The round part that is closer to a puncture is on the bottom. Aren't they going in the wrong direction?
And that's what
if
he's
this is
getting
the
at.
arc of the mouth?
No, I don't think that they are going in the wrong direction.
I see what
You
he's
have
saying.
to keep in mind that presumably Mr. O'Keefe was not standing there and letting the dog just chew on his arm.
Jonathan, this
Okay,
is an
that
evidence hearing.
How do you know
relative
that?
This is exactly an evidence hearing. That is what this is. This is
How
an
do you know
evidence
that?
hearing.
No, but she's not finishing her answer, Your Honor.
The questions allowed.
How do you know what he was doing?
Because it's normal human behavior that if you're,
How do you know what he was doing? How do you know what Mr. O'Keefe was doing that night?
again, it's normal human behavior to pull away from someone that's attacking you, a person or an animal. That's normal human behavior. If he was still throughout this whole attack, I would be looking for a different set of wounds.
You're speculating about all of these comments about what he was doing and not doing. You have no idea. what
She's
he was
giving an
doing.
opinion.
Do you?
I'm just being,
Objection, Your Honor.
The question, wait,
I
Can you answer
expect
that
the judge
question,
to
Doctor?
allow quite a lot of questions
basing
in.
it
This
on
is an
normal
evidentiary
human
hearing.
behavior.
I would want her to allow in just about everything,
And so,
except the most
you would
egregious
disagree with me
questions.
that if these were dog bites, the part that's thicker, that is more similar, although not a puncture, would start at the bottom and work up, meaning the dog's head was over here on the top. You disagree with me about that?
Do I disagree?
Yes.
Yeah, I believe that that's
Okay.
incorrect.
Okay. And if these are canines, did you measure the distance between the canines?
Again, there's no ruler, but the other thing is we don't know what position his elbow was in at the time of this. So
Precisely. They don't
so
know
it
the
could
precise
be,
position.
although it looks like it's a larger, you know, a
Mm-hmm.
larger configuration than a normal canine distance, intercanine distance. That's what you're referring to, the intercanine distance. If his arm was flexed, that distance would be shorter. So you cannot make any assessment based on this picture.
Do you notice the differences between the left mark and the right mark are a greater distance than wound number 1, where you said that it was 2 canines that caused these linear abrasions?
And there's no elbow between the linear abrasions of wound collection number 1. There's no elbow up here to be flexed.
Let me ask again, do you notice the difference between these two? It is wider than the difference between wound number 1 when you said it was 2 canines.
You mean this mark here
Can we
versus
go
this
back
mark
to the
here?
photo
Is
that they're
what you're
talking about? Because this mark here and this mark here is really
Wound one
hard.
On wound 3, number 1, number 5.
Without seeing it, thank
You
you.
said these could be canines. Do you notice the distance is different than the distance where you claim that wound 1 was caused by 2 canines? Do you notice the difference in distance?
Again, I'm not clear what you're asking me. Are you asking me the distance between this tooth and that tooth? That's I think what you're asking me is the intercanine distance. Is that what you're asking me about?
Intercanine distance, I've never heard that word.
Well,
Is that a new one?
No, that's what you're asking
well known in the medical literature.
Let's just look at simple
That's
math
what you're
or
asking
size.
about.
The distance between these 2 wounds
Skin moves.
is a greater
Humans
distance
are squishy.
than where you said it was canines in wound number 1, isn't it?
Again, I believe I just explained it, that if the elbow was flexed at the time that the wound was inflicted, or the bite was inflicted, you would get these 2 wounds that are closer to one another than they appear here, because the arm is partially extended here, and skin moves.
Skin moves.
Are you saying this is a full bite, puncture wound
He's
top
saying
and
it's
bottom?
dynamic, sir.
Excuse me?
Are you saying this was a full bite of puncture wounds, bottom canines, top canines? Are you saying this is a full bite?
I don't believe this is not a full bite. There is no significant penetration of the skin. So this is not a full bite or a complete bite.
Did you say at trial, at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial round small abrasions, again representing upper and lower teeth, in my opinion. Was that your opinion at trial, that this represented upper and lower teeth?
Yes.
And these lower teeth, what teeth were these?
What teeth?
Yeah.
I don't know.
Were they the
Wait, which
canines?
ones does
Could
she
be
say
a
are lower
canine, could be
teeth?
incisors.
Can we go back to the picture?
There we go.
Which
Thank
one
you.
is she saying are lower teeth?
And so your opinion at trial is these 4 could all be canines?
Which 4?
1, 2, and then the 2 punctures, or punctate.
That is a possibility. It is actually, and I think I said this too, that this could actually be a configuration of 2 separate bites. Where you have canine puncture wound, punctate lesion from the, so upper canines, lower canines. And then this could be a separate one. Just can't tell. There's not enough specificity in this configuration of wounds.
And you have nothing to compare it to either.
No?
Do you see the distance is different between
I
what you
can't,
said is a 4 set?
because you keep
upper
focusing
and
on the
lower
defendant's
canine,
face
this
and
one
not
here,
the
this canine?
evidence
Do
that
you
we're
see the
talking
obvious
about.
difference?
With-
Can we go
with
back
all
to
due
the
respect,
evidence?
Mr. Brennan, again, the elbow moves, so the skin moves. The skin overlying the elbow moves, and we don't know the configuration that this arm was in at the time those wounds were inflicted. You cannot make a generalization.
I'm going to ask you one more time, you don't have to answer. Do you see the obvious distance between wound 1 and 3 where you say that it was the canines? Do you see that?
Objection, Your Honor.
So I'm going to strike the part that says you don't need to answer. Can you answer that question, please, Doctor? And then we'll move on, Mr. Brennan.
Yes, Mr. Brennan, we'll move on.
I see the difference, but I understand the difference.
Okay. If these were canine wounds, they can't be claw wounds, right?
Yes.
What?
And based on your knowledge and study and whatever you're relying on, you have no way of telling if this is canines or a claw.
Not 100%, correct.
Not even 100%. You don't have an opinion to a reasonable degree of medical certainty whether it's canines or claws, do you?
I believe those are canines.
Did you testify at the Lanigan hearing when Mr. Alisi was asking you questions? Did you observe any claw marks with regard to the injuries, and you said it's possible?
Possible, yes.
How can you give an opinion to a reasonable degree of medical certainty it was canines, and in the same breath and statement say, well, it's possibly claw wounds as well?
Objection, Your Honor.
That is a fair question.
My
Yeah.
opinion about
He thinks
reasonable
it
degree of medical
misstates-
certainty is about the
he thinks it
whole
misstates her
arm,
opinion.
the configuration, the pattern of the whole arm, and not any one individual wound.
Okay. Wound 4 up here. What do you think
We've
this
been in
might
court
be?
so long, I'm getting wiggly.
I don't know. I'm not certain.
Well, I mean, in the totality of a dog attack, it has to be something related to a dog because we don't know that it was there before. Had to have been something. Right?
It's probably related to the dog, yes.
Well, you don't think he just had this independent
That's not
wound,
going to be helpful.
and then all these came from the dog attack, and this one just happened to be hanging out waiting for them?
That's correct. I don't
Right.
think that he had a separate
I appreciate the
You
zoom
don't think this
zoom.
one maybe was caused by the broken
But
shards of glass from
it's
the
not in
taillight
focus,
during an alleged
unfortunately.
collision, but the
No.
other ones were from something totally different? Do you?
No, because it has an orientation about it. It's oriented, again, in a somewhat vertical orientation, similar to many of these other sets of wounds.
I don't know what that means. It has a vertical orientation. How does that help us understand if this wound existed before or after the so-called dog attack?
It has some similarity of pattern.
So you think this was caused during the alleged dog attack?
Yes,
Okay. What caused this wound during the alleged dog attack?
I don't know.
Is that because there's no methodology or comparative standards, so you can't compare it to anything?
No, because there's not enough specificity in that one particular
Right,
wound
those are
all by
much more
itself.
superficial.
What are the options?
It
How
looks
could it have
like-
been caused during this dog attack?
But we're not really
By
in
the-
focus.
By a tooth or
Okay.
or claw.
The focus
most
isn't
likely.
you.
Could have been caused by the ground?
I doubt it, considering that, again, it's oriented in a similar fashion to the rest of the lesions.
Okay. When you read the background facts of this case, well, let me ask you,
What background
If a dog
text did
attacks
you
an arm,
read?
it's going to create force on the arm, wouldn't it?
It depends on how much penetration. Yes, it depends on how strong the bite is, how much penetration, it gets through the clothing, clothing that's on, on the intervening, between the arm and the dog is going to present a little bit of a buffer.
Well, let's talk about the force on the arm. If this was a dog attack, as you claim, that means the teeth and/or the claws penetrated that sweater and caused an abrasion on Mr. O'Keefe's arm, correct?
Yes.
So there had to be an amount of force pulling on the arm to create that friction, which led to the abrasion. Yes?
Yes.
Okay. Did you know from any of the facts that you reviewed that when Mr. O'Keefe supposedly left the car, he had a glass in his hand with a straw in the glass?
I'm
The
aware
what
that there
now?
was a glass in his hand.
And you're aware when he was found by the side of the road that glass, the broken part of the glass, was right near him with the straw?
I don't know anything about the straw, but yes, I.
And so if there's a dog attack and somebody's holding a glass, right, they're not likely to continue to hold on to the glass throughout the duration of the attack and then move somewhere else with that glass.
I don't know if he was holding on to the glass during the dog attack.
Well, hypothetically, assume that the evidence is he supposedly was holding the glass. Wouldn't a dog attack rip that out of his hand? Wouldn't he drop the glass?
There are many possibilities here. He could have transferred it to the other hand.
Let's look at wound number 5. Do you remember testifying about this?
Yes,
And you said it looks like an arch?
it does to
Okay.
me.
Are you saying the arch is on the top or on the bottom?
No, I thought the arch was on the bottom. But by bottom, I mean the what we call proximal part of the arm. So here, right here is where I think the arch is.
And if this is an arch and these are dog bites, these would be the canines.
They could be,
She
however.
has said she doesn't want to give an opinion about these and is now giving an opinion about these, which is not going to go well
Because
for
of
her.
the curvature of the arm, I can't rule out that this was from a canine and incisor teeth.
Well, this is a different angle than here, right? But there's no flexion like in the elbow on this wound area. This is the bottom of the wrist, right?
That's correct. However, that part of the arm has a different configuration than the upper arm. And it's got it's got a bone right underneath it.
So you're
The
saying...
ulnar bone.
I'm sorry, I didn't mean to interrupt you.
She said the ulnar
Oh,
bone.
it's got the ulnar bone. So a wound to that area is going to look different than a similarly placed or caused wound to this area, which has a lot of padding underneath it from the soft tissue, subcutaneous tissue, and doesn't have the protuberance of this bone right here.
We have a distance problem when we compare these, don't we?
We have a what?
A distance problem. The distances are different. If these are canines, obviously it's a different dog or something else that caused it because the distances are clearly different, right?
Again, one has to know how wounds occur, and I
That's what
didn't
you're
say
here
that
for,
those
though.
are definitely 2 canine teeth on the periphery. I'm saying that I believe that this is a combination of canine and incisor teeth.
When a dog bites and tears, you see a missing tear pattern, don't you? You see the skin gets torn on many occasions?
That's not what
Yes,
happened.
but we don't have any of that here. We have no penetrating wounds here.
Right? Is it remarkable to you that if this was a dog bite with canines, there is no tearing of the skin? Is that remarkable to you?
No, because that dog was not able to create the force enough to penetrate the skin through that sweater.
Could I have Exhibit 32, please?
I don't know what photo they're putting up. Ah, the avulsion. Great.
Okay.
So-
You've seen this picture before?
Yes.
The,
Okay.
the picture they are putting up is a picture of the healing wound from a prior injury from the person who was bitten by Chloe, the dog that had lived at 34 Fairview when this happened. So the photo that they're putting up now is from that, which they obtained after the last trial, it seems. So that's what's going up on the screen now.
And this is allegedly is a dog bite from Chloe?
Yes.
And you see the tearing of the skin, don't you?
Yes.
And you can see the
Right.
corners where
But
the
different.
incisors would penetrate through a puncture. Yes?
I'm not sure what
are
what
incisors?
teeth punctured this, but yes.
And
I see
this-
the skin is all penetrated.
This is consistent with the literature of a tear and a hold and a pull, right?
No.
Okay.
No, absolutely not.
This is not consistent with the dog biting and then pulling the skin.
This is consistent with an avulsion wound caused by a dog.
Okay. Very different wound than we looked at on Mr. O'Keefe's arm.
Yes.
On,
Mr. O'Keefe's arm, very different, right?
correct.
Yes.
Okay. If we can go back to 5, please. Now, your opinion that this is a dog attack. Have you ever had peer review of this opinion with this photograph?
No.
Well, you would agree that this dog bite science is what they call a soft science. Would you agree with that?
I don't know what you mean by that.
Okay, well, it's not like DNA. It's opinion-based, it's subjective-based, the science of dog bites, isn't it?
It's based on a lot of training.
Yeah, and a lot of subjective opinion, too, wouldn't you say?
There's opinion here,
Experience.
yes.
Uncertainty,
There is some, yes.
right. And being that type of science, haven't you read in the studies about peer review, how peer review works?
What specifically are you,
That you have another qualified professional look at it and
Peer
question
review is one of the factors that the court
and
has to
vet
consider
whatever
here.
opinions you're giving. Did you go through that process at all?
I've been through that process, yes.
You've been, okay, and who peer reviewed
You
your
mean
findings?
this case?
Yes.
Oh, no, not this case. No, I thought that this information was rather confidential, and I didn't share this
Okay. No.
information.
Well,
You would never peer
discussed
review
with the
expert
defense,
testimony
other
for a
information
trial.
in this case, didn't you? About the
no.
accident and about people's opinions. You've discussed that as part of your opinion, haven't you?
Yes?
Okay. Did you know that the U.S. Attorney's Office employed a deputy medical examiner to look at these bites? And then he had commented that the wounds are 2 to 3 millimeters, up to 7 centimeters, were documented on Mr. O'Keefe's right arm, and the injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the
Really?
result of an animal bite attack. Did
That's
you get
new
that
information.
expert opinion from the United States Attorney's Office when they investigated this case to consider as part of peer review?
Objection, Your Honor.
I
That's new information. And the new information is that the U.S. attorney had someone look at whether or not these were bites, and the feds expert said they did not believe that they were. But the feds experts also said that they didn't believe it was a car accident. That is new information that we did not hear in the last trial. So I wonder if we're going to see the DA in this case also bring in some of the experts from the U.S. attorney investigation here, because that, again, new information to us.
Did not get that, but,
Did you say you did get that?
no, I did not get that.
Oh,
However,
okay.
I have a comment about that.
Please.
Not very not very many medical examiners have the experience that first of all, have experience with dog bites, seeing hundreds and thousands of dog bites and treating them. And not very many medical examiners have even autopsied a case of dog bites. So although, some physicians have certain opinions based on,
Oh, it's gonna be a battle of the
based on
experts.
what they know. They don't have my experience. I'm
Do
sorry.
you know if Mr. Walsh has your experience or not?
I don't know, who
The
is it?
gentleman who gave this opinion that was employed by the federal government, do you know if he had your experience or not?
What's his name?
Mr. Walsh,
No,
John
no.
Walsh.
No, I don't.
So he could have more experience for all you know.
Oh, I'm highly unlikely.
Okay, you have more experience than anybody in the country.
She didn't say that. She said it's unlikely.
I think I have at least as much experience as any other possible person in the country. And I have it from both aspects, from the clinical aspect and from the forensic aspect.
She has
Did you
very
review the
unique,
opinion of Dr. Kenneth Kinsey, who said that those injuries were not caused by a canine?
she has
Dr.
very
who?
unique experience.
Kenneth Kinsey.
Kenny Kenzie.
No.
Wait,
If you look, I believe Mr.
why are we having a South Carolina crossover today? What did Kenny Kenzie have to say? I'm backing us right up. Okay. So now we've got multiple so much new information today. All right. We just backed up. What is Kenny Kenzie going to say? Because was he consulted in this case, or I wonder if he gave a media interview in this case, but let's see what he had to say. Kenny Kenzie is from the Murdaugh case. I'm so
I think I have
curious.
at least as much experience as any other possible person in the country. And I have it from both aspects, from the clinical aspect and from the forensic aspect.
Did you review the opinion of Dr. Kenneth Kinsey, who said that those injuries were not caused by a canine?
Dr. Who?
Kenneth Kinsey.
No.
No. If you look, I believe Mr. O'Keefe's arm were
When did
completely
he say
bent and he
that?
sustained the injuries. A lot of them match up. They're a continuation of another injury.
And I don't even know who Dr. Kinsey is.
Okay.
Is
We
that
do.
a medical doctor?
So you don't have any peer
We
review at
know-
all? You have
we
nobody
know who
who's
Kenny
given an
Kenzie
opinion
is.
similar to yours about this being dog bites, do you?
Is Dr. I'm sorry.
You have no peer review. You have no peer endorsement. Everything
Kenny
that you...
Kenzie does accident reconstruction.
You have no peer endorsement for any of your opinions, do you?
I didn't think I was allowed to show these pictures to anyone.
Why would she? She doesn't need to show it to anyone. He's trying to trip her up. I want
When
them
you're
to
giving opinions about...
motion to call Kenny Kenzie as an expert witness in this trial too. I'm ready. And apparently the FBI doc, but Kenny Kenzie does accident reconstruction. So it's different than treating physician work. So those are different things.
about the teeth and suggesting that there's might be bend, things you don't really know about. You would agree it would be best to look at the dog, Chloe itself, right?
Not necessary.
If you looked at Chloe and examined Chloe,
I want to hear from the
you would
FBI
know
expert.
whether or not there are any irregularities in Chloe's teeth, wouldn't you?
Yes, I might.
Might, you would see it, wouldn't you?
Well, if I got close enough, and
Right.
I don't know if I want to get close enough to Chloe.
Well, why wouldn't you want to? You're a medical doctor. You want to have an opinion to a degree
Sir,
of medical certainty. Why
this is
wouldn't you
a
want to
silly
see the best
question.
evidence of the distance between the teeth and Chloe? Why wouldn't you?
I'd have to make sure that I wasn't putting myself in danger.
Okay. And if you saw Chloe,
like,
you
"I
could
don't
see if there
trust
was
that
any
dog."
missing teeth, couldn't you?
Yes.
You could actually measure the canines in Chloe, and then you could compare them to what you're calling dog
The
wounds
thing
on.
that's so interesting about this is even if she did, a lot of that wouldn't be allowed in. So it's a whole different thing. The defense is just going to let the prosecution ask whatever they're going to ask so they have a heads up of what's going to happen at trial.
Mr. O'Keefe's arm. You could do that, couldn't you?
I would have to get a veterinarian
Mm-hmm.
to sedate the patient, the dog, because going near that dog would be
That
very
dog's
dangerous.
Bitey.
They'd have to sedate
Which I saw Runkle say
the
in the
dog
chat.
to measure the intercanine distance.
What if you did get a veterinarian to sedate the dog? And then you could safely go and look at Chloe, and you could actually take a mold of Chloe's mouth, right? Mm-hmm. Yes? You've read that in the literature. The best way to...
one could.
I'm sorry.
Yes.
You've read in the
Thank
literature
you,
the
Your
best
Honor.
way to compare
They're not trying to
the teeth
identify
and
the
mark
dog.
is you actually do a mold of the dog's mouth. You know how valuable that can be in analysis, don't you?
It can be, but the question, I believe the question here is not
Was it
which
Chloe?
dog created these
It was
wounds.
exactly.
but
Did a dog create the
these
wounds?
That's
exactly.
not my question. My question
But that's
is,
the question
if
that she
you
was
took a
asked.
mold of Chloe's mouth, you would see the distance between the canines, and you could measure it, quantify it.
Humans
not
are still
guess and speculate.
squishy.
Quantify it, correct?
Your Honor, could we approach, please?
Okay.
Thank you.
Humans are still squishy. All right, we're gonna zoom past this sidebar and see.
If there's any missing,
Oh,
take
I
a
zoomed too far. All right.
All right, so you can continue. Mr.
With the
Brennan.
Thank you, Your
tedium.
Honor.
I'm more interested about the AUSA, the U.S. Attorney's Office witness now. I got a lot more questions about that.
Dr. Russell, when you're examining these separate wounds and the distances and the depths between them, and guessing whether or not it was a canine or incisor, wouldn't you agree it would be helpful if you had a safe opportunity to actually examine the dog Chloe?
It could be.
If you had a safe opportunity to examine Chloe, you could look at the size of Chloe's jaw.
It could be, but those wounds on
We're trying to determine dog
shaking your
versus
head. That's not my question.
vehicle, not dog versus dog.
My question is, if you had an opportunity to go safely and look at Chloe, you would be able to tell the size of Chloe's jaw. You could measure it.
possibly, yes.
You could determine the gape of Chloe's jaw, couldn't you?
I don't know what the gape of
How it bites, how wide it opens up.
I'm not sure I could determine that.
Okay, you
That
could look
would
at
be
Chloe's
really
teeth.
hard to tell with
As
the
they
dog
are
under
now, yes.
sedation.
You could measure the distance between the canines if they still exist in Chloe's mouth.
She said
Yes,
as they are now.
From a model of, or imprint from Chloe's mouth.
You could take a mold,
Right, a mold.
or you could take a tape measure or a ruler, and you could measure. You could
Oh,
do
that
both.
wouldn't be very reliable.
I see. You could determine whether or not she had one incisor, or whether she had 2, 3, 4, or 5, or 6 incisors.
Currently, yes, but I can't tell what the
Incisors?
condition of the teeth were during the incident.
Uh-huh. You could tell if there's any missing teeth.
I guess we're going with incisors.
Correct.
Right. You could
not a
look
Malinois,
at Chloe's
sir.
paws, couldn't you?
Yes.
You
Yes,
could do
one can
moldings of
look at a
those and measure
dog.
those as well, couldn't you?
I'm not sure that that would be useful.
Well,
Measuring
if you think that some of these
Yes, we're going to get back to
wounds
scissor
could have been
hands and
scratches,
scissor
you
teeth.
could look at the nails and the shape of the nails, couldn't you?
Well, nails are frequently cut on a regular
course.
basis, and the distance between the distance between the nails, as you mentioned earlier, can change depending on whether or not the paw
God,
is
boy, okay.
in a compressed state or a more relaxed state. So that wouldn't be reliable.
So you would not even consider measuring the paws because
She
you
just
think
said
that
that's
would be
not reliable.
reliable?
I don't think it would be reliable, no.
You wouldn't study the toenails to see the shape of them?
If I could, I'd look to see if there's an abnormal toenail,
Right.
for
right.
instance. Yes.
And so there would be a benefit to doing that. You didn't do that, though, did you? You didn't go see Chloe and take a mold of Chloe's mouth, did you?
Where is Chloe?
It wasn't necessary.
Well, did you go up and take pictures and measure the teeth of Chloe?
No,
Did you ask to?
no. It was my understanding that Chloe was in another state.
And was
But
unavailable.
again, I didn't think it was necessary, and I have reasons why I didn't think it was necessary.
You thought that Chloe was in another state. Did you ever discuss going to see Chloe and doing these studies on Chloe so you could see if they were dissimilar to these abrasions?
I was asked to evaluate the wounds.
Right.
Do you know that Chloe exists, that we provided
her
notice
job.
to you, that we went up and saw Chloe and took molds? Did you know that?
What?
Did you know that? I'm going to allow it. Did you know that, Doctor?
I do know that now.
Did you know that before you testified the last date in this case?
What? Wait, what? Wait. What? So this is going to be such a different trial when this goes to retrial. So now the prosecution is saying that they went to visit Chloe and took molds. Well, who was there when that was done to verify that it was Chloe? And apparently this was done since this prosecutor has come into the case. So I'm going to back up the questioning a little bit. Well, that's interesting. All right. Let's continue to see what else we have learned so many new things in this hearing. This is why we watch the hearings in between the trials, because look at how much we've learned.
These abrasions?
Huh.
I was asked to evaluate the wounds.
Do you know that Chloe exists, that we provided notice to you, that we went up and saw Chloe and took molds? Did you know that?
Objection, Your Honor.
Did you know that? I'm going to allow it. Did you know that, Doctor?
I do know that now, yes.
Did you know that before you testified the last date in this case, that we actually went up and found Chloe and took molds and measured the paws and the teeth? Did you know that we did that?
I don't know, I don't recall.
Before you came in and testified at the last hearing,
Wait, you don't
recall
know
whether
that?
you knew that Chloe was
Ma'am.
available?
I believe I knew that there was a consultant, that you hired a consultant, and I didn't know what that consultant was going to be doing.
Okay. Now that you know that Chloe's available,
Have you turned that over?
wouldn't those molds be helpful? Wouldn't you want to look at them and compare them to the distances on the abrasions on Mr. O'Keefe's arm?
Objection, Your Honor.
I'm going to allow it.
I don't think it's necessary, for many reasons.
Well,
If the
if you have it,
distance of Chloe's canines is significantly different than these abrasions in this picture, you would agree that the abrasions in Mr. O'Keefe's arm could not have been caused by Chloe.
oh, she's not going to
Would
agree
you
to
agree?
that.
No, I wouldn't agree to that statement.
Because humans squish.
Again, because of the various factors such as elasticity of the skin, shrinkage, there's various factors.
Y'all, she said she knew that had been done. So no, the defense isn't jumping up and down and losing their mind. I see the chat being like, wait, what? This is new information for us in this hearing, but the defense is not saying this was never provided. Outrage, Your Honor. The defense isn't saying that. She said, I knew that had been done. I knew that you had hired someone. The prosecution just has to turn it over when they get it. So if they get it too late, the court can keep it out of it coming in for trial, but none of the defense said, we don't know. When you get a new DA into a case, it's not unusual that you're going to have new investigation happening between. So if this was turned over, which it seems that it was, because A, the defense isn't losing their minds, and B, the witness said, I'm aware that this was happening, it's not a problem. So we will see where we go from this. This is
So-
new for us.
If I understand, you have no interest in examining or seeing Chloe. It's irrelevant to your opinion?
Oh, he's done.
I don't think I need to see Chloe.
He said it was a
You
dog,
said
not a
earlier,
car.
when I asked you about particular wounds, it would be helpful to know these things about missing teeth and spacing and distance between the canines.
And now you don't want to know.
Is that no longer helpful to your
Good
opinion?
question.
No, I think you're mischaracterizing what I said. I
was
believe
a good
I said
question.
that it would give information about the condition of the teeth now, but it wouldn't give information about the condition of the teeth when that incident happened,
In the spirit of medicine and science, isn't more information good,
generally.
generally? But you generally would not want to go see and examine Chloe.
I don't think it's necessary, and there's so many reasons why.
Okay. Thank you for your time.
She's saying it's not necessary because you asked me to say if this was a car or if this was a dog. And I'm saying this was not a car, it was a dog. That's what she's saying. So we're going to get into her explaining because we're going to get into redirect, but that is interesting new information. So what did we learn real quick? Let's do a real quick.
What if? No.
Wrong button. Wrong button. What did we learn so far in this hearing that is new information to us? One, that the U.S. Attorney's Office that is investigating this case with the FBI did have an expert, though it seems that maybe it was a pathologist, evaluate the injuries to John O'Keefe's arm, and that expert's opinion was that those were not caused by a dog. Then we learn that the prosecution is watching apparently media or commentary about this case, which doesn't surprise me. And then we learned that the prosecution had a consultant go see Chloe, measure Chloe's paws, take a mold of Chloe's mouth, that they went and visited Chloe, and that this expert found out about it sometime between the last trial and now. Whether it was before the last hearing in December or not, we don't know. It's very, very interesting what we've learned. I'm interested to see where redirect examination by the defense goes. Very interesting.
All right, Mr. Lessie, go right ahead.
This retrial is going to be a lot of new information. So we are now going to redirect with the defense attorney, Mr. Alessi. Interesting. And
Sure.
again, when the expert says this information would be helpful and then says, nah, I don't really need it, it'll be interesting to see
Make sure I have the right, thank you, Mr. Brennan.
her explanation.
For the record, we have pre-marked number 3337.
Thank you.
In Your Honor, and thank you, Mr. Sullivan, I have provided the court and offered to counsel, but counsel already had the copies, a notebook that has exhibit numbers.
Thank you.
You're welcome. Mr. Brennan has agreed that all the exhibits in the notebook can be in evidence. So that's number 2.
Okay, great.
And so if I'm remembering correctly, Your Honor's previous direction, that if they're in evidence, just refer
So
to
much
them as
new
such. So that's what I
information.
plan on doing.
Yes.
And what I also plan on doing, Your Honor, is taking the exhibits that are in the notebook. I've got non-binder ones individually for the witness that are
Okay.
pre-marked. Does that work also?
Sure, you can just put them up on the stand with Dr. Russell.
In my approach to do that?
Sure.
This is going to be very interesting. So for all of you asking about the dog, it's not up for question today about whether the molds they took were Chloe, not Chloe. None of that's up for question today. If they're going to use it as evidence, would they have to prove it? Yes, they would have to prove it. But that's not the question for today.
May I
So
talk to the witness
it would help
and
if the
just
dog was
find out where
microchipped,
they are?
but we'll see.
I think you can give them to her. I think
Okay,
she can
that's-
figure out
okay.
numerically what's what.
But again, this expert is saying, my job was to say car or dog. I say dog.
Mr. Leslie, I'm not rushing you at all, but is it safe to say that you won't finish in 20 minutes?
That is safe, Your Honor.
Okay, so we will plan on breaking at 1. Mr. Clerk will have to cancel our afternoon list. What,
You said,
how long do you think it might
Your
take?
Honor, I was reviewing my notes from the last hearing yesterday, and the court said that she was setting aside the entire day for this today. So, as they're saying, we need to cancel our afternoon, I thought that had already been done because we know that this is going to take all day.
And I'm not holding you to
So-
this, just curious.
I appreciate the question. If I can just have a quick moment, because I knew what my redirect was going to be until Mr. Brennan went, and I'd like to consider what he did.
So Mr. Brennan started doing all kinds of shit. So now we got some questions because
My best
Brennan,
estimate is approximately 2 hours.
Okay, I'd like us to finish by 4 today.
Yes, Your Honor, understood.
Mr. Brennan, I know you have no idea how long recross might be, but we'll try and finish by 4 today.
great, great. 2 full days. It's so much. I think this might be the longest Daubert hearing I have ever seen. Which just lets you know how important they think it is to this case, right? Yeah, Samaray said, the defense did not jump up in shock. It leads me to believe they knew and had this information. Absolutely. The defense would have had literally the mind-blown emoji if they had never heard that Chloe had been visited. And I don't think that this prosecutor has been hiding the ball with this defense team. It seems that the prosecutor has kept them in the loop with the things that they are doing. That has come up in court in other hearings. It's new from the last trial, but I don't think they are trying to surprise the defense with any of this. They can't do that. I don't think they're hiding the ball. We've not seen any of that happening with this new prosecution team, with the new investigation that they're doing. Everybody asked for more time, for more investigation, and told the court how much additional investigation was going on. So a lot is happening, which also makes retrials difficult, right? Because the defense has put on their entire case, and now the prosecution's like, oh, we can look into this, we can look into that, and we can look into this other thing. So the defense attorneys don't seem shocked. I'm shocked he brought it up in
And I'll
court. That
proceed.
surprises me.
Thank you. Dr. Russell, during cross-examination at this Daubert hearing,
Now she gets to
on
answer
December
all the
12th,
things.
you were asked whether you believed you were an expert in the areas of orthopedics, accident reconstruction, biomechanics, motor vehicle accidents, and defensive wounds. In
Yes,
your
she was.
In your 29-plus years of experience as an emergency medicine physician and training emergency medicine physicians, are you aware of any emergency room or emergency department physician being board certified in orthopedics?
No,
Are you aware of any emergency medicine physician being required to be an expert in overall orthopedics?
no. General orthopedics, no.
But do emergency medicine physicians nonetheless routinely evaluate and treat people injured in motor vehicle accidents?
Yes,
And did you, in your 29 years of experience as emergency medicine physician, routinely evaluate and treat people injured in motor vehicle accidents?
yes, I worked at a busy level 1 trauma center.
She worked at a very busy level 1 trauma center. Accurate.
During your cross-examination in response to a question, you stated that you were an expert in emergency orthopedics. Can you please explain that?
Yes, so emergency orthopedics is a subset or just a part of the overall field of general orthopedics. So in emergency orthopedics, physicians care for, evaluate, diagnose, treat patients who have acute injuries and that don't need operative care. So acute fractures, acute dislocations, those types of injuries are done in many busy emergency rooms, right in the emergency
You
room.
have
And
to
that's
know
I
what
have
to
an
diagnose
expertise
and
in.
how to triage.
Did the rotation at the, you just said busy hospital that you were at, did the rotation when you were training?
For those of you that
did
are local to California, she was
Were
at
you
County
required to
USC.
take a part of the training in emergency orthopedics?
I was required to take a 1-month rotation in orthopedics.
Now, you were asked during cross-examination at this voir dire about one particular specialized training that you had involving motor vehicle accidents, and
When she was
you,
in law enforcement.
in response to a question from Mr. Brennan, agreed that that particular course was rudimentary. Do you recall that?
Yes.
When did you take that course that you referred to as rudimentary?
It was around 1979.
And what profession did you have when you took this rudimentary course that you were asked about?
I was a police officer at that time.
And since
I mean, Emily,
that
Jackson
one
does live in Los
rudimentary
Angeles.
course
So
that you
it is sunny
had,
often.
have you had further training with regard and experience to humans injured in motor vehicle accidents?
Yes, much.
And describe the much that experience and training you've had in that area.
Well, during my 29 years working in the emergency department, we saw motor vehicle accident victims on every shift. And usually there were multiple victims on every shift. So that was part of it. Plus we had lectures and seminars on motor vehicle accidents and victims.
And is your focus in your testimony, both in June of this year and in December of this year, on wounds from motor vehicle accidents or how motor vehicle accidents occur?
So as a physician, My focus is on the wounds and injuries caused by motor vehicle accidents and how to diagnose and treat them.
So, are you sitting as a medical doctor giving opinions on medical causation of the injuries to Mr. O'Keefe?
Yes.
During cross-examination, in this hearing, you were asked about whether you were an expert in accident reconstruction. Is being an expert in accident reconstruction necessary
Right.
to practice emergency medicine?
And is it
No.
necessary for your
Does
opinion
an
in this case?
emergency medicine physician need to be an expert in accident reconstruction to evaluate and treat people injured in motor vehicle accidents in the emergency department?
No.
In your 29 years experience as an emergency medicine physician and training emergency medicine physicians, are you aware of any emergency medicine physician being an expert in accident reconstruction?
No.
Is accident reconstruction even relevant to the practice of emergency medicine?
No.
Right.
Is whether an emergency medicine physician and expert in accident reconstruction a reasoned question in the field of emergency medicine?
No.
During
Zing.
cross-examination in this hearing, you were also asked about whether you have a degree in biomechanics. In your 29
They've
years
got the
experience as an
biomechanics
emergency
people
medicine physician
is the
and
thing.
training emergency medicine physicians, are you aware of any emergency medicine physician who is an expert in biomechanics?
I mean, I'm sure
No.
it's happened. I'm sure
Is being an
someone
expert
has
in
gone from
biomechanics necessary
being
to practice
an emergency doctor
medicine?
into
No.
biomechanical. I'm sure someone
Is
somewhere.
whether an emergency medicine physician is an expert in the field of biomechanics a reasoned
not-
question in the
I love that
field of emergency
phrasing.
medicine?
It's not necessary. And that's what he's getting at. The court doesn't need all of this. The court's like, I know. Like this, some of this is for the audience, not for the court, because the court's like, I know. She doesn't need to be an expert in all of these things. The prosecution is trying to say, right, but if she's trying to say dog bite versus vehicle, then doesn't she need to know all of this? And they're redirecting to, no, but you don't though.
No.
In your 29 years of experience as a medical doctor, where do most people go for the treatment of acute injuries from motor vehicle accidents?
Well, often to the hospital.
To the emergency department.
Do you know, or have you had any experience where a person who has an acute injury from a motor vehicle accident goes to an expert in biomechanics?
No.
Do you know whether anybody who's injured in a motor vehicle accident, acute injury, goes to an expert in accident reconstruction?
No.
On cross in this hearing, you were asked about your expertise in, quote, self-defense. Was your direct testimony in this hearing in your report
Excuse me.
of December 9 about self-defense or defensive wounds?
Would you repeat that question?
Sure.
I know the
Was your
answer.
direct testimony in
She
this
should know the
hearing
answer too.
in December
She's like,
and
"No,
the report that
we
you
know.
prepared dated December 9th,
I know.
was that about self-defense or defensive wounds?
My testimony was about defensive wounds, not
Right.
not self-defense.
What's the difference between self-defense and defensive wounds?
Well, I believe self-defense is something like martial arts and the study and techniques of defending oneself from an attack.
Versus
That's
a
what I believe
response.
self-defense is.
You were also asked on cross in this hearing about whether not observing how a wound to the posterior side of a forearm occurred provided you with sufficient context to determine whether a wound was a defensive wound. What context did you have with regard to
Excuse
the
me.
wounds on the right arm of the decedent to reach your conclusion that those wounds were defensive wounds?
Well, the context is the configuration, the location of the wounds. The location of the wounds and, the presence of a dog.
In the cross in this hearing, you've been asked whether you have observed how wounds are created. In your experience, do emergency physicians or forensic pathologists get to observe how wounds are created?
No.
Do emergency medicine physicians and forensic pathologists nonetheless often reach medical diagnostic conclusions
Right, 'cause they have
without
to.
observing how the wounds are created?
Yes, they do.
And is that a common or uncommon practice for emergency medicine physicians?
Well, that's common.
How common?
Well, I think it's fairly common.
You were also asked whether someone could, and this is on cross in this hearing, whether someone could incur wounds to the posterior side of the forearm if they fall to the ground backwards. Did the wounds to the right arm of the decedent in this case arise from him falling to the ground backwards?
Not in her opinion.
Why not?
Because of the configuration and the pattern of the wounds.
And do you come to that conclusion to a reasonable degree of medical certainty?
Yes.
You were also asked on cross in this hearing about when someone hits a moving or a floating object, whether the patterns are dynamic and changing all the time, and the hitting concept. Can you please explain the question that was posed to you about moving, floating objects and hitting objects and how you evaluated those issues with respect to the decedent in this case?
I'm sorry, Jack, I don't understand the question.
I'm sorry, what?
Doctor, did you understand the question?
Not exactly.
Okay, ask
What?
the question differently.
None of us understood that question.
On cross, you were asked about when someone hits a moving or floating object, whether the patterns are dynamic or change. Can you please explain those concepts in that question and how you analyze them with regard to the wounds of the decedent in this case?
Okay. When there is movement and there is contact, there is movement of the, for lack of a better word, inflicting object, such as a tooth or something else. There is movement along the skin during the period of time in which they are in contact. That's what I understood that I was being asked.
On cross-examination, you were
That was a
asked
rough line of questioning in
several
that it's
questions
difficult
about pattern
to understand what the question
recognition
is.
and pattern recognition methodology. And you were asked about the development, that's what I want to start with, of your pattern recognition skills with regard to dog-inflicted wounds. How did you develop your pattern recognition skills with regard to dog-inflicted wounds on humans?
Well, as I testified earlier, I've seen many, many, many dog bite victims.
Yes.
And sometimes I was able to talk to, I closely examined their wounds. And not only examined, but evaluated, treated. But in many cases, I was also able to talk to them and ask them about how the wounds were inflicted.
Right.
And I did this over and over and over again, hundreds of times. I think I testified to about at least 500 times over the years. So as you do that, you learn. You know, you recognize, you get sharper. So that's how I did.
And did you also edit any peer-reviewed publications that
did all
were
of this
relevant
on
to
direct.
pattern recognition and pattern recognition methodology?
Yes, I did. Now, pattern recognition in general, first of all, pattern recognition in general is a really important feature of medicine. It's critical. It's so important. And we start learning pattern recognition from medical school, from the beginning of medical school, learning how to recognize patterns of cells in pap smears and biopsies, patterns of cells. That's all. That's what a lot of pathology is, pattern recognition. And so, and even radiologists use pattern recognition
Right.
when they look at X-rays of pneumonia, for instance. Different pneumonias have different patterns. So pattern recognition is something that I've been doing since beginning of medical school, and actually a little bit before medical school. So that was 50
You
years
have to look
ago.
at it.
Oh, I think. 40 years ago. 40
Pattern
years ago.
recognition some
We
novel
forgive, ma'am. I get it.
or unscientific process, or is it rooted in evidence-based medical science?
Oh, it's definitely evidence-based medical science. And in fact, there are textbooks on how to recognize certain patterns. So there, for instance, in pathology and, in
This
medicine,
gets to
there are textbooks on how to,
methodology.
how
Oh,
to
we're getting to
tell
lunch
if somebody's
too, I
got
think.
liver cancer or somebody's got, some other disease. This is pattern recognition for the most part. And X-rays too. It's in textbooks. There are huge textbooks and numerous textbooks written about this.
Is pattern recognition methodology that you've been testifying about, is that generally accepted in the medical community?
Pattern recognition as a methodology? Absolutely.
All right, Mr. Alessi, we're going to take our
Lunch.
break. We'll be back at 2 o'clock.
Thank you.
All rise for the court, please.
And that's where we're stopping for the lunch break. Pattern recognition. All right, let's give a quick discussion of what we're here talking about. We'll zoom through the lunch break because court should actually be coming back shortly for lunch. Let me make sure that this is muted. Court should be coming back pretty shortly from lunch. I am going to take a brief break. Court is not back yet from lunch, but I will take a brief break just so I can grab some food and go to the restroom, but it will be brief. But let's just do a quick refresher on what we are here talking about today. And then we will all take like 15 minutes, restroom, hydrate, snacky snacks, and come back. They're going to probably go another 2 hours, 2.5 hours today when we get back. So it is going to be a full court day. I know there have been other things going on in this case today. The chat has let me know there's been other filings. Am I going to go over them today? No. Will we go over them soon? Yes. Either in stream or in quick bits. We will. Don't worry. We will get to it. Not today, though. We're doing this hearing today and just following this train of thought. Let's talk about what this hearing is for anybody new, either to my coverage or to the case. Hi and welcome, new law nerds. Good to see you. Let's talk. We are back in court today, January 7th, for the second part of a Daubert hearing with regard to the defense dog bite expert, Dr. Russell, in the Karen Reed case. This is leading up to her retrial that is supposed to start in April. That had been pushed back. It was supposed to start later in January, and the continuance requested by both sides was granted. Yes, new evidence can come in the retrial. Yes, evidence can be kept out that came in at the first trial in the retrial. And that is why we are doing a full 2-day hearing about whether this expert will be allowed to testify and what she will be allowed to testify to, what the scope of the testimony will be. For a Daubert hearing, they are evaluating the factors under the rules of evidence to determine whether or not this is proper expert witness testimony. The factors of expert witness testimony are that the expert has scientific, technical, or other specialized knowledge that will help the trier of fact understand the evidence. Is this something that the jury might not understand without someone who knows more than they do to come in and explain it to them? I think that has been met here, but we will see. 2, the testimony is based on sufficient facts or data. Is it supported by the evidence? This can't be something just out of thin air. 3, the testimony is the product of reliable principles and methods. That is the prong that the prosecution's really been focused on in their questioning. And 4, the expert has reliably applied the principles and methods to the facts of the case. I think this expert is an expert. Does this doctor have scientific, technical, or specialized knowledge? Yes. Will it assist the trier of fact? The court gets to decide that, and said yes in the last trial. So what the focus has been from the prosecution is this testimony the product of reliable principles and methods? And that's why we are seeing the evaluation of whether or not the pattern recognition utilized by Dr. Russell with all of her experience is sufficient to allow her to testify that the wounds to John O'Keefe are caused by a dog, not a vehicle. That is what the testimony is being proffered. Not just that they are consistent with dog wounds, but the defense wants this expert to be allowed to testify that this is from a dog, not a vehicle, which goes a bit further than what she was allowed to testify to in the first trial, which was that in her opinion, those injuries were consistent with an animal attack, with dog attack and dog claw and teeth marks. So this is what the court is trying to evaluate, and that is why the prosecution keeps asking about methodologies and peer review and going through whether or not that's reliable. And that comes from, and the way that's evaluated comes from in Massachusetts, that Lanigan case. So you will hear Brennan call it a Lanigan hearing. I call it a Daubert hearing. It is, different states have different case laws, but same. So in the Lanigan case, the court determined that the fundamental requirement was, quote, if the process or theory underlying an expert's opinion lacks reliability, that opinion should not reach the trier of fact. So is the way that this expert is determining what the injuries are caused by or not caused by, is the underlying process reliable? If you have questions about process reliability, the dude who was throwing the phone around in his office during Murdaugh, is that a reliable, scientific, repeatable methodology to determine if a phone is thrown out a window, would the screen go on or not? I have questions about that. The coroner also in Murdaugh that was like, well, I put my hands in the armpits. Is this our current reliable testimony? I didn't love armpit coroner either. So are those reliable in the way that we see reliability elsewhere? And again, scientific reliability does change throughout the law. Things that used to be allowed in aren't, things that weren't allowed in are, so that can change. But it's going to have to go beyond that an expert is trained. It has to go beyond that an expert has some level of training in an area. It has to go to whether or not there is general acceptance in the relevant community of the theory and process on which the expert's testimony is based. So you've got information that we need to go through, and then there are factors in that analysis that the court has to consider. Those factors that the court is going to have to consider in this case are whether the scientific theory or process, and that is now not dog bite, connecting this dog made this bite, but saying this is from a dog bite, whether the scientific theory or process has been generally accepted in the relevant scientific community, has been or can be subject to testing, has been subject to peer review and publication, has been, does not have a unacceptably high potential rate of error or high known rate of error, and is governed by recognized standards. So when you hear the questions that Brennan is asking, his questions are going specifically to those factors that the court has to determine. And those are not exclusive, but the court has to go through those factors and determine whether or not the methodology used to determine how these injuries were caused is reliable. So that is the purpose of the hearing today. So when it feels like the prosecution is just going in to try to keep this witness out, that's exactly what they're doing. That is their job in this case, is to evaluate the witnesses and see if the witnesses are using reliable scientific principles to bring that in front of a jury. And the judge's function in this hearing is to act as a gatekeeper. That is the language from the case law. It is the judge's job to determine if the expert comes in and what the scope of the expert testimony is allowed to be. And I imagine that the prosecution is going to do this with multiple experts. Now, will we see the defense doing this too? Maybe. It depends on who the prosecution's experts are going to be. The prosecution has their own witness issues, from Trooper Paul to everything that is still going on with the lead investigator of this case, and more will be. We will talk more about that on a different day, not today. So that's what the court's trying to decide. Will the court decide this today? No, the court's not going to decide this today. This is going to be a written ruling whenever the court gets back to it sometime before April. But no, this is not going to be decided today. This will be decided in a written ruling down the road. Do I think we will have more of these hearings? Probably. Today, it was filed, and this is what I'm gathering from chat. I have not gone and looked and read filings, but the prosecution is filing with regard to the biomechanical experts that testified at the last trial. I'm sure they're going to bring them in again. I wouldn't be surprised. We're going to see more of these hearings. This is a case that relies a lot on scientific information for the defense theory of the case. The prosecution will see what their case relies on when it comes back to trial, because they're going to have some new experts, aren't they? So we are going to give ourselves a little zoom room. I'm going to go grab snacks and more water and use the restroom. We are going to give 15 minutes. So what time is it? It's like 1:10. So 1:25 Central Time. 15 minutes from now, we will be back. We will put up our court break screen. If you have the Law Nerd app and you've recently updated your phone, make sure that you double check your notification settings. We will send you out a notification when I am back. 15 minutes, go get yourself, hydrate. We got about 2 more hours of court. I need to stand up and stretch. I need to get some more food, and I will see you back in about 15 minutes. So Law Nerds, thank you for being here. Thank you for being a Law Nerd. Let's get some music on and let's go to break. See you soon. All right, let's add this. I need to add me. There we go. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. All right, Law Nerds. Oh, I can't hear myself at all. There we go. Hey, everybody. That's the wrong one. Let's all go back to court together, shall we? For those of you just peeking in and are like, what are we doing? We're watching the extended version of a Daubert hearing, which is a hearing regarding expert witnesses and if and what their testimony will be at trial ahead of a trial. We are in the thick of it with this one. We are now a day and a half into this hearing, and we are on redirect. Remember, this is a prosecution motion to exclude the defense expert. So the defense does direct examination, the defense does redirect, the prosecution does cross and recross. We are in redirect. I expect we'll see some recross. The judge isn't going to rule today. There are factors the judge has to consider regarding the scientific sufficiency of the process used by the expert to tell the jury a thing or to help the jury with a thing. And again, there's lots of ways this can go because the defense can always decide that the tactic they're going to take at trial is not, hey, this is our alternate theory. The defense can do this trial just on a, yeah, prove it defense. You say this happened. Yeah, prove it. How did this happen? None of the experts say this happened. Even the state's witnesses don't have a clear theory. So instead of shifting focus on did things happen the way the defense said they did, the defense can always shift the focus back to did things happen the way the prosecution said they did, and whether or not the prosecution can prove their case and pare it down. That is going to be decided between them and their client. I think they want to keep all doors open, and they have the right to do so. But they could lean into this wasn't a car, because even the coroner for the prosecution is like, I mean, there are things we would expect to see with a car accident that we don't see here. So I think they have a lot of options depending on what the judge does here. It will inform their path forward as a defense team, but they can do things differently this time if they want to. So let's go back to talking about this expert and whether or not John O'Keefe's arm was injured by a car or a dog and what this expert will testify to. Let me know what you are hydrating with this afternoon. I have water, of course, but I also have some tea because I can keep it warm at my desk. Merry Christmas to me. So we've got some tea. Also, I'm obsessed with this color green. I'm obsessed. Will my nails be that color green next time? Probably will be. Probably will be. So let us all head back to court. Court's just coming back from recess for lunch. We gave ourselves a little bit of zoom room, but we are not as far behind as we were this morning. So let us roll, everybody. Good to see you. Doctor Who said, go for the hair being, oh, I have this muted. Go for the hair being that color green. No, we need to get back to purple. Right now it is like a purple. It is like a LaCroix of purple. Or a LaCroix of purple. It is a hint of purple. We need to get back to like more purple, but I don't mind the hint of purple. So the sage green, yes, I absolutely love it. Hear ye, hear ye. We are back. Oh, noses.
Go right ahead, Mr. Lissy.
Nosing.
Thank you, Your Honor. Welcome back, Dr. Russell.
I love it so much.
We left off talking about
I undermeant what you
pattern
stood.
recognition
I
and
might
your
need to
pattern
change my car
recognition
color too.
methodology.
I'm obsessed.
Are there patterns to dog-inflicted wounds from civilian
like I
dogs?
Emily, we're back to court. We're pausing immediately. Like I said before the break, when I was talking about the methodology, that's really what the focus of the prosecution attack is here, the methodology and whether or not it meets the legal definition of methodology. And so we're going to see the defense also trying to tie that up and explain it to the court clearly, a methodology. And some processes are easier to explain than others. Think of anything you do regularly in your life and how you would break that down if it is a repeatable thing and how you would explain it, because it can be difficult.
Yes.
What are the patterns?
Law and Amber,
Oh,
no
there are
one knows where
several-
you live,
several
depending on what time
patterns.
zone you're in. It's never too early.
You know, there could be just simple abrasions.
There's no
and
judgment here.
abrasions. There can be.
We listen and we don't judge.
Depending on the depth of the.
And unless we're watching court,
of
then
the,
sometimes we judge.
Injury, you know, there can be what they call the hole and tear pattern if the teeth penetrated through the skin. There can be a variety of patterns, including parallel lines and others.
Is there support in the medical literature for these patterns and your pattern recognition methodology?
Yes.
Can you name the authors of any peer-reviewed
This is one of those factors that we talked
studies
about.
supporting the patterns and pattern methodology?
Yes, so the two come to mind right now, and one is written by Demunic, Demunic and et al. And there's another one with Dr. Pollock et al.
And to help our stellar stenographer, Demunic is
Can we spell those?
D-E-M-U-N-N-Y-N-C-K.
Good job, counsel.
If you could please turn to exhibit number 30.
I wonder if he practices in federal court quite a lot too.
Yes.
Let me know when you have that
I have it.
exhibit.
Trophy
have
wife
it.
and I are on the same page. I listen, my face
Do you
judges.
is this the Demunic peer-reviewed article
I didn't know
you
that.
were just referring to?
Yes.
What I'd like you to
great
do,
color.
Dr. Russell, is to point out where in this article there is the rooting of the pattern and pattern methodology, recognition methodology that you've been testifying to. Where is it located? And with the court's permission, I'd like you
Showing
to read
the court.
specific sentences and paragraphs where that methodology is rooted in it.
Tell us first, because if it's a whole page.
The
It's
judge
not
is
a
like,
whole
can we
page.
not?
Let's just see
Yeah.
where it is.
Okay.
Yes, my face also has subtitles. But again,
Okay.
that's why we're here doing
On
this.
page 298.
That's why we do this.
The second paragraph on the left-hand side.
I know, I just wish they would focus on who's speaking. I agree
Your
with
Honor,
you,
may
Chad.
it's not going to be reading a whole page, it's just the portions of this. Is that acceptable
So
to
you
the
can read a
court?
portion of that paragraph, Doctor? Because what you're trying to do is convince me, right? And these are
Understood.
in evidence, so. Could you tell me where it is, please?
The court's like, just point it out to me, I'll read it.
Left-hand
Right,
left-hand
first
column.
paragraph, second paragraph. Where do
Second
you
paragraph.
start?
So it's part of the second, the third, and the fourth parts. So it says, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the
1010
lower jaw.
pronunciation of maxillofacial.
Usually, the mandibular
Doesn't
dental
come up
arch
in
is
court much.
narrower and shorter than the maxillar, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed.
Dr. B will be thrilled that
And then if you can skip
maxillofacial
to the
was
next
mentioned in court today.
paragraph,
It might
because
make up for the
we want to follow the
incisors.
court's direction not to read everything,
Right.
just trying to focus on the key aspects. Is there something in the next paragraph that also supports it?
Okay, yes. Okay, the the above features attribute to the characteristics of dog bites.
Can you tell us what that sentence means? And does that sentence have any relation to the concept of pattern recognition?
Yes, it does.
Explain
I
how.
heard one of my favorite sounds outside.
Okay. Well, so
If you
they're
guessed the
talking,
UPS
first
truck,
of all,
you would
the
be correct.
previous paragraph was talking about the dentition of the dogs and how there's some variation in the dentition. And then this next sentence says the above features attribute to or relate to or are relevant to the characteristics of what the dog bites would look like.
And then as you continue on in that paragraph, again, not reading every sentence, but is there another part of the paragraph that continues over on to the next page that also supports your testimony that this is talking about pattern recognition methodology?
Yes. So it goes on to say that the puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretch lacerations in the process of biting, shaking, and tearing. This
Okay.
should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to each other, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals which are not accompanied by pulling and shaking, nor by the usage of the prominent canines, and with stab wounds caused by sharp instruments.
Does what you just read establish the pattern and the pattern recognition methodology for dog bites?
There's a number of grounds.
The objection sustained asked the question differently.
What do you conclude from the language you just read with regard to patterns and pattern recognition methodology?
Well, I conclude that patterns are important, and they are what I call highly representative, but they call pathognomonic, meaning that there is nothing else that causes those.
Let's focus on the word, people pronounce it differently,
Yeah.
pathognomonic. What does pathognomonic mean in medicine?
Pathognomonic, to me, I believe it means that you can make a diagnosis based on these factors that are present to the exclusion of any other diagnosis because they are so specific.
So we talked about
Specificity is
on your direct,
good.
and it was raised on cross, the concept of a differential diagnosis, right?
Yes. Yes.
When you have pathognomonic features, is it required to even have a differential diagnosis?
Not really,
Why?
because the pathognomonic features mean that you have the entity or the condition that is explained.
Does pathognomonic mean that the features themselves rule out other possibilities?
Yes, that's what I believe it means.
And is that how you interpret what the author is saying in this article?
Yes.
Please proceed lastly
Please explain.
to the next 2 paragraphs, and then we can move on to the next study, I believe.
In conclusion, to identify a lesion as a dog bite wound, it should have ragged and irregular wound edges, show multiple parallel linear scratches or drying scuff
So
abrasions.
she's going through the peer review to
include a
meet
puncture
those
wound
elements
and
that the court has
sometimes
to
an
find.
avulsion
Notice
with
that the court
irregular
is taking
borders
notes
resembling
and
a
highlighting
dental
along with it.
arch print.
And could you please, as the last paragraph will focus on, read what you
Could
consider
they have
important
relied
in
on the
next
court reading
paragraph?
this herself because they attached it? Yes.
The shape
Are they going to do that after giving 2 days for a hearing? No. They're going to do it all on the stand.
of dog bite wounds depends on the size and breed of the dog and will differ whether or not the full dentition was used to produce them.
Let's stop there. What does it
Whether or
mean
not
to
the full
you
dentition.
when the author says, and will differ whether or not the full dentition was used to produce them?
It means
So
different.
what that means is that if the bite does not include the full, well, let me back up. What it means is the appearance
Here's
of
where
the bite
here's where I
will-
feel for this expert so much is there are times where you can tell, or at least I can tell, maybe everybody can't tell, but I can tell because it happens to me, that her brain is moving faster than she's able to explain and is trying to make sure that she's explaining at a court level and not at a doctor level. And I appreciate her for that because you can see her being like, okay, bring it down a sec.
will vary depending on whether or not all of the teeth impacted the skin or just some of the teeth impacted the skin.
Please read the next sentence.
Only in ideal
read the next
circumstances will a complete impression of all frontal teeth be found, and often only a prominent canine impression can be seen.
Is what you just read relevant
Can you
at
explain that
all
to us?
to what you analyzed with regard to the wounds of the decedent in this case?
Very relevant.
How?
I bet so.
Because many of those wounds on Mr. O'Keefe's arm were only partial bites. They did not have the complete dentition.
Do you recall Mr. Brennan saying various times that you have no support for your pattern recognition methodology?
Yes,
Is this support for your pattern recognition methodology?
yes,
Is it direct support for the pattern recognition methodology you have applied in this case?
yes.
Is there another article, you mentioned two, you mentioned Demunic and Pollock, so let's turn to, and Your Honor, this will be the second and last article.
Okay.
Please turn to Exhibit 34.
Okay. Yellow
And is
Daisy,
this the
right now
Pollock,
this is one of the defense
P-O-L-L-A-K,
team.
study that you have mentioned multiple times in your testimony and that's in your report.
Yes,
Please, like we just did with the Demunic article, please identify the portions of this study that support, you've testified, support your pattern recognition methodology.
okay.
And let's
Let's
do
start
a
at the beginning.
seriatim from the beginning.
Yeah,
Yes,
I'll do it
please.
from the beginning. So, the dog's front, so the first paragraph here.
Okay, the summary?
Yeah, this says summary, yes, summary. In the absence of her parents, a girl of 4 months was killed by a 2-year-old male Rottweiler dog belonging to the same family. The dog's front teeth marks of individual circular or scratch-like abrasions, as well as slit-like skin severances of the skin, okay, arranged in
She's
curved
like,
lines.
it's not the best sentence.
There seems to be a word or two missing.
No, you missed a word. That's
I
all.
did.
That's
Yes.
okay, go ahead.
Okay. The pattern of skin lesions largely corresponded to the anatomy of the dog's set of teeth.
Let's stop there. How does the sentence you just read, what's the key component of that sentence that supports your pattern recognition methodology?
That sentence, the pattern of skin lesions.
Now, let's go down to the keywords. Is there anything in the keywords that supports and roots your opinion that you've given several times that there's in dog bite wounds?
She's definitely
and
given her
humans, there's a
opinion several
pattern?
times.
Yes, so there's about five or so keywords. One of them is injury pattern.
Why is there a section in many medical studies of key words?
So when you're researching, you can find the articles quickly.
And is there any importance to the use of key words when there is a study published?
Well, yes, because it's a key concept of the paper.
Please proceed to and I know it may take a little bit of time and with the court's permission, to the next section of this article that supports your opinion that there is a pattern to dog bite wounds on humans and that there's a pattern recognition methodology used to discern them.
Well, I think the next significant section would be 3.2,
And what is the title of that section?
Morphology of dog bite injuries.
What does morphology mean in the medical community?
Basically means form.
And could it mean something in addition to form?
Form, pattern, appearance, yes.
So with regard to morphology section, please identify the sections, the parts
just gonna
of the
break
article
down the
under this
anatomy of
section
a
that you
medical journal
believe
article.
that you have concluded support your opinion of both the existence of patterns and a pattern recognition methodology with respect to dog-inflicted wounds.
Well, I go to the second paragraph.
Please read that.
Okay. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors also leave an impression, smaller skin lesions, round pressure marks, or streaky glide marks can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly. A gap in the injury pattern can have several causes: oblique biting, curvature of the body surface, interposition of textiles.
What does that mean? I'm going to stop you. What is
He wants to talk about interposition of textiles.
in layperson speak, and how, if at all, is that relevant to this case?
It's clothing overlying the area that was bitten.
And was there clothing overlying the bite mark wounds of the decedent?
Yes.
And what clothing specifically was that?
It was a hoodie-type sweater.
Please continue reading.
Okay, interposition of textiles, different tooth lengths, tooth loss, form and positional anomalies of the teeth.
And keep reading, please.
Right, all kinds of things. We're just going to read it all in. They're not letting the court read it. They're just like,
On the next page,
read
the
it.
spectrum of possible injury forms is extremely diverse. Depending on the type and intensity of local tissue damage, skin contusions with epithelial loss, linear abrasions, tears and/or crush wounds, as well as puncture-like lesions can be distinguished.
Thank you. So, do these studies directly or indirectly support your opinions in this case that there's both a pattern to dog bite wounds on humans and that there is a pattern recognition methodology to discern them?
They do.
And is it
And
direct
that-
or indirect support these studies?
He is saying
I believe
these
this is
go
direct.
And do you
to
believe it's
the fact that this is a
robust,
accepted
these
methodology.
studies, or do you believe there's equivocation with regard to pathognomonic features?
Tina,
No,
it
I
is
think it's
redundant.
robust. And
It's
these
important,
articles are
but
cited
it's redundant.
elsewhere.
And are these articles, particularly the Demunic article, is the citation ubiquitous in the medical literature, or is it sporadic? Are there a lot of citations to Demunic in the medical literature, or are there only a few?
There were quite a few.
Is this
And do you recall
counsel?
the book that Mr. Brennan
Is this well accepted within the community?
showed to you earlier on in the hearing?
Yes.
Does that book cite to DeMunich as support for a section in the book?
It does.
Everything cites back to the thing.
Now, there was
Because
confusion.
the thing makes sense. They're like, good, we've got a
We can
thing.
put those
That's the
studies to
thing.
the side for
It is a
now, Dr.
cornerstone
Russell. Thank you.
thingy thing. I'm gonna stand up in
Now,
a
there
minute.
was some
The new standy
confusion
desk.
on cross-examination regarding where these articles could be found. Some were looking for them in your CV. I'm sorry, Mr. Brennan.
All right, so I'll strike that part of it. Just go ahead without commentary and just ask the question, please.
Yes.
Redirect.
Sure, I will, Your Honor.
He was,
Where are the references, well, are the references to these articles
could've
in
let
your
that go.
CV, or are the references to these articles in your report?
In my report.
During cross-examination, it was stated that you, quote, suggested that you came to your pattern recognition skills because of communication difficulties or because people couldn't share with you or report to you the cause of the wound. Is that an
Should we-
accurate
should we
statement
try out this
about how you developed your
desk
pattern
stand-in for the
recognition
first time?
skills?
I don't know where that statement comes from.
I'm happy to provide it, or I could read
So
it.
let's strike that first part of it.
Okay.
And just ask the question, please. Again, this is redirect, it's not cross-examination.
Understood. Yes, understood. Thank you.
they're all defense attorneys.
Have you ever suggested that you came to pattern recognition skills because of communication difficulties or because people wouldn't share with you or report to you the cause of
The
a wound?
defense
No.
didn't object to Brennan's commentary. The court's not just interjecting, Brennan is standing up and objecting to it.
Would that be an
The
accurate
defense just let
statement
him
at all
be,
about how you
which I think
develop
is good for their
pattern
expert,
recognition skills?
personally.
No.
And why is that not
Strategically, if I was the defense, there's no jury there. We want to see which way the prosecution's going. This is a new prosecutor. I would let him just like, unless it's going to be a really horrible question that's going to leave in a really horrible answer, you just let him roll. Just let him do the things. Let her get a sense for how he asks questions and just let it go. So Brennan's objecting more because that's what he's choosing to do. But that's, the judge can only rule on the objections that are made. Also, he is patterning the redirect like cross-examination. I would let that go too. Honestly, it doesn't.
Because pattern recognition skills are again taught in various subjects in medical school. And
Let's
I actually
let's try the
started
desk.
even before medical school. But in
gonna
medical
stop the
school,
camera so it
they're
doesn't wiggle.
taught in various subjects and in internship and residency. And that was long before I started interviewing patients, with the dog bites of unknown etiology.
Is pattern recognition common or uncommon in the practice of medicine?
Very common.
Can you please
She already
give
talked
some
about that.
examples of pattern recognition and the use of pattern recognition methodology in the practice of medicine?
So I think she already did this before the break,
Uh-huh.
right, Doctor?
I mentioned it earlier with pathology, looking at biopsies.
Oh, I'm sorry, Dr. Rizzo. This is about you, and so you've heard it, and
This
I'm
is
going to move
about
on.
you.
Thank you.
You're
This is
welcome.
about you.
I'm going to move on to a different section.
It's about you.
You have been asked on
I know now we get
cross
to stand.
about
Love it. I'm so excited.
whether in your emergency department experiences,
Oh no, they stand up to object.
well, let me rephrase that.
Sometimes they don't even say
In your
object very loud. They
emergency
just
department
stand up.
experiences with dog-inflicted wounds, have you ever gone to see the dog in question?
Oh, I like that we're getting here.
Do
I wanna hear about this.
emergency medicine physicians
I wanna hear about this more.
need to go see the particular dog or any dog in question to determine whether a wound is from a dog as opposed to some other cause?
She's like, nope.
No.
Do you,
In fact, in
Dr.
what world?
Russell,
In what
need
world
to
could
go
you
to-
see an emergency medicine doc being like, "We'll be back to treat you. I'll be back to treat your broken arm. I need to go see the curb you hit when you fell off your bike first." Can you imagine?
to the particular dog to determine whether a wound is from a dog?
No.
Have you ever heard of an emergency medicine physician needing
It's
to
good.
go
I like the
visit a
standing desk.
dog
Thanks, Chad.
to
It feels
evaluate
good.
and treat a wound from
It's
a
nice
dog.
to be able to stand up and stretch.
Is that a rational proposition?
I don't believe so.
Zing. Is it rational? Yes, only in TV shows, only Dr. House. Exactly. Only on TV.
There was much discussion. Well, let me strike this. You were asked a number of questions about whether your testimony here for this hearing and your statements in your report are different from what you testified to in June 18 and June 21 of 2024. What I'd like to do is to compare the two and go through some questions with regard to that. So, what I would like to do is to have you have Exhibit 35, which is the transcript
They're going to go
of the
through the
December
opinions that the
12.
excuse me,
Do you have that?
that the defense
It's
was
a thick-
attacking.
It's the December 12, 2024. You should have that,
I do.
okay? And what I would like you to do is to also have available exhibits 35 and 36 and 37, because that's what we're going to do side-by-side comparisons. So, let's start out with the foundation for this. Do you have an opinion with regard to the nature and source of the wounds on Mr. O'Keefe's right arm?
Yes.
What is that opinion?
They're from dog bites, dog attack.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Now,
We can see what y'all are researching in the jury box.
at the June 2024 voir dire hearing, the claim is that you didn't say to a reasonable degree of medical certainty that the bites you looked at were a dog. So can you please go to
Karina Mann makes a very good point in the chat and said DNA is specifically
36.
pattern recognition, yes, and scientifically accepted. Exactly.
pages
Oop.
1-30, line 13, to 1-31,
Alessi's
line
voice
1, stop it,
picks up quite a lot in the
1-31,
mic.
line 1. These were questions in response to what you were asked on
Trying
direct
to
by
calm my
Mr.
ears.
Jackson. And I would, with the court's permission, like you to read the question in the answer to what you actually testified to at that voir dire hearing. So please go to tab 36.
So can I see counsel at sidebar, please?
Yes.
I imagine what the court's going to say. I'm going to kill the white noise. I imagine what the court's going to say is, counsel, this is for me. I get it. I get that she said it could be dog bites. I get that she said nail and teeth, and now she's saying these are nail and these are teeth. The court's going to say, I get it. I have enough information on this. Do we need this information? So let us zoom just a little bit till we get back to them being back on the record, because the court's going to be like, do we really?
Response
Let me back
to
that. I zoomed too far. We zoomed too close to the sun because they aren't showing the court and the speaker, so it's hard to tell from visual cues. I need the visual cues.
Yes.
Thank you.
Jesse in the chat asked, have I ever seen the court say no
Dr.
when
Russell,
people ask for a
could you,
sidebar?
or
Yeah.
first of all, do you
Yes.
recall in question?
Not this court. This court generally is pretty permissive unless they're about to go to a break and said, can we go to break? But some courts, can we approach? No. No. I haven't seen this court do it, but yeah, judges do that. They're like, no,
On cross.
not at all. You don't need me. Move on.
The claim by Mr. Brennan, or the statement in his question by Mr. Brennan, that you did not express certainty in response to Judge Cannoni's question about the certitude of your opinion. Do you recall those questions?
Yes.
to be fair, chat, figuring out, Casey, and a number of people said this, so it's not you, it's a number of people said this. This is redirect. So they did this in direct for an entire day. They had an entire day of direct. The Commonwealth just did their cross-examination, and now we're in redirect. We don't need to retread the same ground in redirect they did in direct. They had an entire day of it. So it's keeping with how much they had an entire day of direct examination in December. So that, to be fair, it is balancing the fact that we are not here to do direct examination again. We are here to precisely ask the questions that are needed. We are not here to retread the ground that's already been, at this point, well trodden. So, Muffin Man said, if there's no jury, why would they need to approach the judge? Because there's still a public audience.
Well, let's go
And
and
it's the
look
court's
exactly at what you said
The court doesn't
in
want them
response
arguing.
to the question that Mr. Brennan raised, that was raised by
also
the
like
judge.
Yanetti's tie.
If you could turn to Exhibit 36.
Guys, I'm very excited about my new desk. I really am. It's gonna make things, I'm gonna wiggle, but it's gonna make
And if
things
you
good
could
as we get into a year of trials.
Read page 1-51, lines 10 through 23. I'm sorry, bear with me a moment. Bear with me, I want to give you the correct
Next, we're redoing the
citation.
bookshelf because now you guys are going to see it more. So next, the bookshelf up here is getting a zhuzh. That's what's next. This is very exciting.
I want you to go to, did I say 37? I wanted to say 36.
Brittany, a lot of you
Did
have been
I say
walking while
36?
watching
You
today.
said 36, but you
Because I was
said
getting
page
tagged on
151.
Instagram
Might have meant
by those
page
of you walking
131.
along with me.
Right. That's what I want to go to, Your Honor.
I don't know if I would be able to walk and do this, but I do have a walking pad for when I'm on meetings and stuff. I don't think I can do it while I'm in trial.
Bear with me a moment, Your Honor.
Sure.
This is going to be one of only 2 questions in this area.
He's like, I promise, if you just let me.
What I'm trying to do is to get to Your Honor's question. That's what I'm going to pull out.
My question was on page 151.
I'm sorry?
My question was on page 151.
150. Thank you, Your Honor.
151.
Just be, I appreciate your faith in me. I don't do well trying to walk and talk. I'm worried about me
Can you go to
messing
page
myself up.
151
I'm not well practiced.
and read the questions from the court, Judge Cannoni, and what your
Oh,
answers
I've been
were?
tempted to paint the walls.
Yes, from line 10.
One project at a
The
time.
court, question. I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree
Of
you
medical
hold that
certainty,
opinion?
Right.
Answer, yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches. Question, do you know what kind of animal? Answer, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty.
this is
Very
the
sure, high
previous-
degree of medical certainty.
This is the previous voir dire.
Question, reasonable degree of medical certainty? Answer, yes, definitely. Question, okay, and another question.
No, that's
That's it.
That's it. Yep. Now, to be fair and accurate, has your opinion that the wounds to the right arm of the decedent were caused by a large dog attack strengthened from June of 2024 until now?
They have.
Why?
Well, because between then and now, my opinions have been challenged. And as, any good doctor would do, they go back and reevaluate what they base their opinions on. And I did that. I reevaluated. I looked at the pictures again, the evidence again. I looked at peer review studies, and I was convinced that I was correct.
And had you looked at, what caused you to go look at the peer-reviewed studies?
Y'all asked me a lot of questions, so I went back and double-checked my work after y'all asked me a bunch of questions. I mean, who wouldn't?
What were you
yes. Well, so I looked at the peer
That
review
makes
studies,
sense
and
to me.
I periodically would do that throughout my whole career in terms of dog bites. But I looked at the peer review studies again because I was
Right, I
asked,
wanted to go look.
why I didn't write a report, and so I was asked to write a report.
Were you asked to write a report before in June of 2024?
No,
But you were asked to write a report after June of 2024.
correct.
Now, let's
For
go
everyone asking about the
to,
desk, I'm working on getting you guys a code for the desk, so stay tuned. Stay tuned. That would be my goal. But I like her answer because
is
it's
this
so real.
what doctors and
Like-
scientists do?
Sir, this is what people do.
Go
you
back
challenge me.
and
I'm going to go double
analyze
check that I'm right. And if I'm not right, then I'm going to change my
matter.
mind.
Especially
I wasn't
when
right.
maybe
And if I am right,
there's
I'm
a
gonna be
challenge, another doctor is a question, there's a peer review process, whatever it is. Is that something that's common or uncommon in the medical community?
She wants to know if she's right or not. Reximoto in the chat said, is the doctor getting paid for these hearings? Yes, she is paid by the defense. Her travel is paid, her hotel is paid. Remember, she's from LA as well. Her travel's paid,
I only have
her
a few more
hotel's
questions,
paid.
Your Honor. I'm just looking at
Unless
them
she
to-
chooses to volunteer her
conclude.
time. But then she's also
On
paid an hourly
cross,
rate.
you were
Unless she
asked
says, just pay my travel and don't pay me. That would be
about
her
whether
choice.
you were aware of, or whether you saw a need to peer review your opinions and conclusions in this matter. You recall that?
Yes.
Was that necessary?
No.
Why not?
Because first of all, there was no question in my mind that these were from dog bites.
And are there any persons that you're aware of in the entire country who have experience with emergency medicine and forensic pathology that you could even send it to for a peer review?
No, and that was the other issue,
like,
is
I
I
have
wouldn't
so
even
much-
know
I
who
have
to send it to
so
because I
much
don't know of anybody with
Of a
such
varied
experience.
background that there
I
are
am
no
going
peers.
to, let's assume hypothetically that Mr. Walsh has stated
Oh, the
that
other expert.
these injuries
So he is posing the other expert's finding as a hypothetical. What would be interesting to me is if he provided that to this expert before the hearing. It seems like not. So we're going to hear more about what the other expert said, and I'm very interested to hear that. This is new information for us.
do not
Back us up real quick.
that these injuries do not photographically appear to be described as puncture bite wounds and thus are highly unlikely to be the result of an animal bite attack. The abrasions are unspecific. Abrasions occur in body moves over a blunt or rough surface such as a skin knee. Do you find that analysis sufficient to evaluate whether the bite wounds in this, the wounds from the right arm of the right arm of the decedent are from a dog or not?
No.
Why not?
Well, clearly that person, whoever wrote that, didn't even recognize the pattern. And so thus couldn't really even make that opinion and,
They said negative, ghostwriter, the pattern is full.
just didn't recognize the features.
Right, what's their expertise? Are
In
they
the
a
hypothetical
pathologist?
that I just gave
Are
you,
they a
do
treating
the
doc?
facts that are used in any way support the conclusion that is stated?
I don't believe so.
You don't believe so, or can you answer whether they do or they don't? Do the facts stated in that hypothetical support the conclusion that is made in that statement?
Actually, they don't.
Assume the same person
This is why experts battle.
said a vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Would you agree or disagree with that statement?
I think she'd probably agree with
For the
that.
conclusion, would you agree or disagree with the conclusion?
Would you please read it again?
Sure.
That sounds
A
reasonable.
vehicle backing into O'Keefe
This is the other
is
expert
one of many
in the
possible
feds.
causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Do you agree or disagree with that statement?
I agree up until
And this, not having it in front of her is probably frustrating. And this is why we might not see that expert from the feds who says, look, I don't think these are dog bites. I also think a car crash is part of a plethora of potential problems. However, a taillight's not going to shatter because you're not going to have the force you need without other injuries. If a taillight shatters by hitting an elbow, then the elbow is probably also going to shatter. So you're not going to get these injuries from a car crash without these other injuries. The things go together, which would be a, say it with me, chat, say it with me, pattern. So this is the other expert from the feds that the state brought up, or the Commonwealth brought up during the cross-examination, that they are now bringing up, giving the entirety of that opinion, which is, from photos, these don't look like dog bites. However, there are things missing for it to be a vehicle collision. And that is the problem with this entire case, isn't it? It just sums it up in one sentence.
mention of the taillight.
But what is it
Right.
that you agree with in that statement?
Well, I agree to the part that says that that it was insufficient to cause the injuries, the death of Mr. O'Keefe.
Now, aside from that hypothetical question, what is your opinion of whether a motor vehicle caused the injuries to the right arm of Mr. O'Keefe?
The motor vehicle did not cause.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
This is why I think the defense, honestly, think the defense should focus on, how did a car do this?
Are you aware that only microscopic pieces of plastic were found in the hoodie sweatshirt of
Thank you,
Mr.
Tricia.
O'Keefe, as opposed to, quote, littered, end quote, aspects?
I am.
Are you aware of any evidence of littering of pieces of plastic or glass in the hoodie of Mr. O'Keefe?
No.
Are you aware that there was pig DNA found
In my
on the
breakfast.
decedent?
That's not where they were going.
Are you aware?
Not on the decedent.
On any
On the
aspects
clothing.
of the decedent's clothing.
Yes.
Do you know, from your experience,
Elizabeth,
with
I agree with
regard to dog-inflicted wounds, your many
And we can talk about this.
emergency
In a
room
bit, I agree with you.
evaluations and treatments of them, whether or in your knowledge of dogs and dog dentition in general, are you aware of whether dogs eat any type of food or treat that has pig in it?
I'm aware that dogs, some dogs eat treats that have the pig chews and other kinds of chews. And so yes, they do. Some dogs do eat things that contain pig.
So weird.
Your Honor, just if you will, a point of information. I believe I'm done with my questions, and the reason why I say I believe I'm
Why
done.
don't you come to sidebar instead of having
Okay.
a discussion across the courtroom?
She's so particular about that. Look, man, there's things I'm particular about too, but why don't you come to sidebar instead of having a conversation across the courtroom? He is not from this jurisdiction, Alessi, so he is trying not to run afoul of this court's rules. So I appreciate him for being overly deferential and cautious. I think it works well with this judge, but I think he's just about done, which means we'll be getting into recross. The court wanted to be done today with this particular hearing, and I hope that we will be. Yes, Lyndon, Alessi is going full rules of order. I also wonder how much he practices
Dr.
in
Russell,
federal court.
Attorney Alesi, pardon me.
Ben, I would be a terrible judge. I would be a terrible judge. I am a much better YouTube commentator. Look, judge work is so administrative, it would make my eyes boggle. Also, my faces, and that is not always judicial demeanor. Also, it is, you don't have much control of your schedule as a judge, and it can be very political. Nope, I like doing this. No. Judge Judy judge, yes. Real judge, like Judge Abby judge, no. It's so much administrative paperwork, my ADHD would scream.
Asked you about Dr.
like,
Walsh's
check all these
statement
boxes, and if
about
you
the
fuck
cause
it
of
up, you
injuries.
really
Remember
fuck it up.
He just asked you that?
Yeah.
What he didn't offer in the report is this, and let me know if you agree with it. Decedent John O'Keefe was
I'd be sitting
documented
there
to
like
have
this.
craniocerebral injuries, including skull fractures of the optical skull and the right parietal bone with associated subdural and subarachnoid hemorrhages. These injuries of the scalp, skull, and brain are consistent with, among other things, a backwards fall, unobstructed, unprotected falls due to various reasons are known to result in serious craniocerebral injuries resulting in death. Other mechanisms of injury cannot be excluded. Do you agree with that?
Objection, Your Honor.
No, we don't agree.
I'm going to allow him to do it.
Do you agree with that part that you didn't hear of Mr. Walsh's opinion?
I want to rehear it because I was reading chat. So I'm gonna back it up so we can rehear it. But this is why I want the zoom out of the whole courtroom, because the drama of it is so good when you have Alessi popping up on his feet going, objection, Your Honor. And you don't get that if you're just zoomed in. Like, I want to see what's going on in court. And that includes the bouncing out of your seat like a jack in the box to object. I want to hear the rest of this opinion from Mr. Walsh.
I'll be ready in a moment.
So let's hear it again.
Okay.
We can just timestamp it now that we'll hear the
Dr.
full
Russell,
Walsh opinion.
Attorney
Apparently,
Alesi, pardon me, asked you about Dr. Walsh's statement about the cause of injuries. Do you remember? He just
Yes.
asked you that?
Yeah.
What he didn't offer in the report is this, and let me know if you agree with it. Decedent John O'Keefe was documented to have craniocerebral injuries, including skull fractures of the optical skull and the right parietal bone with associated subdural and subarachnoid hemorrhages. These injuries of the scalp, skull, and brain are consistent with, among other things, a backwards fall, unobstructed, unprotected falls due to various reasons are known to result in serious craniocerebral injuries resulting in death. Other mechanisms of injury cannot be excluded. Do you
Yes.
agree with that?
Objection, Your Honor.
that's
I'm
fair.
going to allow him to do it.
That's fair. Because that's what all the coroners have said. It looks like an unobstructed backwards fall to the back of the head. But if that's the opinion, are we going to get back to the state's witnesses who were like, well, somebody could have been bending forward? And we're not getting back to the bend and snap from the first trial, are we? Unobstructed backward fall causing those injuries. Yes, it could be.
Do you agree with that part that you didn't hear of Mr. Walsh's opinion?
Yes.
That's
The
what
documented
all
changes
the
in
other
color,
docs
swelling
said.
of soft tissue around the eyes are most consistent with the medical finding of periorbital ecchymosis, as documented in the autopsy report. Periorbital ecchymosis
So he agrees
is a
with the
passive
coroner.
accumulation of blood around the eyes secondary to the documented skull fractures. These findings are less consistent with and are not documented as contusions of the eyes.
Oh,
The 1
that's what he
centimeter
wanted to get
laceration
to.
of the right upper eyelid, laceration of the anterior right tongue, then abrasion of the anterior and left aspect of the nose
That's
are
what he wanted to
documented,
get to.
considered nonspecific, and may have occurred to a variety of mechanisms. Do
Okay.
you agree with that?
Yes.
Okay. The 2 red contusions on the dorsal aspect of the right hand were documented. The hand injuries may represent an injury sustained during an unprotected fall in which the back of the hand impacts the ground. These hand injuries are nonspecific and may have resulted
Or
from
medical
impact of hand
intervention.
with any blunt object. Do you agree with that?
It's possible, but there are other mechanisms.
Right.
When you talked about those articles that Mr. Alisi had you read, there is nothing that details what pattern recognition analysis is, the specificity which you are looking for when you're looking for a wound, does it?
I disagree.
Okay. When you looked at that Exhibit 5, if you could pull that up, you said individually none
Jen
of those
Penn in the
wounds,
chat,
did you
yes, that's what
say,
he's describing.
to a reasonable degree of medical certainty were caused by a dog.
Yes.
It's only if you looked at them collectively.
Yes.
Okay. When you look at those collectively, it does not tell you the order in which the wounds were incurred, does it?
No.
It doesn't tell you if they're all incurred at the same time, does it?
They were occurred around the same time, I can tell you that.
Yes. But they don't tell you the order, the chronology, do they?
No.
No. In fact, when you look at the studies that you introduced with Mr. Alisi, let's talk about the Munich one very quickly. There's a chart, page 298. It talks about the things you would want to do to identify a wound. It talks about scene investigation, doesn't it, in the chart? Table 2.
That's a fatal case, though.
Scene investigation is something you would look for?
That's in a fatal case caused by a dog. The cause of death was the dog.
This whole thing, the whole excerpt is a fatal case that you're relying on for this pattern recognition analysis. This whole article is about a fatal case.
Does the mechanism of dog teeth work differently, whether it's fatal or not? Because I feel like maybe not, but you wouldn't study it medically unless there was a fatality, because otherwise the person gets treated and goes home, unless you're this doctor who, oh wait, studied non-fatal dog bites and wrote a book about it.
That's
Isn't
what
it?
I'm saying.
Right. And in this fatal case that you're relying on to say this pattern recognition analysis, it points out scene investigation is the priority, doesn't it?
I think you misunderstand. The focus of that article is to identify.
Under his breath, I think he said, no, I don't, which is wild snark, and I want to hear it.
Pattern recognition analysis, it points out scene investigation is the priority, doesn't it?
I think you misunderstand. The focus of that
He
article
did say, no, I
is to
don't.
identify the dog that caused the fatal injury. In this particular case, I don't believe any of those are fatal injury. That is not the purpose of the identification of those injuries.
Does the chart also say examination of the victim?
Excuse me?
Examination of the victim, does it also say examination of the victim?
I don't have it in front of me anymore, but.
Well, you relied on it, you don't remember
Yes.
this?
I think you have it. You don't have
Oh,
it?
do I have it? Oh, yeah, it's a minute.
Okay.
Okay,
Table 2,
okay.
page 98, examination of the victim. You did not examine the victim, did you?
No, she
Table two.
relied on
Yes,
the
table 2,
examination.
page 90. And the last part is examination of the...
Examination.
Also, the expert that he was quoting earlier also didn't examine the victim.
I examined photos.
The last part is examination of the dog. You did not examine Chloe, did you?
No.
Okay, so the 3 things in the table it tells you to do, you didn't do any 3 of those, not one of them.
Those,
Different purpose.
again, the purpose of this article was about the fatal, how to, the forensic approach to a fatal dog attack. We did not have a fatal dog attack here.
You didn't do any of those three things, did you?
No.
Okay. The shards in the sleeve, exactly where those wounds are, same area, same limb, right? The
That's what you
shards.
say.
How many shards were in that sweater?
Objection, Your Honor.
So, I'm sorry, you said that's what you say, doctor? Is that what,
Yeah,
is that
and
what your
he
answer
said,
is?
Mr. Brennan said that the shards were in the exact same
She
location.
said that's what you say.
Okay,
And
let me
that's-
rephrase that. The shards in the right arm of the sweater, the shards from the taillight that was shattered,
Yes.
those shards, how many were there? How many
I
microsoft?
believe there were only a couple.
Why do you believe there were only a couple? Where did you read that?
This is what I was told
This is you were told by who?
by defense.
Oh, so instead of looking at the actual criminalistics report, you simply rely on what they tell you to base your facts?
That's what I,
She should have the
I was told,
criminalistic
yeah.
Wouldn't it be more
reports.
prudent to actually look at the criminalistics report and make your own determination objectively and medically, rather than regurgitate a point of the defense?
well, I was told, this morning you said that the sleeve was littered with glass. And I was told that it was not littered.
I see. Have you ever looked at that criminalistics report for
I'd be
yourself?
happy to do so now.
I'm asking if you've ever looked at it before
No,
you
she
offered
hasn't.
this opinion.
No.
No. If the glass shards were in that sweater in the arm, and we know glass can cause a hole in a sweater, in a fabric, can puncture it, and it can cause an abrasion to
really
skin. Have you
stretching the
done any
definition
tests
of
or studies
shards.
to rule out that the broken taillight that was in the arm sleeve of Mr. O'Keefe, did you do any studies to rule out that it didn't cause those injuries?
Objection, Your Honor.
I'm going to allow it.
The glass shards would not have caused all the round wounds in the sweater. Those holes. The defects in the sweater mostly were round. They were not slit-like defects that I would expect with glass or plastic.
You're telling us that a sharp piece of glass cannot cause a hole to a sweater.
No, I didn't say that. I
I-
said they would not, especially on multiple sites, the same exact type wound,
Well.
defect.
If the glass was shattered and the glass had a number of pointy edges, wouldn't you agree with me that can cause a number of punctures in somebody's arm if the glass went into the arm and then came out?
Yes, but they wouldn't look like that.
You don't have any past case or history to suggest what the glass shards would look like randomly when they hit somebody, do you?
Show her the
That's
glass
incorrect.
shards.
I have seen hundreds of motor vehicle accident victims who have been cut by glass. They don't
Also, she is probably talking about motor vehicle glass. He is talking about whiskey glass.
look like that.
So from your perspective, the glass just remained dormant in the sweater but never protruded through the sweater and
sweater
caused
was
the abrasions.
kind of
That's your
everywhere.
opinion?
I didn't say
Your
that.
Honor, could we have a sidebar on this? Sure.
I have no further questions. I'm good.
Your Honor, can we have a sidebar? I'm done. I'm going to stop now, Your Honor. I'm going to stop. That was literally him. I'm going to stop. I'm just going to stop now. That's funny. She's like, I'll just stop. They're getting to how much information do you need to evaluate to be an expert witness? He wasn't going to stop going through that, but let's zoom to the end of this sidebar and see where we go. I zoomed and saw that what's coming up in our future is the fan. Let's see if the court says anything about whether or not they are taking a break. Also, yes, this expert probably should have all the reports, because then the expert would be like, well, the shirt was in the snow, and then it was cut off in an ambulance, and then it was on the floor of the ER. And she would have expertise to talk about what that looks like in a code situation, etc. So,
Dr. Russell, when I'm referring to these shards, and I've said glass shards in Mr. O'Keefe's sweater,
You've
a more
said that a
accurate
lot.
way to define it would be that these were plastic shards, the plastic covering of the taillight, not glass.
you've said glass the entire fucking hearing, sir. All you've said is glass. Now it's plastic.
Okay?
Okay.
All right. Thank you.
Sure.
Dr. Russell, you are all set.
We're done?
We're done. You're done. We're not done, but you're done. You can step down.
Dr. Russell's like, We're done for now, thank God. Sorry, I'm wiggling. So if my
If
camera's
counsel
wiggling, it's me.
can- If counsel really can keep your, Mr.
Arguments.
Lessie, if counsel really can keep your arguments to 15 or 20 minutes, I'll give you 5 minutes to pull them together, 5 or 10 minutes to pull them together.
Thank you very much, Your
I
Honor.
really
All right.
can't keep the arguments to 15.
All right, so I'll be back out at 3:15.
All rise, please.
All right, the hearing is done. We are going to go to argument. I have stretched. I'm going to sit back down for argument so I can take notes. I'm curious as to what points they hit. Let's talk about what I think they are going to touch on most specifically. The prosecution is going to hit on methodology, and argue that, try to make sure we don't jump scare with the audio. Methodology. There is no methodology here, and that's why this isn't a proper subject of an expert. Not that this expert doesn't know what she's talking about, but that this area is not an area that should be an expert witness testimony. So that's what they're going to focus on. The defense is going to focus on, look, this has been peer reviewed, this is part of science, and treating physicians are in the best position to recognize these because they are using it day in and day out to practical effect, different than what a coroner is deciding. And the peer review article is talking about the coroner forensic approach to determining if a death was caused by a dog attack. However, that doesn't change the fact that pattern recognition is part of what is used to make these determinations. So with all of that, we are going to get to arguments and go to court. So let me zoom, and then as we start arguments, I will sit back down real quick. It's harder to zoom from here. It definitely changes my orientation to
It's 19.
to my monitor setup. All right, let's get back to court. I should swoop, and then I'm gonna go hang out with my kiddos because they have a snow day. Because, you know, there was the threat and whiff of ice. There was a scintilla of ice, and it was actually quite icy last night. So, you know, it smelled like snow. So it was like, we'll just take a day, which I love. So now we're going to get to arguments. Yay, arguments!
All right, did counsel have enough time to pull your thoughts together?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, Mr. Brennan, it's your motion, so I will hear you.
Peggy, we're gonna have more purple. I just haven't had time.
Mr. Brennan.
It's a scintilla of purple. It's a LaCroix of purple. So his
Let's start
motion.
with a couple of very important cases for Your Honor's
Can you go
consideration.
back to the mic?
The first is one out of
No, he's just gonna argue standing there looking at the judge directly. Sure.
the District of Massachusetts Federal Court. It's Hines 55 Federal.
I'm still here. I'm just moving my desk.
Page 62. It's a 1992 case authored by Judge Gerger. It had to do with a soft science handwriting analysis. It was a very thorough and thoughtful case that talked about soft sciences, methodology, and when there is an absence of methodology. In that case, I'm sure Your Honor is aware.
Like
it
throwing
had
a
to do
cell
with
phone?
A proposed witness who wanted to look at a handwriting exemplar and provide an opinion of a so-called match. The court said there were very important canons, very important principles or foundations that have to be considered when we're discussing a soft science.
And this is what we've talked about, these factors.
Empirical study is not enough. Simply because somebody has seen something before, whether it's once or twice or 100 times, is not a science. It's not a methodology. It's not medicine. It is a personal aside.
Diagnostic. It's not an aside.
A potential expert has to be in a better position to understand and explain to jurors rather than a simple layperson. That means there has to be some level of methodology, some type of guidance, some type of study so that they can assist the jury in better understanding what they believe their conclusions are. Empirical is not enough because a subjective opinion without medical, factual, scientific support is just an opinion. A person can look at the constellations and see the Big Dipper, they can see Orion. It's a matter of perspective. It's no different when we have something like a soft science, something different than DNA, where a person wants to give an opinion because they've seen something before. That's not enough. And in this case, Dr. Russell has never been in the business of identifying dog bite wounds. She treats them. She's an emergency room physician, had some experience as an ME. She treats a wound that is brought to her. She's not diagnosing the wound or determining the mechanics of injury. She doesn't have the education, she doesn't have the qualifications, she doesn't have the training for that. That is not what her job is. It is to treat the injuries. And so all of her perspective and opinions are empirical. She doesn't have a book, she doesn't have a study that teaches her how to do. She never took a training, she never took a class, she never got a degree or certificate. She's looking at her past experience when someone reports to her that it was a dog bite wound, and she's trying to use her memory and make a decision whether or not she thinks this is similar. That is not science. That is not medical certainty. And so there's nothing to suggest that whatever method she used, I still can't identify it because I don't know, despite many questions of asking her, what her methodology is, other than she says it's pattern recognition analysis. It's empty phrasing unless you can identify and articulate what is the specificity. What is the standard? And we still don't know. After all of this testimony, we don't know. In Cromwell versus Rintala, that case had to do with a prosecution expert talking about paint spill. And this could not fit more closely to this case. The
I'm interested
conviction
to hear
was
about this
overturned
case.
because the prosecution called the paint spill expert. It was found to be prejudicial because the expert relayed their past experience. Their past experience about paint spills. Exactly what Dr. Russell did in this case. No more, no less. Her past experience treating injuries that were reported as dog bites. A person with their past experience with paint spills. The court was very specific in Rinaldi about why this was improper and why it was prejudicial. It said that just because a witness has experience or particular experience and decides to use that as a methodology does not make it methodology. And it's just like Dr. Russell's testimony. There is nothing about it that employs methodology. In Rinaldi,
Rintala.
pardon?
Rintala.
Thank you.
The court's like wrong case or wrong
Direct
pronunciation.
the court to page 39. And it talked about when the expert used methods to determine that paint was poured or spilled. And the problem, why this case was reversed, the court said, instead, meaning the expert, he simply relayed his past experiences working with and around paint and drew conclusions therefrom. That is exactly what Dr. Russell has done. She has relayed her past experiences working with and around treating dog bites and drew her conclusions from that. They cite Cromwell versus Franceschi. I'm probably saying that wrong as well. But what that quotes is, while training and experience, to which the expert referred, might have taught the expert methodology, it is not itself a methodology. And so while Dr. Russell may have taught herself or been intrigued or interested in dog bites, it is no methodology. The defense has introduced a couple of articles. Those articles do not describe or lay out a methodology for identifying dog bite wounds. They don't provide a standard. They do not provide a comparison. They don't provide any guidance. And so the danger in having somebody go before a jury and portray themselves as an expert when they have no methodology is they can pretty much provide any opinion they want to the jury that can be unchecked because it's not factually based.
Well, you
It
can
can't
bring
be
in an
compared.
expert.
It
You can
can't
bring in
be
a doctor.
analyzed. It's not peer reviewed. It's just an opinion. And when an expert lacks methodology, classic things happen, which happened in this case. What happens is that a witness does not actually have certainty about what they're saying. A witness is prone to change their opinion because there is no standard of methodology to confine them. A witness can just change their mind without new information because it suits their purpose. When we looked at Exhibit 5, and we actually broke down the wounds into separate wounds, 5 wounds, the doctor, I believe, concedes when you look at each of those abrasions independently. She cannot say with scientific certainty. She can't say with any certainty that those were caused by a dog. Her fallback was when you look at the entire series of wounds, that equals a dog
He's
attack.
argued this much better than Mallory
No
did.
basis, no reason why we reached that bridge from uncertainty to dog attack other than just because she said so. That can't be challenged because there's no methodology. And so the risk we have is you have an expert who gets up in a voir dire and they give opinions that wound number 1 could have been teeth marks, could have been claw marks. Wound number 2 could have been teeth, could have been claw. Wound number 3 the same. Really no idea. It's just guessing or speculating. And then they get up later and they change their opinion that more benefits their side. She later testifies at trial, sometimes maintaining teeth or claws. And then she appears in this hearing after writing a report and consulting, and she is emphatic that these are not scratches, but that they are dog bites. Think about the posture of that. If she is now saying that these are dog bites and they're not scratches, and she's changed her, that impliedly concedes that her testimony in front of the jury, for which she was allowed to testify as an expert, not only was inaccurate, not only unsure, but inevitably
Not exactly what
it's
she said.
misleading. It cannot be helpful testimony if an expert provides an opinion to a jury and they, later on, without any real changes in information, changes their opinion for whatever reason. They're not constricted because there's no methodology or standard. And so the fact that this witness was allowed to testify at the last trial with opinions she no longer endorses or stands behind, and the fact that we can reasonably conclude that is misleading to the jury, well, that begets the argument that she should not be given another chance to go in front of a jury and give a different opinion without having actual factual and medical and scientific support, and she does not. There is no doubt about one thing, she has no idea. When I walked her through the different wounds on Exhibit 5, I invited her to explain to Your Honor, why is it that this wound was caused by a dog? There's no circumstantial evidence to support that, none whatsoever. It's just her personal, empirical history dealing with dog injuries in the ER. And when I asked her for wound 1, what direction were these canines? She couldn't tell. Where's the puncture wound where the dog anchors and pulls? There is none. The distance and width of those wounds, how could she reasonably and fairly say they were caused by canines? Any indication, any support, any pattern recognition that would tell us that was caused by canines, and she couldn't give us any information. Not weak information, not information that I could fight with another expert, not information that I could say, wait, not the admissibility. None. She could just fall back on, well, when
And
I look
that's
at
gonna be a
everything, it's a
good
dog
point.
bite. Same thing with number 2. Number 2, interestingly, the widths are much different than wound number 1. It doesn't take an expert to know that it wasn't the same mechanism that caused the injuries to wound 1 and 2. And if they want to continue to pretend it's a dog bite on wound 1, there's no way they can reconcile that wound 1 is in any way similar to wound 2. It would have had to be a baby dog or a different dog or the pack of dogs I asked her about the first time I talked to her. It is totally
That's not what she
different.
said.
And again, when I asked her for any specificity, these weren't hard leading questions. I opened to her to explain to us, why is that a dog bite now? She would only give us a conclusory answer. It just is. There was nothing about teeth or detention or about the dog, about anything that would support the claim that that was a dog bite and why she changed it from the scratch. None. We get to the elbow wound number 3. There's the speculation that the arm could have moved, would have moved, but yet she has no idea. She has no factual support for this. None. And she vacillates between this being potentially bites, scratches. All 5 of the different points on wound number 3 could be canines on both sides, or maybe there was a 4-point canine in the smaller fraction of number 1 and number 2. in wound 3. That cannot be. It defies common sense and reasonableness to say the same dog caused wound number 3, points 1 and 2, with the so-called punctures, and caused number 1 and number 2. Again, you can simply look at the distance between canines are not going to move when a dog bites an arm. An arm can move, it can change the angle,
People move.
the depth. The canines are not going to move. Then we get to wound number 4, equally baseless. Wound number 4 at first wasn't sure if it even had to do with the dog attack. But then that made no sense. So Dr. Russell retreated to say, well, it did have something to do with the dog attack, but hard to define. And then wound number 5,
Why is this
again,
where the camera
a
is?
4-point bite that is totally reconcilable with 1, 2, and 3. There is no collateral or supportive evidence to suggest that this is a dog bite at all. It's fertile imagination for her to get on the stand and claim it's a dog bite. Not just that there was no opportunity and that there was no dog that touched her, but the wounds are dissimilar. She cannot point to a pattern, a methodology, a standard to say, this is why this is a dog bite. It's just a dog bite. So it's interesting when we learn that she didn't know about much of the evidence that wholly contradicts the fact that this is a dog bite. She didn't know that there were plastic shards in the sleeve
I
of
mean,
his
you
arm.
did say glass 100 times.
The fact that there is physical evidence that results from a collision left in the very place where this wound happens to be there isn't mere coincidence. It isn't mere coincidence. It's exacting evidence. And what is not exacting evidence? The absence of DNA. Now, this is important because Dr. Russell was comfortable taking the stand and providing information to Your Honor for consideration that was totally baseless. It didn't in any way hamper her willingness to do that. She floated theories of taint in the DNA, or manipulation, or the DNA wasn't handled properly. There was absolutely no good faith basis whatsoever for her to suggest for a second that that DNA collection, preservation, and testing wasn't sound. She had a right to look at the evidence in the criminalistic reports and the DNA processing. She knew she could not admit the significance because it would undermine the entire theory. And so she was comfortable on the stand using her experience as a doctor to try to convince Your Honor that DNA was insignificant based on a demeaning of the evidence with no basis. An insulting claim that somebody did something wrong with no basis. The reason why that's important, it shows that this witness has the willingness to testify to Your Honor about a conclusion for which there is no support. This witness has the comfortableness to testify to Your Honor about an opinion that has no factual basis. And her doing that with the DNA was a parallel to her doing it with the dog bites. She is comfortable getting on the stand and simply giving the ultimate opinion that is helpful for her cause without any support. And so that DNA attack by her is reflective of her willingness to compromise fact, science, and medicine to just provide an opinion. Knowing there is no real methodology here, there just isn't. Knowing there's no standard, unable to provide us any balance for why this is a dog bite, having the free rein of an opportunity to look at the exhibit and tell us anything she wants to support as a dog bite, and being unable to do that, the defense employs differential diagnosis. That's a fancy way of saying, well, we might not be able to prove this, but we can disprove everything else. That's the way they presented this expert. They own that. Because when you look at those different wounds, and you can't identify them as dog bites individually, you can't say the whole series becomes a dog bite. Wound 1 has 0 value. Wound 2 has 0 value. So 5 times 0 is 0. Cumulatively, it does nothing for us. Using the word dog attack doesn't make you look at that and say, well, that's methodology. That is nothing. And so differential diagnosis is a very compelling argument for the government why you should not allow this. This witness is in no position, kind of like the DNA and kind of like the opinion on dog bites, she is in no position to engage in differential diagnosis regarding to car accidents. She may have been a police officer, and she treats injuries at the hospital. She is not an accident reconstruction specialist. She has never gone to an accident and done a reconstruction. In fact, she never even went to the scene in this case. She never saw Mr. O'Keefe. She doesn't even know about much of the evidence that exists. She didn't consider the black box. She didn't consider the speed. She doesn't know the angle of the collision. She doesn't know what Mr. Keefe was doing in his last moments. She has no idea about any of that, none. Yet she'll be presented on the stand as if she can exclude a car collision as the cause of those injuries. Not that they could be, and it's consistent with what didn't happen. How dare she get on the stand with no experience, no training, no methodology,
That's strong
no
language.
facts, and ignore reality and say this couldn't have been a car collision. It's funny that as a emergency room physician, she considers the basis of mechanics of injury based on what people tell her. If they come in and say, I got bit by a dog, or a parent says, my child was bit by a dog, they rely on statements of witnesses. She didn't rely on statements of witnesses here. I hit him, I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone. Whatever the statements were. All the various statements. An expert like her, as she proposes to be, would consider the witness statements to try to determine the cause of mechanical injury. So for her to take the stand respectfully and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with no factual basis, in defiance of actual fact, it's repugnant to the sense of fairness in the courtroom. A witness, just because they have experience as a doctor, doesn't mean they can just come into court and say what they want and then let the government try to counter it. That's not how it works. And so when we consider not only what she doesn't know, but what she chose not to know, it is overwhelming. This is not a qualified person to come in and talk about dog bites. From her perspective, she's probably one, if not a few people in the country who can even do this kind of thing, which suggests that there is no real methodology. If she is the only expert in the country, it is not generally accepted in the community. It can't be.
That's
It
not a
can't
bad
be.
argument.
And as much as the defense may want her to testify to promote this theory, she does not have the credentials and qualifications to do that.
That's not a
She
good
didn't even
argument.
take the basic steps that you'll see in some of the literature of going to the dog. Chloe, they knew we found Chloe. They know we've done molds. And she says they told her. And she tried to fight with every posturing angle that may be important, but she didn't need to do that. I dare say, if she had taken some steps to try to do due diligence, it wouldn't have ended well for her theory. Perhaps that's why she didn't. She doesn't have the qualifications, she doesn't have the experience, she doesn't have the methodology. Her willingness to tell opinions that are speculative, factually wrong, not based in science and math, should disqualify her from giving another baseless opinion about a so-called dog bite wound. There is no DNA, there is plastic shards in his arm.
Not in his
She's
arm.
done no due diligence. And she can't describe any methodology because there is none. And she, most importantly, has changed her testimony from hearing to hearing, and we should not let that happen again. Thank you.
Thank you very much. All right, Mr. Lessie?
I know you guys don't like Brennan, and I know you don't like the way he's arguing. We'll talk about it after arguments are done, but he made some points that are going to be strong for his argument in this, and we will talk about that after we hear the argument from the defense. I know in this case particularly, it is very difficult to look at this argument in a vacuum, but that's what needs to be done. Looking at this argument about this expert in a vacuum, and we'll talk about it. But he did have some very good points in his argument, despite the fact that I know a lot of you do not like the way he's presented them. There was definitely some snark in there, but he had some points that will be, I think, well taken. He argued this substantially better than the last time the Commonwealth argued, and we will see what the defense has to say. Because I imagine they're going to have quite a lot to say. Including,
great-
it's offensive to say a woman with this much career experience doesn't have any experience. I imagine that will happen at some point.
This danger to the issues in this case, the greatest danger to a defense right to a jury trial and present its witnesses to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view. Remarkably, all of the arguments you just heard now do not come from a medical doctor,
They're his opinion.
which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is the affidavit? Where is the report of a prosecution witness to support
To refute.
one statement Mr. Brennan just made in 30 minutes? Where is it? It doesn't exist. I would like to start my argument and
That's a
tell
very
you
good
exactly where I'm going to go. I am going to go to why we're here and what the issues are for this motion. So I'm going to start my argument with what is the legal standard that Your Honor faces
We
to
love a
answer it. And I
roadmap,
know
sir.
Your Honor knows it. I'm just doing it for the logic in the presentation.
Oh, we love it.
I'm going to go through that.
We love a roadmap.
I'm going to identify specific case law of dog wound cases, not paint cases, not others, because it matters, because Daubert and Lanigan are so flexible and so nuanced, it's got to be the issue before it. Paint cases that Mr. Brennan mentioned are irrelevant. So I'm going to go through cases that speak specifically to dog wounds on humans. Then what I'm going to do is to go through the completely inaccurate statements of Mr. Brennan. He said it, I marked it down 8 times in just his argument alone. There's no methodology.
He did say that
I'm going to go
quite a
through and
lot.
say what the methodology she testified to was, where it's rooted, and then I am going to go into why Dr. Russell is actually stronger in December than she was in June. So let me start out with the
I don't
baseline for
disagree with
this
that
hearing.
either, by the way.
The January 20th transcript, page 1-4. And if Your Honor will indulge me, it's what Your Honor said, and I'm going to read it verbatim.
We love using the court's
This
words.
was when Dr. Russell was challenged by the prosecution the first
As long
time.
as you're not
Line
attacking the court with
15.
them, she doesn't like that.
I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked at that capacity, but that she does have specialized knowledge in that field that may assist the jury in that regard.
That's the court's
So if
finding
you
from trial.
compare the level of information that Your Honor had at that time to reach the conclusion to what we have presented in this hearing,
Court has so much more.
11-page single-space report. And Your Honor noted before that there wasn't a report, so we
God,
wanted
if
to
you give
respect
me a
that
single
and get a
space
report. Your Honor has sat through testimony, which I'm going to adduce, but not too much because you sat and heard it, and went through her qualifications, and we adduced much more of her qualifications, much more than were adduced when Your Honor first found that finding and made that finding. So let's start with the law. Mr. Brennan and I agree on one thing. The Rottola case is relevant.
Well, that's good. Let's start with what we
But-
agree with.
Respectfully, Mr. Brennan went off in a tangent, because what does Rottola stand for that's relevant here? Quote, the crucial in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. What is the subject matter of the testimony?
I know.
It's what are the cause of the wounds to the decedent's right arm. I submit that if you ran an artificial intelligence program, you
Don't do that.
couldn't come up
Don't
with a
bring an
more
AI to
perfect
court.
witness for the subject matter of this testimony. Emergency medicine physician, 29 years experience, forensic trained pathologist who has co-authored books on dog bites. She's well-versed in the articles. She is consulted by experts like Dr. Vail that you heard about for these types of issues. The crucial issue of whether she's qualified, to me, is 100% in favor, and I don't believe you could find another witness more qualified. And that's the crucial inquiry. What's the second prong of the inquiry? After
These are the
qualifications,
factors we talked about multiple times
is
today
the methodology
when we're looking at 702.
reliable? That's the second. Whether Mr. Brennan
case law.
agrees, and 95%
He
of
clearly
what he
doesn't.
argued, that's for cross at trial. But more importantly, that's for a jury to determine.
Well, the
That's
court's the
the
gatekeeper.
job and province of a jury.
The court's the
To
gatekeeper
determine
here to
whether,
determine if it
assuming
comes
Mr.
in.
Brennan ever gets a doctor to come in and counter Dr. Russell, it's for a jury to decide which expert do we give more weight to. But the focus of this hearing, why are we here?
The court's a
The
gatekeeper
second
to that.
prong is the methodology. Mr. Brennan, 8 times in just this argument now, and he tried it on cross, said there's absolutely no methodology.
EDB said all he
Your
was going
Honor
to say was
heard the
methodology.
same thing that all of us heard. She went through her own pattern recognition methodology, especially in redirect, but she did it very thoroughly in a report and very thoroughly on direct. She went through what it is. And importantly, counter to what the Commonwealth just said, she says it's rooted in the medical literature. We just heard the statement that there's no support for it. Demunic and Pollock. And we walked through, with your Honor's gracious indulgence, we walked through specific sentences and paragraphs where that pattern recognition methodology is stated. And here's a key. Remember, please, the word pathognomonic. This
Well,
pattern
damn it.
is so specific
Remember,
that
please,
it
chat.
almost by itself rules
Word of the day today is pathognomonic.
out anything else. That's the definition of
Today's stream is
pathognomonic.
brought to you by the letter P.
And that's the definition. And
And the number
Dr.
3.
Russell used highly characteristic, but she did note and explain what another study said was pathognomonic. It's incredible.
Pathognomonic of a sign or symptom specifically characteristic or indicative of a particular disease or condition. Pathognomonic. There we go. Never forget.
To me that it can be stated that there's no methodology here and that there's no basis for it.
Because
It
it's
is generally
pathognomonic.
accepted in the medical community. That's the purpose of the Pollock and the Demunic article, is to establish that
I do like it
is
better
accepted.
than nutraceutical, I will say.
Dr. Russell is not coming here to the court and just testifying, it's my subjective empirical statement.
Can we leave the
Mr.
victim's mother
Brennan
alone and go back to the
tries
attorney?
to do in his argument exactly
This attorney's arguing incredibly well. Can we just show him, please?
what an expert rejected and for which he has no support. And that is to say, we got to look at these wound by wound by wound, and he said 0, 0.
I was just asking if we had the old one, but no, we're all good. We learned a new word, Dr. B. Not incisor, pathognomonic. Don't worry, I'm not asking you to define it. We're listening to their final arguments. So good to see you. Thank you. No, but it's okay. Thank you.
0, 5 times 0 is 0. He tried that on cross. Dr. Russell rejected that resoundingly. She said, you're missing the point. The point is
Just
the
show
pattern.
the attorney,
you look
please.
at these all together, and it's the pattern that matters. And the
Dr. Bisa.
authors, Pollock and Demunick, say that pattern is pathognomonic. You really don't even have to go to other causes, although Dr. Russell said she did because that's what good, thorough doctors do.
He sounded out pathognomonic well enough that I could spell it close enough to
that
put it
Dr.
in
Russell
dictionary.com.
didn't explicate a methodology. It's incorrect that she didn't explicate that there's a rooting in the medical community and that it's generally accepted. Now let's go to the cases. Mr. Brennan cited to a paint case, etc., but interestingly, and in contrast, in our papers, which Mr. Brennan has had for almost a month, and he didn't respond, interestingly, we cited to the Lobello case,
Interesting.
the Brinker case, both of which are dog wound injury
lawyer
cases, not
argue.
paint cases. I know a
wanna see
little
the
bit
lawyer
about
and the
Lobello
judge.
because I know a little bit about the firm that sponsored the expert in Lobello. It's my firm, my law firm. And
Okay.
the exact argument that Mr. Brennan just made was expressly rejected by the court on a dog bite case, a dog wound case. Here's what the court said. The court finds that Dr. Sirota qualifies.
For everybody asking, why did this attorney come into this case? Why this defense attorney? Why now? Well, his firm was part of a case that went all the way up to be evaluated to the point that it's a reliable published opinion and an authoritative published opinion regarding what? A dog bite. A dog bite. Let's go back to this attorney talking about case law, please.
Qualified as an expert on the presentation. This is on Westlaw page 10. The court finds Dr. Sirota qualified as an expert on the presentation, treatment, and medical sequelae of an attack by a dog. Here's the key. As explained in his expert report, Dr. Sirota has personally repaired thousands of wounds and lacerations, including wounds and lacerations caused by dog bites. And he's authored a number of peer-reviewed articles in the areas of his certification, et cetera, et cetera, et cetera. And so
the wandering camera is killing me. Here's the thing. The criticalness of this argument can't be understated, so I'm going to take a second to pause because courts don't want to do something weird. A court doesn't want to be the one that does something different, something strange. They don't want to make the appellate court go, They want to do what the courts before them have done and be like, well, these other courts have tread this road. We are not taking the path less taken. We are going to do what other courts have done. Don't be weird. And what he is saying to the court is, hey, my firm and I did a case that is authoritative and published, and you can look at how that court decided that this expert was an expert in dog bites based on his medical background. So you don't have to do anything weird, Your Honor. It's not different. It's not unique. Other courts have tread this ground, and it doesn't come up a lot because there aren't a lot of cases where dog bites are going to come up in the criminal context particularly. It's not going to come up all the time, but it has come up with other courts and they have allowed it. So what we're asking you to do isn't weird. We're not telling you that this is something so esoteric that no one could ever derive that an injury came from a dog bite. No, it's not weird. We're not trying to, do hair analysis. We are doing something that is done in courts when it comes up and is allowed. And look, this court allowed it, and this is why. So it's giving the court the background that the court needs to know that this is not something that's weird. Other courts have allowed it in. And do you know what happens if other courts have allowed it in? It means that there is a methodology because other courts have evaluated these factors too. And this judge has done it before. He started his argument with, Judge, you've allowed this in before. And here's how other judges allowed it in.
certification, et cetera, et cetera, et cetera. And
That's a very important case to cite.
There is a dog bite case from the Southern District of New York, not an insignificant court, as recent as 2023.
Not insignificant. Yes,
saying a doctor.
What did he say? Oh, he just said he was practicing in the Southern District of New York, which is what? Federal court. So when Emily's like, I wonder how much he does federal court. He argues like he argues in federal court. This makes so much sense, which is why he said, so weird the prosecution never mentioned this case. They're over here talking about paint.
Doctor that sees and treats all these, that's reliable. That's,
want
and
that
this
case.
was a Daubert challenge, Your Honor. This wasn't an incidental
Same
question.
thing we're doing here,
The
Your
challenge
Honor.
was defendant's motion to
argument.
preclude expert testimony, albeit federal rules of 702, but we know in Massachusetts it's
702
Daubert,
is the
Lanigan.
same.
You can satisfy Daubert, the federal, but you also Lanigan, and under Davis, you can have generally
702 is
accepted in
same.
the medical community as well. There's one case. Another dog bite case, we cite Brinker, that Mr. Brennan didn't address.
Did anyone
Is
catch the case site? Will
a
you
federal
drop it in
court
the
case
chat?
in Indiana where the same challenge to a doctor about the cause, and it was italicized, the cause of the injury to the person there. And the court basically said in that case that this expert here, and they challenged the causation issue, said that doctors who have experience in treating them, that's enough in and of itself. We don't need to go into, we know Daubert's flexible. You don't have to use all 5 factors. They're called non-exclusive factors for a reason.
It's true they
which is a
are.
good segue now to Massachusetts cases.
Your Honor, Southern
Mr.
District of New
Brennan's
York does
hypothesis
it.
is that you can't just have somebody use their years and years of experience. You've got to have something more complicated. We cited the Goodman case, a Massachusetts case, and I'll read the relevant portion. The challenge in that case was to a burn pattern. So it's not a dog bite case, I want to be clear about that, but it's a burn pattern. And here's what the court said. The foundation for Slowick's methodology, that was the expert here, was simplicity itself. Examine the exterior of the facility for external causes, and finding none, examine the interior of the building to locate the origin of the fire by following the burn patterns. And the court put by following the burn patterns in italics, not me.
Pattern recognition.
And so the court basically
She's
said,
reading what he's talking
here, it's simple. Just look at the patterns. This person has experience with seeing these patterns. Next case.
What? No. Where did the rest of the argument go? Oh, that was unacceptable. Hold on. Let's see if it was just the feed cutting. Let me jump back to, hopefully this is the right part. That was terrible. Let's see. I'm going to back up to try to get to where he was in his argument. Well, I will be saying I'm glad they were focused on the judge because it makes it easier to zoom. But yes, we picked a feed based on closed captioning, and sometimes it bites us because I think their feed probably just ended.
For almost a month, and he didn't respond, interestingly.
All right, we've gone a little too far. Let's zoom.
The issue there, not a dog bite case,
Okay,
I've already
there
given
we
you
are.
2, but a firearm examiner in that case. The court said, and I'm going to quote, a judge may also look to his, let's get it correct, her, for this case, own common sense, as well as the depth and quality of the proffered expert's education,
And we've seen
training,
this
experience,
in the law in
read on,
Massachusetts.
to determine reliability. All right? So even in situations where courts have repeatedly said, including dog bite cases, if a doctor has repeatedly looked at, treated, etc., they get to testify with regard to whether they believe a wound is caused by whatever. And in the 2 cases I've given you, dogs. So the law is very clear for what the position is of the defense with regard to methodology, and that's what this hearing's about. That's why we're here. Is her methodology reliable? And there is one methodology. There's a pattern methodology. She testified to it. And the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me
No doctor.
that we're being
No
faced
affidavit.
with the challenge to whether the defense could put up a defense and put up a witness when there's no opposition to her methodology from, as your doctor has, or your honor has required, a medical doctor that is required under law in Massachusetts.
That's a fair argument.
I also, Your Honor, want to go to now what the Commonwealth has argued in its papers, which I think further underscores the waywardness of their argument. On page 11 of their papers, the Commonwealth further attempts to criticize, or excuse me, what we said in our papers on page 11, the Commonwealth further attempts to criticize Dr. Russell for being a, quote, trained emergency room physician as opposed to a professional in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behavior.
Well, right.
How does that square with
Doesn't
your
matter.
honor's standard that it must
Yeah,
be
the
a
defense
medical
attorneys are
doctor
tired.
that speaks to the causation of this injury? By definition, a veterinary medical science person is not a medical doctor.
And they're not.
A forensic odontologist, most always a dentist, is not a medical doctor. And certainly
Dentists don't see a
canine
lot of dog
behavior. And
bites.
why are those words there? Because that describes exactly the expert that the Commonwealth has sat on since the trial, Dr. Cosby. That's him. And in the book that Mr. Brennan attempted to use, Dr. Cosby has
There's
written some
another
of those articles, interestingly enough, citing the very articles that Dr. Russell relies upon for the very pattern methodology. So again, the waywardness of the Commonwealth's argument is they're not addressing the need to have a medical doctor. We are not here arguing over whether the dog behaved correctly. We are here to determine, and this is the focus.
What happened to the arm?
What is the medical cause of the injuries to the decedent's right arm? And what we have done, perhaps too thoroughly, is we have established the credentials of Dr. Russell, not only with regard to dog bites, but with regard to medical causation, a broader umbrella. And under that umbrella of medical causation is expertise in dog bite wounds, expertise in motor vehicle accidents, but importantly, expertise in wounds caused by motor vehicle accidents. We never presented her as an accident reconstruction because if you need to be a
But she's
medical
not.
doctor to be able to opine on these wounds, I've established through Dr. Russell, and it's unrefuted by the Commonwealth, that Dr. Russell has never heard of someone who's an ER doctor who is an accident reconstructionist. They're two different disciplines. And
Right.
lastly, on this point, before I move to my next, if an accident reconstructionist is going to come in and try to testify about the nature of wounds, I think I can predict what Your Honor might do.
Because
So,
the accident reconstructionist
in
wasn't allowed
terms
to
of-
do that in the first trial. The accident reconstructionist was allowed to talk about mechanics of accidents, but weren't allowed to give medical opinion. That happened in the first trial.
Why
100%.
we are
Thank you, Chad,
here.
for providing what looks like the site for that case.
It's
I appreciate it.
straightforward. Her
Thank you, Lori.
credentials are enormous. Her experience is enormous. She has been truthful and honest. Your Honor has the notebook for the exhibits for today and can look and see that she did not make inconsistent statements. By way of example, when she said, when it was alleged that she said possibly was in the question, not in her answer. When it was alleged that she didn't answer your question to a medical degree of certainty, we proved that that was wrong with specific language. So on the methodology, this is straightforward. In the law, in the cases I've given you, in Massachusetts as well as dog bite cases, it is completely accepted for a medical doctor to use their many years of experience in treating these types of wounds, and that's exactly what Dr. Russell did in this case. Now, a very important, in my judgment, Your Honor, legal point. The Commonwealth has waived its entire motion, and here's how they did it. I asked Dr. Russell what I refer to in these Daubert hearings as the magic question. I said, do you have an opinion on the cause of the injuries to Mr. O'Keefe's right arm? Yes, I do. What is that opinion? I believe that those wounds were caused by a dog attack. Do you hold that opinion to a reasonable degree of medical certainty? I do. The Commonwealth never objected to that question. To me, that's a waiver of the entire issue. If they thought she was unqualified to answer that question, they should have done what Mr.
I don't know
Mallory
if that's
did
going to work.
and the June 21st trial.
And objective.
Because another part I've got in the notebook for Your Honor to see is she never got the opportunity at the June 21
It's
trial
worth raising.
to answer the question of whether she had that opinion to a reasonable degree of medical certainty.
I mean, the
because
motion's the
Mr. Lally
objection.
objected, as is his right, and Your Honor sustained it, and sustained it, and sustained it. That's yet another reason why it's not inconsistent.
pointing it out for the appellate
because at the
courts
June 21 trial,
later.
she never got to answer that question because of the Commonwealth. But back to the waiver.
It's a good argument.
The
gonna
Commonwealth
be the
should
most
have, at
persuasive
that
argument.
moment in the hearing,
But he's saving
objected,
it.
but they didn't, and they have waived that objection for this motion. Lastly, I want to just cover a couple more items that Mr. Brennan had quickly. He kept saying, can't be, equally basis, evidence wholly contradicted. Where's the medical profession to support that? Those are Mr. Brennan's opinions. And respectfully, Your Honor, I don't believe that's even for the court in this hearing to decide. That's for the jury to decide. As almost all of these cases go to, the Labello case that I cited, those arguments go to the weight of the testimony. They go to cross-examination. As Your Honor well knows, you're the gatekeeper to see whether Dr. Russell gets to go to the jury, whether you're going to keep that gate open that I believe you very carefully and judiciously decided on June 18th. And I respectfully submit that gate should be much wider open now, given what Your Honor has heard and the basis for it. But even if Your Honor might be inclined to be interested with, maybe even persuaded by some of the things Mr. Brennan said, those have nothing to do to whether there's a methodology or whether it's reliable. Those are easily answered by DeMunick and Pollack. And that's the end of the inquiry. Everything else is beside the point. With regard to the DNA that the Commonwealth has tried to make so much about, there was only one reason why that was brought up. It was brought up because Dr. Russell answered she didn't need to know much about the DNA. Why? Because the pattern of the wounds are so highly characteristic of a dog bite and a dog attack, and because the authors used the word pathognomonic. But because she was careful, she went through a differential diagnosis.
We're getting our SAT
But
words
she was
today.
consistently honest and forthright. When she didn't know something, she said so. So in terms of this particular matter, and I'll conclude my points at this point and keep to below the 20-minute mark.
30 minutes.
I'm sorry, 30-minute mark. The tremendous importance of a defendant's right, especially in charges of this seriousness, to present a defense, to present a counter-argument to the whole theory of the prosecutor's case. Their theory is that a motor vehicle hit the decedent and caused these injuries to the right forearm.
Yes.
The presumption should be the defendant gets the the right to present evidence. Now, they don't have an absolute right. You got to satisfy Daubert, but I believe the satisfaction on the crucial inquiry of qualifications and then the methodology and reliability is overwhelming. So, Your Honor, I would urge that Your Honor find that Dr. Russell is qualified. She's qualified as a medical causation witness, which has her able to not only testify at trial with regard to whether those wounds are caused by a dog attack, but also she can testify, and she's qualified to do so, that it's not from a motor vehicle accident, and she's also allowed to testify with regard to her forensic pathology hat, because contrary to the impression of the first in June, she's been doing forensic pathology as recently as her time at Corcoran. And my last point, Your Honor, is this, and it blends in with the point I made earlier about the jury. Shouldn't a jury be able to hear the alternative theory of the defense? Shouldn't the jury have that information so that justice can be served, so that the best decision can be made about whose theory about these injuries is right? We've satisfied beyond my view, respectfully, any reasonable doubt about her qualifications and methodology. Let's let everything else go to the jury and decide, so Ms. Reed can have her fair day in court.
Okay. Thank you. We
And
have
they're
some
gonna be done.
scheduling things that we
Scheduling.
should take care of. There's another motion from the Commonwealth on another Daubert hearing regarding the digital evidence expert.
There is, and also, I don't know if it's docketed, but I filed a notice to the court regarding my concerns about ARCA witnesses, and the reason I filed that prior to filing an actual motion is because I appreciate the trial court date, and I do not want the defense to be unaware of my intention.
And yes, you heard the court correctly. There are also motions for Daubert hearings with regard to the digital forensics, and one filed today with regard to the crash reconstructionist from the FBI investigation. All right, so let's see what they are going to do with the Daubert hearings.
All right, so
And the
let's set a
scheduling.
date for a Daubert hearing.
We're doing this again with
Any
digital
idea how long you
first.
expect it will take regarding the digital evidence expert?
Well, Your Honor, when you say that a Daubert hearing, you don't mean an evidentiary hearing. You mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can
What?
set
I can't do
it,
it tomorrow.
or, well, then we'll stay now and do that.
What?
Are you ready to do that, Mr.
No,
Jackson?
we just
Then-
got this on, we just got this on,
What is with these judges? We'll just stay and do it now. What the fuck? No. No. We have to talk about Blake Lively tomorrow, Your Honor. What are you doing? And she's like, can we do it now? And AJ's like, no, we just got it. This happened over the winter break. We're going to have at least 2 more Daubert hearings. But they're talking about different things. The court, AJ said, are we talking about an evidentiary hearing, or are we talking about a hearing to see if an evidentiary hearing is necessary? All right, I'm going to let them finish up the court day.
Expert.
well, Your Honor, when you say that a Daubert hearing, you don't mean an evidentiary hearing. You mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can
Well, I can't-
set
I
it,
can't do it tomorrow.
or, well, then we'll stay now and do that. Are you ready to do that, Mr.
No,
Jackson?
we just
Then-
got this on January 31st.
Okay.
We have not had an opportunity to respond.
December.
December 31st, probably.
What did I say?
January.
Yes. On New Year's Eve. We've not had an opportunity to respond to it. We
Okay.
expect to have an opportunity to respond to it.
How
in the
long will it
courts.
take you to respond to it?
Probably a couple weeks.
All right, so what I want to do, because I want to set some dates, and if we're not going to have a hearing, we'll cancel it. It's easier than getting the motion, deciding that there'll be a hearing, and setting a date, because we're sticking with that April 1st trial date.
I understand that, but the problem with setting a date for a hearing and an evidentiary hearing requires us to bring someone in from out of state.
No, so what I'm saying is, file your paperwork.
Okay.
All right? We'll set a date for a hearing.
Okay.
We'll set an evidentiary hearing date. I just want to lock those in. I'm trying to do them on Mondays or Fridays for you, thinking that it would be better for your schedule if we tried to accommodate that. But we've got a full session, so.
Mr. Brennan and I talked briefly, I don't want to speak for him, but we talked briefly about the January 27th date. I think all council have that date cleared because it was a trial date at one point in our history. So what about the 27th for the motion on Mr. Brennan's Daubert request?
On all witnesses, not just, you said you're filing.
The only one he's got is for Rick Green.
He filed one
What did
today.
you file a notice of, you said today?
Notice that I expect that I will likely move to exclude the ARCA witness for failure to comply with Rule 14. It's not a Daubert hearing.
Okay.
It's compliance with Rule 14.
Okay, so that's different.
Yes. I am waiting for a response from the United States Attorney's Office that I'm supposed to expect next week.
Okay.
If that changes my position, I'll notify the defense and the court. If it doesn't,
So he's asking to exclude the experts from the feds, the ARCA experts, the accident reconstruction biomechanical crash daddies. He's asking to exclude them based on Discovery Rule 14. That's different than a Daubert motion. So he filed notice to make a Rule 14 motion. So it's a placeholder. He said, I've asked for more information from the U.S. attorneys. I filed notice of a Rule 14 motion. So he is reserving the right and giving proper notice to bring that motion. So we don't have enough information on that yet because that's notice of a motion regarding discovery. So we're not there yet. So Rule 14 is going to deal with discovery, not dealing with Daubert, which is scientific process and whether or not an expert has sufficient scientific process. Okay, let's keep going. All right.
then I'm going to pursue that motion.
Okay.
Aaron, may we be seen briefly at sidebar scheduling?
Okay, so now there's two things. I should have just waited till they went to sidebar. Emily, keep reading. Just keep reading. That's what I want to do. That's what I'm going to go do the rest of the evening. We're going to be reading, and then we're going to be in court reading. Well, we're going to be reading filings tomorrow. I want to see if they give us a date. It sounds like it might be January 27th. So we'll see. I don't know. I'm not going to cover their Rule 14 notice now. It's Rule 14's regarding discovery in Massachusetts. It's a notice of motion. It's not even the full motion. So we don't even have grounds. We have a, hey, we might do this. So there's no further need on that. I just want to see what date they're coming back. I think it's going to be the 27th. So let's see. I'm trying to get to where they're back on the record to see if the court puts the next date on the record so I don't have to go dig through the docket for it. All right.
Clear. The 31st will be oral argument at 9 a.m. And if there's an evidentiary hearing, it will be conducted on February 6th. We'll block off the day. And February 7th, and we'll also hear the ARCA motion if there's something on that. So we'll go for the 6th, but we'll leave time if it carries over so we don't have what happened with Dr. Russell, such a big gap in between. Okay? All right, we'll see everybody then. Thank you.
All right.
Here the A.
I'm just going to make sure we have all the dates, and then I'll go to the docket too.
First will be
So January 31st. I don't know if they'll also do the 27th. So January 31st.
clear. The 31st will be oral argument at 9 a.m. And if there's an evidentiary hearing, it will be
So that's a
conducted on
placeholder,
February
6th and
6th.
7th.
We'll block off the day. And February 7th, and we'll also hear the ARCA motion if
Okay.
there's something on that. So we'll go for the 6th, but we'll leave time if it carries over so we don't have what happened with Dr. Russell.
Okay.
Such a big gap in between. Okay?
Okay.
All right, we'll see everybody then. Thank you.
Thank you.
All right, those are our next dates. All right, so next dates on docket. Well, let's give a summary as they're exiting court, and we'll get to the next dates on docket. So we will get there. Angie's, it seems that there's some confusion, but we will talk about it. No, that's not what they are saying in the question from the chat was, so I'm hearing this right, ARCA is good for Fed but not state. No, they are saying that they have a discovery issue with regard to the experts that testified in the first trial from ARCA. So that is different. All right, let's do a summary of what happened today. It was a lot of a day. Let's do a summary. We'll do some questions. And then after almost 6.5 hours of streaming, we will take a break because we are streaming again tomorrow because we are now on our Tuesday, Wednesday, Thursday shit. And I am very excited. 3 days a week of streaming. Tomorrow we will be streaming. This week, though, we will not be streaming on Thursday because I am going to stream Friday because I want to cover the oral arguments at the Supreme Court regarding TikTok. Unless that date moves, I don't think that it will. But unless something happens, and then we'll stream Thursday instead. This is why you need the Lawnerd app, because if you have the Lawnerd app, I can just tell you when our schedule changes because court dates change and the things we're covering move quickly. So if you do not have our free app, the Lawnerd app at lawnerd.app.com, go download it for iOS and Android. Make sure to check your notification settings. Let's do a swoop and a summary to the best of my ability after a long day in court, because that is sure what it was. What a very busy day in court for the Karen Reed retrial. Today was that is not helpful. This is why I should mute the feeds before YouTube autoplays something. Today was the second part of the Daubert evidentiary hearing regarding Dr. Russell. Dr. Russell testified in the first trial regarding the injuries to victim John O'Keefe's arm, testifying that they were most likely from dog bites. Her testimony was fairly limited. Some of that was due to discovery and the fact that she was discovered as a witness in the middle of trial, and it didn't give the Commonwealth a lot of time to find another expert and rebut her testimony, and her testimony at that trial was limited. The special prosecutor has been brought into this case for the retrial, has brought a motion to exclude her as a witness, and argued and made some good arguments in his final arguments to the court that there is no scientific process here, saying that this is not something that can be repeated, that this is not something that's widely accepted within the community to recognize dog bites through pattern recognition. Of course, when the defense made their arguments at the end of the hearing today, what they said is, well, Your Honor, in other courts, and let me show you the rulings on the other courts, other medical professionals have been allowed in to give this testimony because they have treated wounds from dogs and are able to look at a wound and say, this is a wound that if it came into my ER, in my experience, I look at that wound and go, that is a dog bite. We need to treat it like a dog bite. That wound did not come from a vehicle collision. And the defense is asking that Dr. Russell be allowed to testify to not only that the wounds on John O'Keefe's arm were from dog bite and dog scratch marks, but from an animal attack, and that those injuries do not come from a vehicle collision and are not consistent with a vehicle collision. That is what they want to use this expert for. The arguments at the end I thought were quite good, though the prosecution did spend more time going after the qualifications of the expert than I thought they would, which was surprising because the question here for me isn't whether or not she's qualified, it's whether or not the process of recognizing dog bites, and dog attack marks are something that is recognized within the medical community as something you can look at and recognize. And it seems from the defense and their case law that it is, because medical professionals have to be able to look at injuries to a human and go, that's a dog bite. We'll treat it like a dog bite. So the court is going to decide not only if Dr. Russell is allowed in as an expert in the next case, but also what opinions Dr. Russell will be allowed to give if she testifies in the retrial. At the end of the hearing today, we also heard scheduling for the oral argument to see if another evidentiary hearing, another Daubert evidentiary hearing will be had regarding the defense digital expert. And then there are Rule 14 discovery motions with regard to the ARCA experts, who we on this channel called Crash Daddies, who did the accident reconstruction and the biomechanical engineering information. They came from the FBI investigation into this case. Some other things that we learned. Guess what we learned today? Well, today we learned that the prosecution actually went and found Chloe the dog and did measurements of Chloe's claws and paws and did, they said, molds and casts of Chloe's jaw and bite. And the defense expert had not seen those, but was aware that that had been done. So the prosecution continues to do investigation into this case, including finding the dog and then doing measurements and molds of the dog. Whether this information will come in at the second trial, we don't know yet. If there's going to be a evidentiary hearing on this, we don't know yet. But that was new information to me in this hearing today. We also learned today that there was another expert from the federal investigation. It seems that that expert is a pathologist that looked at the wounds to the victim, John O'Keefe's arm, and said that they did not believe that those were animal attack or dog bite or scratch marks, but also that the injuries to John O'Keefe are not consistent with being hit by a car hard enough to cause the injury to the back of the head that caused death. So I don't think we're going to see that expert being called by the prosecution, because even though they say, I don't think the injuries to the arm are from an animal, they also say, I don't think the injuries to John O'Keefe indicate that he was hit by a car, which is consistent with the pathologist in this case that did testify. A lot of new information we learned today for sure. And that is why these hearings, though they can have very slow and dry moments, also have so much information. It's clear that this second trial of Karen Read under the direction of Hank Brennan is going to be a very different trial than the first trial of Karen Read was. And we saw that in the way he proceeded in court, and while made some good legal arguments, also brought in a whole lot of snark. It's going to be very interesting to see how this goes forward, but we're going to have a few more court dates to go to see the evidentiary hearings in this case before it goes to trial in April. We've been assured it will be a shorter trial when it goes to trial in April. I don't believe that for a minute, but we'll see what happens. We do not have a ruling yet from the Supreme Judicial Court regarding the jurors in this case, so that is still pending. We do not have a ruling on this motion today and probably won't have a ruling before the next hearing. And we will be back in court on the Karen Read case, it looks like at the end of January. And with that, let's get to some questions. Lawner, you've got questions, I've got questions, we've got questions. Let's back around. All right, let us get to all of the things. Megabo in the chat said, I've been listening in the background all day, just now sitting down to watch. Did EDB get a new camera? The picture is so crisp. I did not get a new camera. I did get a new desk, so it changed the position of my camera. I changed around all my lighting, so everything is a little bit different, but not a new camera, just a different setup and different positioning. So I'm a little closer to the camera than I was with my prior desk setup. So that I'm going to keep working on the lighting. We'll continue. But for now, we are happy with it. It is less reflecty in the glasses, which was a huge thing that I was trying to accommodate for. So let's get to some questions, and then I am going to get to, well, probably playing some Mario Party with my kids because it was a snow day today and they are all home. So I would like to see this. I would like to see them. Mike Roll in the chat asked, and thank you for the super chat, do these judges handle other cases? Yes, lots. How do judges find the time to hear all the cases? They schedule them in advance the best they can. I have so many questions about how the judicial system handles all the cases in front of them, often with a lot of exhaustion. It depends on the jurisdiction, but yes, this judge set aside a whole day today, and then we'll have a full day of cases tomorrow. It is quite a lot of work depending on where you work. There that will hear a couple cases a day. There are courts that will set aside a full day of arguments. There are courts that are going to hear 20 cases in the morning, start a trial in the afternoon, and do it again the next day. So it really depends on your jurisdiction, how the courts operate, because they all operate differently. But yeah, it can be incredibly busy. Like master arraignment courts, depending on the jurisdiction, will go through 80, 100 more cases a day, but in a smaller jurisdiction might only do 2 or 3. So it really, really depends. But yes, this judge has another caseload of cases. And in Massachusetts, it's really interesting to me how the judges circuit, because they docket through criminal and civil, which I can't even wrap my mind around. Like once you're a judge assigned to criminal, like your brain is kind of in the law of criminal, which is different. The criminal procedure is different. There are different things going on in criminal than in civil. And then they rotate them into civil. And it's like, oh, hey, now you're in civil. It's like, wait, what? Wait, we were just doing criminal. It's different jurisdictions do it incredibly differently, but the circuiting through criminal and civil as a sitting judge would make me bananas. It's like, could you just leave me in criminal? And especially criminal attorneys who become judges are like, what do you mean you want to put me in civil? And then civil attorneys who have judges that were in criminal their whole career are like, what do you mean you were in criminal your whole career? No, that's not how any of this works. But it's also like the civil case log in California is exceedingly backed up. So if you're filing civil cases now in California, especially in Los Angeles, you're going to get a trial date 2027, maybe on calendar. So it really, really depends. It really depends. Lizard, good to see you in the chat, said, thank you for such a long day. We love you. Look, go big or go home, right? We're coming back for a full court day for the first stream back from the new year. Can the prosecution admit things like the dog into evidence only to prove the defense wrong? Dog bite is not in their case. They can use it as rebuttal evidence. They can use it in their case in chief. The prosecution can try to make the defense theory a sideshow. They have to be careful not to burden shift onto the defense. But the defense did that a little bit themselves in the first trial, where the defense pulled the focus onto their theory. I want to see the defense in this case really push the focus on the prosecution's case. Not just, we have an alternate theory, but really use their perspective of the case to poke holes in the prosecution case, to keep the focus on what did the prosecution prove, not to put the focus on what did Jen McCabe do or did not do. The focus on the case got so much into proving or disproving the defense theory that it moved a bit from, did John O'Keefe get hit by a car? And that, I think, is the stronger focus in this case. And I know people want to go down but what happened to John O'Keefe rabbit hole. I will just remind everyone, the prosecution has to prove their theory of the case. Everything outside of, did Karen Reed hit John O'Keefe with a car, is outside of that. And if the prosecution can't prove that clearly, distracting with everything else that might have been going on and who said what and who did what and all of that, I think is a distraction when the pathologist from the case, the prosecution's pathologist, says this victim's injuries are not consistent with a motor vehicle accident. I think the defense should keep pushing into what did the prosecution really prove, instead of, well, did this witness do this and did that person Google search that? I would like to see this case pared down. But again, that's the defense's choice, and that's partly the defendant's choice. But I think poking at what did the prosecution prove or not prove is a strong case. I think once you get into everything else, it can get confusing. And I don't know if it helps them, but the defense has the opportunity of taking a look back at the last trial. And if the defense wants to, they could. If the defense wants to fight all this and build all this up and keep the prosecution running down these witnesses, and then the defense doesn't want to put these witnesses on in their case in chief, they can choose to do that too. So they can run the prosecution down on all kinds of, rabbit holes, and then turn back around, get into trial and be like, everyone that comes in to testify in this case is going to tell you that John O'Keefe was not hit by a car. And the prosecution can't prove to you that he was. Period. And they can do that too. So we'll see what happens. Casey Cat, thank you so much. I love that you guys love the new setup. Yay! It took the entirety of break to set up the setup. I am bruised from building a desk. It took time, but I'm now redoing the bookshelf. We're now on a side quest. Look, the ADHD side quests of redoing my office have side quested me so far down another rabbit hole. And Brian's like, you can't paint your entire office right now. You need to be ready to stream. And I'm like, but I want to rebuild my bookshelf. I want to paint I want to do everything. He's like, we need to be ready to stream. You do not have 2 months to just redecorate. I'm like, we're going to do it piece by piece. Music to My Soul said, prosecution, basically, if the dental mold does not fit. Oh, that's not the standard. Did I get it about right? That's not the standard. And it's also not the focus of the case here. The focus can be, hey, did John O'Keefe get hit by a car? Everyone says no. The injuries to the arm can be from something else. And that is something they can focus on. Jiki Masuki in the chat said, finally less glare in your glasses. The reflection in the previous setup was painful for me. It was painful for me too. So taking the time to do it was needed, and I appreciate it. So Christina is talking about bully sticks in the chat. Thank you. Annie said, is the result of this motion subject to appeal? Yes, it is. Whether it'll happen before the trial or not, we'll see. But yes, it is. Brendan said, thanks for the coverage. Thoughts on Honey? Oh, bitch. Do I want to talk about Honey so bad? Attorney Tom has a great video on it. It will probably end up in quick bits just because of how much court we have this week. But yes, I have thoughts, but it'll probably be thoughts in quick bits because it's really interesting to me. So yes, but Attorney Tom has a great video on it. So if you want to go watch Attorney Tom's video talking about Honey over on his channel, go watch it. So he is the attorney that is suing PayPal in a class action. We'll go over the suit if you guys are interested. I'll do a quick bits. It'll be in quick bits, and then I will go into it. I will go into it more if we have time, because there are so many lawsuits right now in the Blake Lively stuff, and I am so behind on Diddy Jay-Z stuff. There is so much that's fucking happened. So taking a break, all of you who took any kind of a break over the holidays know the feeling. Anytime you've ever gone on vacation, you come back and your email's just like, hey, did you enjoy being away? Here is a flood of things to do. The law was like that this time. It was like, people were filing shit on Christmas Eve, on New Year's Eve, on all the rest of it. They're like, here's all of it. I'm like, God damn it. All of you need to take a break. We all need a break. Can we just take a break, please? But no. So there is so much to cover, and I want to do the Supreme Court TikTok arguments this week, and I want to talk more about all of the intertwinedness of the Blake Lively Baldoni stuff. We haven't gotten to do a deep dive on that yet. For those of you in the chat asking, what is Honey? Honey is a scandal at this point, but Honey is a browser extension that worked with a ton of YouTubers, sponsored a ton of YouTubers, and another YouTuber did a really deep dive investigation to find that the browser, they say, was switching out affiliate codes. So if you had the browser and you hit an affiliate code to go buy, something or download something, Honey switched the affiliate code. So any creator that uses affiliate codes and their audience also had a Honey browser, they would not have gotten the credit, and then Honey would have gotten paid. It's more than that. That is a very simple overview, but Attorney Tom is suing about it. Legal Eagle made a video saying he was suing. Attorney Tom's actually the law firm that is suing. So yeah, not the delicious sweetener from bees, but a browser extension owned by PayPal. So Mel, thank you so much for the compliment. Mel said, EDB, you're the only person I'll follow for Lively Baldoni. Everyone else is emotional and taking sides and going with vitriol on both sides. Yeah, it's a hard one because it's so divisive. But I think evaluating the lawsuits for what they say in the lawsuits is important and valuable. And I think being able to bring the temperature down and say, let's wait to see, will be helpful. So I am always in everyone's going to have an opinion. I want to see what comes out in the lawsuits. So my opinion is I want to see what comes out in the lawsuit, and then I have questions, which is really how I approach most things. I have a lot of questions about this case. I have a lot of questions. I still have a lot of questions. After a trial, there shouldn't be this many questions. So I have questions, and I'm angry about how many questions I have in this case. Like after an entire ass trial, what, 8 weeks, 9 weeks of trial? I want to have less questions. I want to have less questions. I want to know more than what the layout of tables is at the frickin' waterfall and how much it was snowing. I would like to know more than that. But I feel like that's what I know at this point. This is a great question. How did your nails survive the new setup and side quests? Not well. I lost a few little sparkly bits, but also I asked for help when I needed it and I used tools. I also got my nails done after most of the desk setup was done. So, and then I took them shorter to kind of help, but I lost some of my little glittery bits, but that's okay. I thought that might happen. So, we'll see. Let's continue on. And snow, high tops, the basketball game, who was sitting where at the basketball game, that the Colokeithuses are kind of goals. I enjoyed them very much. But the main questions are still questions, which frustrates me. J. Michael, good to see you. Going to catch up on replay while Jade is at gymnastics. Excited for a day at Animal Kingdom with friends tomorrow. Enjoy the day. I'm sure it's warmer in Florida than it is here in Tennessee. Jilly Bear, good to see you. 25 months as a law nerd. As a law nerd member. Congratulations. So yay. Beth, good to see you. I just got around to looking at the special gifts from the launch of the new shop. Isn't it fun? It's fun. Am I going to Go Fest in New Jersey? I need to take a look at dates because I suspect that will be during trial. But I'll take a look. I need to take a look at the calendar. It's Always Sunny. I'm sorry that oh no, yay, fourth surgery of the day was canceled. All good. So you get to come in and see the law nerds. I read that wrong at first. It's like, well, when your own surgeries get canceled, it can be very frustrating. But when work surgeries get canceled, it's like, hey, now I've got a minute to myself, which is delightful. Let's see. Victoria said, and a lot of the chat said this again and again and again and again, but sir, have you seen your qualified experts? Yes. The arguments regarding Dr. Russell are kind of in a vacuum. We will see how it goes as we get into the prosecution experts. I don't think we are going to see motions to exclude the prosecution experts because it goes to the defense theory of the case when you bring in Trooper Paul and he's like, there was a pirouette in the crime scene, talk to me. Like you don't get better than that as a defense attorney when you have someone who's supposed to be an expert and they're just like, it just spoke to me. And you're like, is that your testimony? What? When the experts from the state or the Commonwealth can't explain the core fundamentals of how the case happened, that is a problem. And that's why we're not going to see the defense being like, this isn't an expert. The defense is going to look at the jury and be like, really? That's how they're going to do it because it feeds into their theory of the case. So that is what it is. Cheryl, thank you so much for the super chats and the compliments. I don't know about that. I've just done this a long time and I like looking at the law and I like evaluating what is being presented. And I think I can do a pretty good job of narrowing down to the facts we're looking at right now and keeping that in a vacuum. Is this something that's going to come in right now? Brennan made some good arguments. I know y'all don't like him, and it's okay to not like him. It's okay to find him off-putting. A jury might find him off-putting. He made some good arguments. I think the defense rebutted him incredibly well, and I think Alessi took a very, very good approach in saying to the court, look, Your Honor, you found this expert an expert over the summer. And you know what, Your Honor? You were right. We would love it if you just keep being right. Because look at how smart you are, Your Honor. Look at everything you said. You were so right. Keep being right. And I think that goes to the defense's benefit here, is that the judge ruled in their favor before. I don't see her saying, I shouldn't have done that then, so I'm going to do it differently now. So I would be surprised if that was her ruling. I also think the defense made a really strong point when they said, this is all just Brennan saying shit. Like, he's just saying stuff. But where is the medical expert to say, this is not accepted? This is not how it's done in the field of medicine. Where's that person? We just got his opinion. Ugh. And I think it was a solid point. So we will see. We will see what happens. Elizabeth, I mentioned this earlier. I think the third-party defense is also difficult for the defense because it's very hard for jurors to not shift the burden in their mind when the defense says, the defense said at the beginning of their opening statement in the first trial, and it was much more compelling than Lally's opening. But their first sentence of opening was, Karen Reed was framed. But it makes it really hard for the jury to not go, oh, prove it to me. Because the defense doesn't have to prove anything. The Commonwealth does. But when you come out of the gate saying the defendant was framed, the human inclination is, show me. Buckle up, show me. And it's not on them to do it. So it will be interesting to see how they approach that in the second trial. So I'm very interested to see that. Jess said, this lady sciences. Yes, this expert sciences, and sciences quite a lot. Jenny said she added purple to her hair for her aunt and BFF who was diagnosed with dementia last week. Jenny, I am sorry. That is a tough diagnosis. It reminded me of you and how I've always loved all the purple Lawnard stuff. I hope it makes you feel like you have your armor on, walking through something that is difficult. So hugs to all of you, because the purple sometimes feels like a hug. I know mine is a whiff of purple. It is like a hint. It is a hint of purple at the moment, just because I have not made the time. Other things have been happening. So I want to make the time. I have not well made the time. My kids have gotten haircuts. I have not gotten back. Ashley, congratulations. Ashley said, my standing desk and got a walking pad, 50 pounds down. Look, getting to walk during the day always feels good. This woman is very well qualified to testify. I agree that this expert, Dr. Russell, is very well versed in what she knows. I think it's going to come down to whether or not the courts have accepted it, and bringing up the judges in the Southern District of New York is going to be persuasive for the court, because it's like, but Your Honor, the cool kids are doing it. Those judges over in the Southern District of New York, they know some shit, Your Honor, and they said it was fine. So let's go. Lindsay, I am sorry for the loss of your Ponard. There has been a lot of Ponard loss over the holidays. It is very hard. It's a unique and painful thing, losing a Ponard. It really is a very different type of grief. So I'm sorry for that. It is incredibly hard because we love our pets so much. The loss of them is devastating. So give yourself some time and space. Nicola said, do you think a new trial will be harmful or helpful to Karen Reed? For example, will the prosecution get new and better experts? I don't know if they'll get better experts. They will probably have some new experts. Yes, the prosecution does know a bit more about what the defense case is, but the defense also has room to bring in more information from their experts because they sorted out during trial. I think it can be difficult if the witnesses for the Commonwealth, I almost said state, but the Commonwealth have their own set of problems. There are more issues going on with the lead investigator in this case than there were at the time of trial. That's going to be a problem for the Commonwealth, but the Commonwealth also has a heads up of what the defense is going to bring forward and where the jury got stuck, because we have so much information from this jury. We know where they got stuck and that they didn't think at all that this was a second degree. So we'll see, but it can help and hurt both sides. The defense still has to turn over their discovery, but the prosecution also has more time. What the prosecution can't do is undo all the shit that happened at the beginning of this prosecution. Like, they can't do that. But those moments of like the video being inverted in court, those shouldn't happen again. So we'll see. But then again, the line of questioning where Buchnick was talking about the video and didn't even say it was inverted until like the next day, that will still come up again because it's like, didn't you say this and represent to the jury that? So it will happen and we will see. All right. I'm going to get to just a handful more. And then my in-ears are starting to make my ears tired. So Taylor said, I got my wife a Lawnard's hat and she flipped out. I hope in a good way. And I hope that she was very excited. Irish Rover, absolutely sending prayers to your mom, and you're in good company here. The Lawnards as a community have been through it, have supported people through it, and you are always, always in good company going through it. And I love seeing how many of you made statements in support. Almost halfway to 4 years of membership. That's amazing. Charlene, good to see you in the chat. My muffin stickers are my favorite. I got a lemon. Aren't they so good? I love it. I love it. I love it. We're out of water, MVA. Thanks for helping to distract us this afternoon. Oh no. Oh no. Book Dragon Jen said, would love to see Brennan as a defense attorney. I mean, it's going to be a lot of what we've seen here because he was very much in defense attorney mode today. Lawnards, I am going to let the mods go. And we are going to go. It has been a very long day. I will be back with you tomorrow at 11. We will be going over all of the lively Baldoni Wayfarer. It ends with litigation. It starts with more litigation lawsuits tomorrow. Make sure you have the Lawnard app. A huge thank you to the mods for like day one back. And it's almost a 7-hour stream with a full day of court. Woohoo! Friday will be a shorter day in court, that's for sure. Just a little harder to follow along with because it's audio only, so be prepared for that. But it will be interesting to see what the questions are regarding TikTok, and I hope that we learn more from those hearings on Friday. So Lawnards, I will see you in court tomorrow. Don't forget to get the Lawnard app. Thank you everyone who gifted memberships and for super chats. I appreciate all of you. Take care of yourselves. Take care of each other. Thank you for being a Lawnard. And let me find where all of my stuff went so we can roll the outro. Lawnards, out. We'll see you soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Lawnard.